So very good afternoon everyone. So now we are going to start with the day one of the revision for law. As I already said, let us first complete the big chapters with huge amount of marks inside it. In that, the first chapter that comes in mind for every student must be two chapters. Number one, share capital and debentures. Number two will be FEMA. Okay, these are the two kingpins of the law syllabus for CA Inter. Number one will be share capital and debentures. Number two will be the FEMA. These are the two areas which will come for 20 marks in exam. Okay, FEMA and share capital and debentures. These two chapters are technically share capital one chapter, debentures one chapter, FEMA. These are the three chapters which will be coming for around 20 marks in examination, which mean to say that most important from our exams point of view. Very, very important, extremely important from the exams. Number one, first we need to complete that. Once we complete the share capital debentures, once in the today's session, first target is to complete the share capital and debentures. First we will complete that, we will close this area. Once completing, after that a small chapter is there for our syllabus, that also we will take and complete, like charges or some small chapter, let us take and complete. Listening? So target is to complete substantial marks in this revision session, such that this 4-day session should give immense clarity on what we have to do in examination. Clear? So the point is, we are going to start with the syllabus or the concepts relating to the CA, Inter, Corporate and other laws. From the exams point of view, first one, target. There are 6 chapters in your syllabus which will account for 50 to 60 marks in exam. As our first target to complete those 6 chapters. Chapter number 1, share capital and debentures. Chapter number 2, management and administration. First one, share capital. Second one, management and administration, so called general meetings chapter. Okay, next, number 3, FEMA. Number 4, accounts of companies. Number 4, accounts of companies. Number 5, incorporation. Number 6, interpretation of statutes. Okay, if you are pakka confident with those 6 chapters, 100% you will get 50 marks in exam. Student won't have energy to read all those chapters, they will not get good marks in law. And as simple as that. Did you understand my point? So the main problem with this particular syllabus is, you observe now. As I said, I will just put it on the screen for you to understand. First 2 minutes, if I give you the overview, you can understand well. Share capital, please listen. Share capital, there are around 30 sections. Management and administration, so-called general meetings, there are around another 30 sections also here. Okay. Incorporation, 20 sections. Accounts of company, 10 sections. Next one, which chapter I told you? Incorporation I have written, accounts I have written, FEMA and interpretation of statutes. Observe now. Totally Companies Act, for you in the exam, 139 sections are applicable for exam. How many? 139. Some sections are not applicable for you for the exams. Removing all those, 139 sections are applicable for exam. See here, totally how many are there? 90. Almost around how many sections? 100. Means what is the meaning? Total syllabus, 4 chapters are accounting for 100 sections in your syllabus. Shall I tell you what is the meaning behind this? 75% of your Companies Act syllabus is concentrated in 4 chapters. What are those 4? Share capital, management administration, incorporation, accounts of company. Okay, share capital will come for 10 marks, management and administration 8 to 10 marks, incorporation will come for 8 to 10 marks, accounts of company will come for around 6 to 8 marks. Technically to tell, these 4 chapters will account for around 35 marks in your exam. Substantially important. If you prepare those well, you will be 100% pass first. Failure concept will not arise in law. When? If you are perfect with those. Okay? And we are not just doing these four. Along with this, we will be taking some small chapters which will come for 5 marks each. Listening? Like chapters like dividends, charges, deposits, etc. Are you listening? Okay? Now listen carefully to the point. Main target is, from the exams point of view, we have to go. Okay? Substantially the most important and crucial areas we have to cover in the revision classes. Listening? Therefore, with that viewpoint only, first we are going to start with share capital. Next we will be going with small area. One big area, one small area we will take. Listening? One big chapter, one small chapter. So maximum possible extent I will first complete share capital and debentures. It will take around 3 hours time for us. How much time? 3 hours. Very big chapter. I can't do anything. There is a very big chapter, vast chapter in our syllabus. Around 2.5 to 3 hours we will take. If completed early, very good. Let us take the highest one, be conservative. Once completed, I will take a small chapter like dividends and I will complete. Let's put the target bigger. If we achieve, very happy, or else we will carry forward and complete. But we have to complete the target. Okay? Let's start with that. Please open your books, whatever book you are using, study material, my book, some other book, no problem for me. Open the study, or some book, open the share capital chapter. See here. I will first, please. I will first tell you what are all the important sections in share capital chapter. What are all the important sections? The most important sections are there, which we should never leave in this chapter. In that, 43 rules are important. Do you know what is there in the rules? Differential rights. Which one? Differential rights. Next one. 48. 52, 53, 54. Sir, 55 it was printed 2 times. Actually 55 will be redemption of preference shares. 55. This time in your exam and a coming September exam, every time before examinations I used to give the super 50 questions. What are very important. This time 99.9999% chance is there. Question will come from any of these 4. 56, 57, 58 and 59. Pakka. You take it for granted. We'll meet on exam date again. Okay? One question from them will come in examination. 56, 57, 58 and 59. Next important one is 62, 63, 66, 67, 68. These are all the main core sections we need to cover. Shall we begin? What I am going to do is, see here, total syllabus. Break that into parts. Important ones, set A we will combine. Share capital is the first rank number 1 chapter in our syllabus. Hello, listening? In share capital also all sections are not having equal difficulty. Which are more difficult, let us complete them first. Are you with me, everyone? Let us start with that. First one. Come to section number 56, 57, 58, 59. 56, 57, 58, 59. Fifty-six, 57, 58 and 59. Okay? Okay. Let us first understand the concept. If you want running notes or whatever the notes you want, you can write down. Okay? I will tell you all the important key points which we need to keep in mind with regard to this. Okay, one by one, let us begin. Let's start. From now, target is 2 hours. We have to complete share capital as a chapter without debentures concept. Without debentures. 40 minutes we will spare for the debentures. Once both are completed, we go to dividends. Listening? Yes, sir. That's the target for the today's session. First, we need to complete them. Okay, let's begin. See the screen. Point number 1. First, whenever question comes on transfer, okay, the concept is transfer of shares. Is it permitted or not? Let us try to understand first. Everyone in the class, hopefully you are coming for the revision, means I have certain expectations from you, means some basics you need to already know. Tell me, what is the definition of a private company? What is the definition of a private company? Private company means a company which is having minimum paid up share capital, and by its articles, by whose articles? Private company's articles. 3 things will be there. In the articles of association of a private company, 3 things will be there. Number 1, it will restrict the transfer of shares. Ade chapter. Private companies will restrict the transfer of shares. Simple logic. Me and my brother, me and my dad started a company. Listening? Started a company. Example, let us say, I wanted to leave my company. Leave my company means what? Open the door and go out. Other leaving means? Leaving means what? Leaving as a shareholder. If you have to leave as a shareholder, what you should do? Sell the shares. What you have to do? Loudly. Sell the shares to whom? Some other person. Shares to some other person. For example, he is there. I wanted to sell shares to him. I will sell to him. Now he will come. Who he is? He is some stranger. Okay. My dad said that, who is coming inside our company? I said, someone will come. I will not allow someone. This is a private limited company. It's a family firm. Anyone who should come inside should only be a family member. If you wanted to leave, sell to your brother, let him come. Now tell me, transfer is permitted or prohibited? Permitted. But transfer only to the that's called as a private company. I am not telling prohibited. I am telling restricted. It's not. What happens if I prohibit? If you prohibit, that perpetual succession will not be there. What will not be there? What are the 5 features of company? Artificial legal person. First one. Second one, perpetual succession. What do you mean perpetual succession? If you go, some other will come. Means if I have to go and some other has to come, there should be transfer of shares. If you prohibit transfer of shares, where is the perpetual succession? Clear everyone in the class? So again repeat the point. Point number 1. There are 2 types of companies. 1, private company. Number 2, public company. Whose shares are freely transferred? Answer. Public company shares are freely transferable. Private company shares are transferable. With restrictions. Okay, I will ask you one question. Tell me, why transfer is permitted? Why transfer is permitted? Who gave that power? Law. Law. Who permitted? Law. Okay. Who permitted? Which section gave? There is one section in Companies Act which says that shares are movable property. Loudly everyone. Shares are movable property. When I say it is movable, it will move from one person to another person. That's the meaning of movable property. Share is a movable property. Therefore, it will transfer from one person to another person. In a private company, transfer of shares is. In a public company, shares are freely transferable. On that basis, one chapter itself has come in share capital. The name of that area is transfer and transmission of shares. Everyone understood the point clearly? That's the first one. Just a summary, you read the concept. Tell me. General provision. Shares and debentures are movable property. Shares and debentures shall be transferable in the manner provided in the Act and Articles. Okay. Next, public company shares are Freely transferable. Private company, there will be restriction. Can it be prohibited totally? No. Cannot impose absolute prohibition. Did you understand or not? Tell me all the points now. Don't sit idle in the class. Start. Point number 1. Shares are which property? Since it is movable, it is from one person to how it will be transferred? In the manner specified in the act or in the articles. Everyone understood the first one? Next point number 1. Public company law shares are freely. Do you know why? Public company definition, do you remember? Public company means a company other than a private company. Other than private company means what? Private company will have restriction on transfer of shares. Other than private company means public company don't have restriction on transfer of shares. So therefore, the shares of a public company are that's the point. Everyone understood the concept? Very good. Next, private company will transfer with prohibition or restriction? Can I impose absolute prohibition? Not possible. Next, there are two concepts we have to deal here. One transfer, another one transmission. Second one, what is the difference? Transfer means we will voluntarily transfer from one person to another person. Me transferring to her, say the shares, means I am interested to sell the shares. She is interested to buy the shares. Transfer happened between two parties. This is called as what? Transfer. This is called as what? Transfer. Let us say this example. There is A, there is B. B is the son of A. B is the son of A. A died. What will happen? A died. What will happen? Shares will get transmitted, not transferred. Shares will get transmitted. Transfer two parties will be there. Transmission two parties will not be there. Because the person who has to transfer, he is no more there. He died. How the dead person will come and transfer and die? Do you understand the point or not? Okay. Now listen carefully to the point. Point number 1. Two concepts are dealt here. Transfer, transmission. Tell me, what is the difference between transfer and transmission? Transfer is a voluntary action. Transmission is a operation of law. Operation of law means automatically shares will get transmitted from one person to another person. Everyone understood the concept clearly? So please read this. Transfer means what? Voluntary transfer. Operation of law is called as a transmission. If you want, take a notes, write down the key points there. 1 minute time for you. Number 1, share is which property? Maximum possible try to maintain running notes, because separately don't spend time on writing. Are you clear? Or else I will do one thing. I will share these notes. Okay, na? This particular notes I will share. At least have it. Do anything. But don't sit without book. That's the point. We can speedily complete. That's the only intent. Okay? Now tell me. So let's stop writing. Only key points, whatever you want, you write down, remaining you leave. Let's complete the syllabus first. Point number 1, shares and debentures are? Therefore they are? Public company shares? Private company shares? Transferable, non-transferable? Transferable. With restrictions, without restrictions? Very good. Number 1. Transfer is a? Transmission is a? Automatic, which is also called as a operation of law. Number 1 completed. Take this. Section 44 over. Next one. What is the next one? Requirements for, read, transfer or transmission of securities. Transfer or transmission of securities. Listen carefully. Important section. I said you, again I am repeating, 56, 57, 58, 59 are the expected questions in your exam. Any one out of them can come for 4 marks in exam. Share capital generally will have 3 questions in your paper. How many? 3 questions will come from share capital chapter. Okay. 2 questions will come as a descriptive, and around 2 to 3 MCQs will come. So be very, very specific and clear about this chapter. Very important. 10 to 12 marks is the weightage, including MCQs. When I say 10 marks to 12 marks, don't see descriptive. Also you should see the MCQ. Last attempt 5 questions came as MCQ in share capital chapter. Isn't it? How many? 5. And 5 ones means how many marks? 5. Again in question paper 8 marks question is there. Means how many marks one chapter? 13 marks. It changes your fate. Whether to pass or not to pass. Do you understand or not? The fate changing chapters these are. So don't play with these. Have perfect clarity. So point number 1, section number 44, everyone understood clearly? Now which section we are going? Section number 56. Sir, before we go into this, I wanted to make certain points clear. Listen carefully. What is the concept we started? Transfer and transmission. Let me first explain. After that we read. Shall we? Yes, sir. See there. There are 4 sections totally. There are 4 sections totally. 56, 57, 58, 59. 56. Procedure for transfer and transmission is there. Procedure for transfer and transmission will be there. In which section? 50? This section 56. Procedure, requirements. Okay. Next section. Once this is completed, what is the next one? First, let me tell. 56, 57 separately we will cover. What is the next one? 58. Sir, what is this? I made a transfer. But there is a, what happened? Refusal. There is a refusal. This refusal can be of 2 types. Private company refusal, public company refusal. How it will be for both these will be dealt in this section. 59, rectification of register. You can see here. Wait. What is the next one? Rectification of register of members. Rectification of register of members. That is section number 59. Called as, what is the concept? Rectification. See here once. I will show you the learning objective and then we will begin. See here. First we are going to complete section number 56, 58, 59. Why this is not covered? I covered this in the book in the last because this is only a, what it is? Punishment. Only penalty you have to remember. So out of these 4, which 3 are very important again? 56, 58 and 59. 57 is only a penalty or a punishment section. So let us concentrate first on the important sections in that. Okay. If you have the notes, please open that. Just, or if you have the running notes or something like that, please keep the heading summary of section 56, 57, sorry 58 and 59. 56, 58 and 59. Okay. First. Listen. I will first write down the, explain the summary. Section 56. Procedure for transfer and transmission. How many of you are thorough with these sections? Perfectly, how many of you know? Fatafat you should write everything. See, no one. I know which areas are dangerous in this chapter. If I ask buyback, how many of you know the buyback concept? Buyback. See. And do you know what is the intention of the student? Which is asked 10 times in exam is important. Which is not tested till now is unimportant. Which is already tested, person like me has to prepare question paper. Means I will ask new question only. At that time only paper, tough paper, student will label. Na? Paper is a tough. Do you know what is a tough according to student? A topic if comes where he didn't prepare, then he will call it as tough. As really tough or not tough, we will see later. But what is tough in our intent? General question paper which is within our expectation, if it doesn't come, we label that as a tough paper. Okay? Tough papers, do you know what they will do? Transfer or transmission, these will come. We expect buyback, Are you understanding or not? Rights issue, bonus issue, those we will expect and we will go. One question also will not be there in paper. Something they will ask on transfer, transmission, rectification of registers, etc. That paper, tough paper. So let us first start with the so-called tough concepts and complete. Okay? Sorry, listen carefully. I will explain, at least put some brain here. Listen. There are two persons in this concept. Number one, transferor. Number two, transferee. Okay? Transferor will transfer the shares. Transferee will pay consideration. Will pay the consideration. What will be transferred? Will be transferred by? To whom? Who is the seller? Loudly. To whom? What they will transfer? For that what he has to pay? Now tell me. Shares are with whom beginning? Went to whom? Now who is the owner after paying the consideration after the transfer? Transferor or transferee? Transferor only, registration should be completed, then only transferee will become owner. Registration is this chapter. Are you understanding or not? This is clarity first. So the pot breaking truth behind this concept is very, very simple. You know what it is? This particular area, see 56, 57, 58, 15 wanted to tell, what is the concept we are going to deal? Transfer and illa registration of transfer and transmission, not transfer and transmission. Loudly, registration of transfer transmission is not the chapter intent. What is the intent? Registration of transfer. Sir, I will ask you the question. First answer. We have so many chapters of law in syllabus. First one, preliminary. Second one, incorporation. Third one, prospectus. Fourth one, share capital. Fifth one, deposit. Sixth one, loudly, registration of charges. Again, charges is not in our syllabus. Okay? Yes. Charges is not in our syllabus. Charge is there in our syllabus. How to create a charge? How to create a charge? It's not there in our syllabus. You should tell it is out of syllabus question. Why you are asking? Okay? How to register the charge? Don't tell out of syllabus. You will be out of class. Charges is not in our syllabus. What is there in our syllabus? Registration of charge. That's why name of the chapter is not charge. Name of the chapter is registration of charges. So then charge is governed by whom? There is one separate act called as SARFAISI, Securitization and Reconstruction of Financial Assets and Enforcement of Securities Interest Act. That act will cover charge creation. After charge is created, Companies Act governs the registration process. Understood? In the same way, transfer and transmission is not governed by Companies Act. Registration of the transfer and transmission is a problem here. Listening? I will sit like this. You see and tell what is section 58. Refusal to transfer and transmission. Refusal to register. Problem is not with transfer transmission. Problem is with the registration of the refusal. So registration of the transfer if refused. Listening? Sorry. Use your smart brain. See section 59 and tell. Rectification of transfer. Rectification of transmission. Rectification of registers of transfer and transmission is governed by syllabus. How many of you first time learned about this? Raise the hands. So, this is problem. Problem with law syllabus is not about difficulty. Problem with law syllabus is innocence. So, we are so small enough to understand the basic concepts what institute wanted to tell. So, chapter name say we are not properly understanding what they wanted to tell. So, there is no problem on giving a tough question paper. So, there is no such concept. Put properly this here. You will definitely get 60 plus in exam, provided you follow properly the strategy. Start. Number 1, 2, 3, begin. What is the name of this area? Registration of transfer and transmission. That is subject matter. It's not about transfer. Listening? Why transfer is not governed by syllabus? Because nothing is there to govern. Who am I? Transfer. Koushik Mukhesh. Boy. Now, so tell me, who am I? Transferor. Who are you? I will give shares. What happened? That's all. What is there to govern here? Is there any act governing transfer and I am transferring shares to you. Is there any act governing this? Sale of goods act. Arey, Muttal. Do you know Sale of Goods Act? What is the definition of goods under Sale of Goods Act? Goods means any kind of movable property other than actionable claims and money, but includes shares. Answer over. Sale of Goods Act govern that. Why Companies Act is required to govern the sale of goods, sale of shares from one person to another? Companies Act has nothing to do with it. Now did you understand why Companies Act don't govern transfer and transmission? Who governs that? Contract Act and Sale of Goods Act govern. Who govern? Act and Sale of Goods Act. Governs what? Transfer and transmission. Who governs registration of the transfer and transmission? That's what we are going to study now. First we know why this chapter came successfully at the last. Okay, let us begin with the concept transfer and transmission. Now tell me, how many parties will be there? First let us complete. Who is the first party? Second party? Transfer or transfers what? Transfer he pays what? This is the transaction that happened. Up to here Companies Act has nothing to do with. But Companies Act will involve in one case. This particular transaction should not happen on a oral form. Means, what do you mean oral form? Oral form means you give the share, I will transfer, like that it should not be. It should be on a written paper. Written paper. That paper is called as SH4. What is the paper form? SH4. SH4 should be stamped and executed. Should be stamped and executed. What do you mean by stamp and execution? Stamp means on a stamp paper, not on the postal stamp. Are you understanding or not? Not those stamps. Stamp means stamp paper. On a non-judicial stamp paper, you should prepare SH4. What is the form? Tell me now. Sir, please concentrate here. Please, let's complete fast. Who is the first party? Second party? Transferor is transferring what? For that what he is receiving? Who is receiving? Okay, very good. Now what is completed? Transaction completed. What starts? Registration starts. Okay. For registration you should go to whom? Company. Who issued shares? Land belongs to whom in India? Land. Plot of land belongs to whom? Government. Therefore registration of land is done by government. Shares belong to whom? So who should register? Company register. That is logic. Clear or not? Land belongs to government. Government registers the land and building. Shares belong to company. Company should register that. Hello, listening, everyone? Tell me now. Who is the first party? Second party? What is transferring? What is receiving? What is completed? Transaction completed, that's all. Okay, but this has to be done on a white paper, oral form, stamp paper. Both the persons has to sign, because under contract act consent is required. Seller has to give the consent, buyer also has to give a consent. Seller gives a consent to sell. Seller gives a consent to sell. Buyer gives a consent to buy and pay. Buy and property transfer ki I am consenting, money payment ki you are consenting. All this should happen on a white paper, stamp paper. That's why in the book also they will write SH4 formula, you should execute it, you should stamp and execute. Execution means signing by both the parties. Execution means what? Signing by both the parties. Who are both the parties? Transferor and transferee. These are the two important parties in this transaction of a transfer. Listening? Now tell me, sir, I am promising and I am telling you, if you listen to this diagram properly, when you see the substance in the material, just like the 2 minutes you will complete this 1.5 page answer. Law is not at all difficult. If you tell FM difficult, I can at least get convinced. So some formula is there, I am not understanding, means at least I can understand. Such a conceptually, logically they place all the sections. You should understand only the idea behind that. After that, easy to remember. So point is, tell me, how many parties will be there? 2 parties, transfer completed. It should happen on a white paper or stamp paper? Stamp paper. Signed by both the parties. Any of them, means either a transferor or transferee, should send it to the company for registration. For registration. Sir, when I should send, sir? Anytime I can send? No. It should not be more than 60 days from the date of execution. From the date of execution. What do you mean from the date of execution? Can you please explain me the meaning? Stamp paper we will buy. We will write agreement. On the 2 people will sign. Below the signed date will be written. From that date within how many days? 60 days. You should send that to whom? For what? For what? So this is the point. Sir, up to here everyone explain me the concept. How many parties are there? Fast. Number 1. Number 2. What is transferred? Transferred from? To whom? Transferor paid. Transferee paid. This all has to happen on a form called as what form? SH4 should be on a white paper or on a stamp paper? Signing, no signing. That is also called as what? Execution. Executed by both the parties, or else the agreement is invalid. Both the parties has to execute it. Once executed, you have to send it to the company for registration and complete the registration within a period of 60 days from what date? That will come as an MCQ. 60 days everyone will remember. From what date 60 days is a question here. 60 days from what date? Date of execution. The signing date from there, how many days? 60 days. 60 days lo what has to be done? Wrong. You have to send to the company for registration. Company can take another sweet 6 months time. It is your obligation to send to the company within 60 days. If you are thorough up to here, I can go to the next one. Yeah. Understood? This is step 1 that you have to understand. Now I will ask one question answer. How many parties are there? But there is a second problem. Do you know what is the second problem? Transmission. Transmission law, always one party will be missing. A father, B son or wife, whatever the case may be. A died. Shares will be transferred or transmitted. Why transfer can't happen? Because one of the party not there. Who is not there? Who is not there? Who is there? Wrong answer. If transferor is not there, other party can't be called as a transferee. Like this only we'll write in exam. Transmission, transferee. I will write come again. When transferor is not there, how come transferee will be there? Are you understanding or not? Then who should be there on the other side? Receiver. I said who will be there as per Companies Act. Shall I tell you? Now this is very clear and sure that you didn't read anything about transfer transmission chapter. Do you know what the other party is called as? Person intimating the transmission. Person? Tell me the language properly. Person? Who died? Example, in our names, who died? A na B na? Don't kill both. Who died? Who died? A died. Okay na? Now tell me. A is in somewhere in South India. Company is in Delhi. A died here somewhere. Immediately company la bell ring. A died. How company will know? Somewhere in South India, if a A died, how company will know? You should intimate the death of the person through a death certificate. Once you give death certificate to company, automatically shares are transferred to you. That's called as a transmission. That's why in a transmission, two parties will not be there. There will be only one party, and that fellow will be called as a person intimating the transmission. Person? And what do you mean person intimating transmission? Person who intimates about the death. Person who intimates about the death is called as a person intimating the transmission. So hopefully everyone understood the logic clearly. Yeah? Answer. In a transmission, how many parties will be there? Only one party. Who is that one fellow? He will directly inform the. Now shares will be directly transmitted to his account. Everyone understood the concept clearly? Everyone. But the most important thing is transmission like SH4 form, all this nonsense will not be there. Why? SH4 form who will sign? Both the parties. Here you take SH4 form, but both parties can't sign. You have to intimate about the death of a person. Immediately company will transmit your shares. From whose account to whose account? From whose account to whose account? From the person whose shares are under transmission, from his account to the person intimating the transmission. Who bought the shares? Person whose shares are transmitted. Persons in control of the shares. Person whose shares are transmitted. A na B na? Who got the transmission? B will become the owner from that date. Means he can buy, he can sell, he can lend the shares. Whatever you want with the shares, you can do as if you are the real owner. As if you are the means simply to tell, upon transmission, will the transmitted person will get full rights over the shares or not? Yes. Each and every point what I said now will be there in the material and in the book. Please don't mistakes in this regard. I'm not telling any story to you. Point number 1 again. Understood this procedure? Yes, loudly? Yes, very good. Second one. Did you understand transmission concept? Yes, on transmission, the person to whom the transmission is done, that fellow will become the owner. Real and unreal, keep it away. He will become the owner. He will have a right to sell the shares or not? Yes, he will right to retransfer to some other person or not? Yes, you will become like a normal owner. You have all the rights on the shares. Listening? Now, not yet completed, sir. Not yet completed. Listen. Full story I have to tell first. Next important point. All this is applicable if it is a private company or a unlisted public company where the shares are not in Demat form. Where the shares are not in Demat form. Sir, I will ask you one question. I have my Demat account. I have my Demat account. I have 1,000 shares of TCS. I have to transfer the shares to some other person. Listening? I will take SH4 form, then I will transfer. Directly online transfer will be done. Did you get my point or not? Therefore, try to understand clearly. Whatever we are reading in this chapter, in transfer transmission, full procedures will be applicable if and only if the shares are held in which form? Which form? Physical form. If the shares are held in dematerialized form, these procedures will apply or will not apply? Will not apply, because all this happens through the depository. Happen through the depository. How many of you know what is a depository? Not names, beyond that, other than names. 1, 2, 3. Sir, it is a time for you to learn about what is a depository, because there is a separate concept also on depository in our syllabus. Point number 1, listen carefully, 2 minutes I will complete. What is a depository? Listen. Bank, what bank will do? That also doubt, huh? What bank will do? What bank will do? SBI, HDFC, ICSI, all these. They will accept deposits. Sorry, okay. Forget about loans. Loan concept I am not asking. Can you put your money in bank? Yes. Why you put money in bank? Tell me 2 reasons. Safety. Number 1, safety. Number 2, easy transmission. Easy transfer from one person to another person. I am from Hyderabad, you are from Chennai. It takes around 14 hours by train, 1.5 hours by flight. It becomes very difficult for one person to come to Chennai from Hyderabad, pay money and go back. Correct? But if there is a phone pay, what I can do? In 1 second I can do the same. Clear or not? Yes, why phone pay is working? Because phone pay is linked to a bank account. Linked to a Bank account. That's why we are doing the transaction as simple as in 1 second. Correct? So what is the purpose of maintaining a bank account? Two very important reasons. Reason number one is a safety. Reason number two is the easy transferability from one person to another person. These are the two promising features that a bank will do. Listening? Answer? Yes, same you merge now with the shares. Depository is a bank holding the shares of a person. Holding not the cash, holding the shares of a person. Okay, na? Now tell me, I am SBI. I will take money from her. I will take money from him. I will take money from so many people. Clear? If she write a check in favor of this person, if she issue a check in favor of this person, say 1 lakh rupees, what I will do now? From her account I will deduct how much? 1 lakh, and to his account I will transfer 1 lakh. Debited to her account, credited to his account. Same, correct? Yes, same depository also will be doing. Two reasons why depositories are there in India. Number one, safety. Number one, safety. Or else previously you don't know 2000 time la share certificates ki forgery. Do you know what is a forgery? Signature will be forged. Means same like the other person, they will sign and they will transfer the shares. Later this fellow will come to know that my shares are not with me. So that's a situation way back in 2000s. So because of dematerialization of stocks, what happened? Shares are kept in which form? Electronic form. Means we are what form? Dematerialized form. Listening? Safety. Second one, when it is in electronic form, I can transfer just in a click. Same thing depositories are doing today. Did you understand? Now answer my question. Physically, if I have to transfer money, I have to go to the bank, fill the form, give it to them. They will transfer from one account to another account. Correct? From that, online transfer, phone pay, how easy it is. From one number to another number, just like that we are transferring money. Now transfer speed becomes extremely faster in physical form and electronic form. Will be very slow in. Same apply also on shares. Shares are safe in Demat account. Number one, transfer is very easy in Demat account. So in Demat account, SH4, transfer, 60 days, registration, all these are required or not required? Answer. Not required. Reason? Not required. Answer is fantastically right. But why? Shall I tell you why? I will ask you one small question, answer here. Stock markets do you watch regularly? Not regular, at least you know how stock market works. Tell me, one company share will be bought and sold how many times on a particular day? Lakhs of times. How many times? Lakhs of times. Working day, you don't know how much a transaction will happen. Lakhs of times one company share will be bought and sold. I am company. Please listen carefully. Who I am? Company. She is the owner. She is the owner. Owner means one of the shareholder. You are all the shareholders here. I am TCS. She is one of the shareholder. Means one of the owner of the company. Okay, na? I wrote her name. Member number one. I wrote her name. Some ABC. I have written. She sold the share. I strike off. Sold to him. His name I have written. By the time I complete his name, he sold the share. Intraday trader. Do you understand? Immediately he sold to him. Oh, he is not there. I strike off. I'm about to write his your name. Sudarshan. Suddha. I have written. He also sold the share. So by the time I got the information that Sudarshan has bought the shares from Dinesh. Okay. I have written Dinesh. Immediately he sold. I strike off. Immediately he purchased. Suddha. I have written. He said that I also transferred. I struck off. How many times I have to do like this? Therefore, company don't maintain register itself. Who will maintain register? Depositories will maintain. That's the headache of the depository. Clear or not? Online registry is there with the depository. They will maintain all those. Listening? So who is the depository? Don't tell names here. Who is a depository? Depository is a repository. Depository is a repository means a store place. Repository means storage place. Depository is a repository. Not depository, bro. R. Depository is a repository of shares and debentures. Simply securities. Listening? This is the purpose of a depository. Now what will happen when you have to transfer the shares? 1 minute they will transfer the shares from one person to another. Who will do the tracking? Who will do the tracking? Depository. And a company will have the names of its members. A company don't have. Everyone. Company don't know who is their member also. Day end, and today trading day will be completed. Now another half an hour to like that, trading period will be over. Once the trading time is completed, what time is completed? Trading time is completed, depository will update the list of all the members. Update the list of all the members. For example, tomorrow TCS wanted to go for a buyback. TCS want to go for? Buyback to its shareholders as on tomorrow. Tomorrow. Yesterday person I don't want. Day after tomorrow I don't want. Tomorrow who is all the shareholders? For them I wanted to offer the buyback. Now TCS will ask depository. Depository, who is my member? You don't know? No, I don't know. Give me the list. Now depository will give the list to TCS. This is the list of all your members. 30 lakh shareholders are there. This is a list. Do you know what is the date called as? Tomorrow's date is called as record date. What the date is? Record date means the date on which the records has to be updated. The day is called as a record date. So now tell me the complete details of all the shareholders of India is maintained by TCS, Infosys, NSDL, CDSL. That means, do you know why? That NSDL, CDSL is under the control of the government of India. Such that data leak will not happen. Fraud cannot happen. Understood the point or not? This is all happening because of one entity called as depository. There are two depositories in India. Number one, NSDL. For NSDL, number two will be CDSL. BSc works on CDSL, NSC works on NSDL. These are the two depositories. Depository hold shares in what form? Physical, electronic. Transfer becomes automatic, fast or slow? Economical and fast moving. From one account to another account, fraction of seconds they will transfer. Listening? Then where is the question of transfer is signing 60 days SH4, from where all this story will come? That's why all these provisions, whatever we read till now, will apply if and only if shares are transferred in a physical form. Section 56 is over. Shall we read now? Let us see. There are 2 points which I didn't cover in section 56. We will cover that when we read the notes. See there. First, so don't waste time. Fastly you read first. Transfer deed. First one. What is the form you need to take? SH4 is called as a instrument of transfer, also called as a share transfer deed. What is it? Okay. Next, execution. Transfer deed shall be stamped and dated, and it shall be execution means what? By whom and whom? You should submit to the company within how many days? 60 days of what date? Execution date. Which date? To whom you should send? What you should send? Answer. Only SH4 you should not send. SH4 attach share certificate. Attach the first take which certificate? Certificate. Which certificate you need to take? Share certificate. On the top what should be there? SH4. Signing by both the parties. Then you send it to the company. So transfer deed shall be submitted within 60 days. Certificate relating to security shall also be submitted. Transfer deed may be submitted by transferor or transferee. Signing should be done by both. Who will send to the company? Dependent. So first thing understood or not, everyone? Yes, sir. Answer? Yes, sir. I will give one question. First answer to this point. Read sixth point. Understood? So share transfer deed, all these procedures are applicable or not applicable? Not applicable where the shares are held in a dematerialized form. So where the securities of a company are in dematerialized form, company shall intimate the details of allotment to the depository immediately after the allotment. Sir, what is this point? I will explain. Listen. Whose details depository will maintain? Whose details depository will maintain? Members or shareholders, anyone. Those information they will maintain. Correct? How do they get that information first? Company should only give at the beginning. Do you know what will happen? Do you know public offer? Loudly. Initial public offer, you know na? Public offer is made by whom? To whom? Loudly, don't sit idle. To whom? Who subscribe? What you pay first? Application. After that, what you pay? Allotment done means that day you will become the shareholder and owner of that particular company. Correct or not? Once allotment is done, you will become the owner. Then on the day allotment is done, company will intimate the list of all its members as on that day to the depository. From then, depository will update the list. Ante basic details who should give? Basic details who should give? Tell me now. Company went for? Some are not listening. Please listen carefully. Company went for? Public offer, IPO. Okay na? Who issued shares? Issued shares to whom? Public subscribe to the shares. They become? That details the first company should give to the depository. From then, whoever the shares are transferred, depository will take care. Depository will? Shall I tell you why? Listen carefully. There are two types of markets. Primary market, secondary market. IPO is a primary market. Do you know whose involvement will not be there? Stock exchange involvement will not be there in primary market. Whose involvement will not be there? Everyone? Involvement will be there or will not be there? When the stock exchange involvement will start? The moment it enters into the secondary market, whose involvement will begin? Answer. Now I will ask you one small question, answer. Everyone please listen. I wanted to buy this mic. I can buy in two ways. Way number one, directly go to the manufacturer and buy. Second one, buy from Amazon. Amazon is a depository. Are you listening? Amazon is a manufacturer. Amazon is a secondary market. Secondary market ki depositories are required. Primary market directly I am buying from you. Listening or not everyone? Manufacturer mics. Now he will list his mic in the Amazon. Like that company manufacture shares. The manufactured shares are listed on the stock exchange. From that moment depository work will begin. Do you understand the difference or not? So tell me, who should give the primary details to the depository? Company only. That's what he wanted to tell. Read now. Where securities are issued by company in a dematerialized form, company shall intimate the details of the allotment. Why only allotment? Because on allotment you will become the member to the depository immediately after allotment. If you don't do, punishment under 447 will get attracted. Understood the point or not? Don't just nod the head. Yeah, understood or not? Yes, next. What is the next one? Transmission of shares. Okay, read. Don't see the length of the answer. Dead easy. Nothing will be there. Nonsense. Read. Where any person acquires any right to securities by operation of law, the company may register the transmission of shares in favor of such person if the company receives intimation of transmission from such person, and in such a case no transfer deed shall be necessary. Just now I told you na, STD, SH4, 60 days, all that nonsense is applicable when? Transfer or transmission? Here this is a transfer case, a transmission case. Read. Continue. Thus, in case of death of holder of any security, his legal representative becomes entitled to the securities by operation of law. The legal representative is required to submit to the company intimation of transmission. On receipt of such intimation, company is required to register the transfer or transmission of securities in the name of legal representative. Until the shares are registered by the company in the name of legal representative shall not be entitled to the voting rights. Sir, whatever the concept we discussed is there or not? So listen carefully. Answer becomes very easier. You can write in your own words also. The only requirement is you should first understand how the section works. Okay. So first summarize and tell me, did you understand this entire paragraph or not? Yes. Tell me, when transmission will get attracted? When transmission will get attracted? By operation of law. Example, death, insolvency, like that if it happens. Clear? Now tell me. Person who acquires a right on any securities by transmission, okay, will be generally a legal representative. Will be generally a legal representative. Number one. Okay. Now tell me. If the death of the holder happen, if the death of the holder happen, first the legal representative should intimate about the death of the person. Then company will register the transmission in the name of legal representative. Till this process is completed, can you exercise any voting rights, get the dividend, etc.? No, that's what he wanted to tell. Did you understand the concept clear up to here? Okay. So now what we completed, please let me know. What are the two things we come? First tell me, had we completed transfer deed concept? Yes. Execution? Yes. Submission of document? Yes. Next one, dematerialized form? Yes. Transmission? Yes. Deed. I ask you one question, tell me, after transmission is completed, who will be the legal owner? Who will be the legal owner? Legal representative, also called as a person intimating the transmission, will become the legal owner. Can he sell? Yes. Read. In case of death of holder of any security, the transfer of security by the legal representative shall be valid even though legal representative is not the holder. Holder means what? Real owner. As if legal representative were the holder. That means even though you are not the real owner, we will treat as if you are real owner. You can transfer the shares to some other person. Clear or not, everyone? Means if A die, who will get the transmission? B. Can B sell to some other person? Yes, you can sell happily. You are the owner from that day. Clear? These are all the important points that one has to remember in this case. So summarize everything fast. Fatafat give the answer. The big areas I will spend time, small areas I will complete very fast. See the answer. Tell me. Point number one. Transfer deed. Transfer deed is optional or mandatory? Mandatory. Application form number? Okay. Next point number one. That SH4 form is called as? Or it can also be called as a share transfer deed. White paper, stamp paper. Next, it should be executed by both the who is the party? Transferor and transferee, and submit to the within 60 days of execution of the share transfer deed. Listening? Okay, done. Now answer my question. Point number one. So once the share certificate and the share transfer deed both are submitted to the company within 6 days, company will start what process? Registration process. Okay, what process will be started? Registration process. Okay, very good. Tell me. Now tell about something about dematerialized format. Dematerialized form means shares are held by? Shares are held by? In such case, share transfer deed and other procedures are applicable, not applicable? Answer. So the transfer of shares will be in a physical form or electronic form? All these procedures are applicable, not applicable? Now I want one answer from you. Company went for IPO allotment. What it has to do? Just now I told you. Company went for IPO allotment. What company has to do? Immediately after the allotment is completed, company should intimate about the list of members after completing the allotment. Number 3. Next point. Tell me. Transmission, tell the points relating to transmission. In a transmission, how many parties will be there? One party. What about the holder? Holder is there or not there? Shares will get transferred, transmitted. To whom? Intimating transmission. Generally, he will be the legal representative. He has to intimate about the transmission. Means death or whatever the case may be, he has to intimate to the company. Up to here, everyone understood the point clearly. Once you intimate about the transmission to the company, company will make necessary changes in the register and write your name. Listening, everyone? Tell me, what rights transmitter will be, transmission person will have? Means the person who received the shares, the legal representative in simple language, what rights he will have? He will have all the rights. But what should be completed? Registration should be until registration is pending. He will have voting rights. He will get dividends. Very good. After transmission is completed, can the legal representative sell the shares? Yes. Transfer the shares? Yes. He is a real owner, not a real owner. He is not the holder, but as if he is a holder, he can do the transfer of securities to some other person. Everyone understood all the important points in this, but two important points are still there. Very, very important. MCQs they tested in one of the exam. Please listen carefully. Tell me, who have to execute the form? Adya, who is that both? Who will submit to the company? Either of the parties, either transferor or transfer, he will submit. This problem came. Do you know what happens? See here. He is the transferor. Okay? He is the, or let us not say transfer, he is the holder. He is the holder of shares of TCS. Do you know what is the share price of TCS? 4,400. One share. How much? 4,400. Okay? He has 1,000 shares of TCS. Who he is? Holder. Who he is? Holder. Owner of these securities. How many shares? 1,000 shares. Of what? TCS. Physical shares he has. Example. TCS shares are not in physical form. Understand as an example. He is having physical shares. TCS shares, 1,000 shares. 4,400 each. Up to here everyone understood? At 40 lakhs worth the shares he is having. Listening? Yes, let us understand what happened in his case. I am his very close friend. I went to him. I have stolen his share certificate. Okay, 1,000 shares ki one certificate is there. That certificate I have stolen. And I am very, very, very skilled forgery person. Means happily I can forge his signature. Are you listening? What I can do? I can forge. Okay. Now this is a situation. Now see a small change in the story now. Please listen carefully. Shall we? Listen carefully. I am having the shares of TCS. Now I am having the shares of TCS. How many shares I am having? IPO went. Okay. In the IPO I subscribed to the shares. 4,000 I paid 500. Application money, allotment money paid. First call, second call, final call still pending. Paid, yet to be paid. Not yet paid, yet to be paid. Okay na? So 3 amounts are still pending. 2 amounts I paid. Another 3,500 I have to pay. I paid only 3,500 to 600 rupees. Understood up to here? Company went for IPO. I paid up to allotment money. Mine are partly paid, fully paid. Partly paid, fully paid. Partly paid shares. Okay na? Now listen carefully to the story. I am the person. He is my friend. What I will do is, I will take a share transfer deed. I will take a share transfer deed. And I will take a checkbook belonging to him. Who I am? Transferor. Who I am? Holder of the security, let us say. Who I am? Holder of the security. Listen to the story properly, please. Who I am? 2 persons I am. Holder come transfer. Who will transfer here? Holder only will transfer. So who I am? Holder come transferor. Okay. I have taken 2 documents or 3 documents. First one, share certificate. My share certificate with me. Second one is share transfer deed. Number 2. Number 3, checkbook. Okay. One thing, I stolen a checkbook from him. Why stolen? I went to him. I told one one copy of a checkleaf I kept in my pocket and I came back. Listening? Yes, mine is a fully paid or partly paid? Answer? Partly paid. I took the checkbook. Checkbook I have written 44 lakhs. I signed his signature. Did you understand the remaining part of the story now? Yes, I signed on that. Okay, I have taken a share transfer deed. When I can sign on checkbook his signature, why can't I sign on SH4? I signed on SH4 also. My signature I have signed, his signature also I signed. Listening? Now tell me, share certificate anyway with me. My signature anyway I will sign. His signature I forged how many times now? Loudly. One in the, next in the SH4. Both signatures I forged. Over. I folded it, put the check, put the STD, put the share certificate, folded it, put it in a closed envelope, pasted it, written the registered office address, sent to the company for registration. Listening everyone? Everyone listening? Now what happens? Let's see the fun. Now see, matter went to the company. Company, there will be share transfer house. People will be doing only this work. He tore the envelope, he opened the cover. It was so found that R. Koushik Mukhesh is transferring the shares. Listening? Once registration is completed, money will be transferred from his bank account to my bank account. It saw the check number. Some 6 digit check number is there, they saw there. Check number tally. Signatures they saw. Signatures tally. STD 2 signatures. 2 signatures tally. 60 days I have to send. 60 minutes I have sent. So everything is tallied. Listening? Registration office in company about to register that by common seal. Then they got it out. Here these are partly paid shares. Which shares? Loudly? Which shares these are? Partly paid shares. Company will not register. First it will intimate him. Do you know what company will ask? Raja, in your name, one share certificate came. Those are partly paid shares. But you are paying full amount of 44 lakhs. Do you know that this is happening? Who will ask? Will ask whom? Transferee it will ask. If transferee says yes, then only registration will be completed. Are you understanding the point or not? Who can send the share transfer deed? Loudly, who can send the share transfer deed? Not answering. Who can send the share transfer deed? Either a transferor or transferee. Either transfer or. If share transfer deed is submitted by transferor, if share transfer deed is submitted by, and if the shares are partly paid shares, and if the shares are, company will intimate the transferee first. If transferee said yes, then only registration will be completed. This is the security given by Companies Act for transferees from not getting cheated by the transferors. Did you understand the point or not? Tell me, who can intimate the transfer to the company? Transferor or transferee? Anyone? If transferor intimates the company, company will intimate whom? Wrong. It will intimate only if the shares are partly paid. If the shares are fully paid, again I won't intimate. When will I intimate? If the shares are, do you know what is the problem with the partly paid? Liability is there. What is there? Do you know fully? You know limited liability concept in Companies Act? What is the concept of limited liability? Liability will be limited to the extent of amount paid or unpaid. Fully paid liability not there. So no problem. But first case, if it is partly paid share, this fellow papam, he will be liable for the future liabilities of the company. Therefore, tell me, when company will intimate the transferee? If the intimation of the transfer, if the STD, SH4 is submitted to the company by transferor and the shares are partly paid shares, then company will intimate whom? That's the point there. Please read now. Rights of transferee to object the transfer. Read. Go give notice to the transferee if both the following conditions are satisfied. Start. First condition. Submitted by the transferor and the shares are partly paid. Company will give intimation to the transferee in form number SH 4 or 5? What is 4? Share transfer deed. What is SH5? Company intimating to the transferee. Tell me, what transferee should do now? Respond within 14 days. That's why within 2 weeks. If transferee fails to state the objections within 2 weeks, company may thereafter register the transfer. Even after that, if the transfer is silent, I can't do anything. I will believe that silence is taken as an acceptance. Silence is taken as a, after completion of how many weeks? 2 weeks time after, silence will be taken as a acceptance. Sir, everyone understood all the points inside this section or not? Answer. With this, we completed the biggest section in the transfer area. The main procedure for transfer has been completed with all the important points inside it. That's all. Sir, everyone got the full clarity? Now you tell me, from the zero knowledge what you have, now you understood the complete conceptual clarity about the transfer or not? Yes, so summarize everything. 1 minute time, let's revise everything from this particular part. First tell me, point number 1. How many parties will be there? Number 1. Number 2. Who will transfer? Who will pay? Pay through or transfer through or process through oral form or written form? What is the form? Name. Share transfer deed. How the share transfer deed should be? It should be stamped and it should be executed. It should be submitted to the within 60 days of date of what? Execution of what? Share transfer deed. Submit to whom? Very good. Next, point number 2. It should be signed, it should be submitted by whom? Either a transfer or when company will intimate the transferee about the happenings? First, share transfer deed must be submitted to the company by, and it should be, then who will intimate? Intimate whom? About what? About the receipt of transfer certificate for the registration. Intimate to whom? Transferee ki intimation will be given by company in form number. Reply should be given within. If you don't give reply within 2 weeks, it will be deemed as accepted. Now tell me, transmission time la how many parties will be there? Because who will not be there? Holder. Immediately who will be, to whom I will transfer? Legal representative. That fellow will be called as a person intimating the transmission to the company. SH4, 60 days, all these concepts will apply or will not apply? Will not apply. Who will be the legal owner after transmission? Legal representative. Can he transfer the shares to another person? Though he is not a holder, he will be treated as if he is the holder of securities. Clear? Next. This entire procedure what we discussed till now are applicable for Demat holding or not applicable? If a company go for IPO allotment, what is the obligation of company? What company has to do? Company has to intimate the depository about the list of all the members to whom what is made? Allotment is made. With this, the big section is over. This is a main section that we need to remember. Okay? Any question they can ask in exam. Now what we completed, can you please explain me? What we completed? Answer, sir. Section? Okay. Next. 58. There are 2 parts in 58. Refusal to transfer. Register the transfer. Listen, sir. This very, very important. Another question. Please listen carefully. I will put it on the screen before you. Please see there. What is the concept? Please read. I will again, like other section, I will first tell you the objective of this section. Why this section has come. After that you can understand. And this much time I will spend only on these 4 sections. Once a normal share capital chapter starts, again I will go very fast. Because I know no one is reading this area. So share capital chapter, lesser read chapter. In that these are much lesser. So therefore I am taking reasonable care. If the question comes in exam, you should be able to write. Shall we begin? See the screen. Point number 1. Listen carefully. Answer. Point number 1. Refusal to transfer or transmission of security. What happened? Let me explain. There are 2 types of companies. Private company, public company. Private company can refuse the transfer or cannot refuse the transfer. Cannot. Can do what? Refuse the transfer. Because in a private company, transfer of securities is prohibited or restricted. Public company la freely transferable. So private company la already restrictions will be there. According to the restrictions, it can refuse the transfer also. Correct? 58 section is talking about 2 things. Number 1, tell me, how many parties will be there in a transfer? Number 1. Number 2, submit the share transfer deed within 60 days from the date of, to whom I will send? Company refused to register the transfer. Then these sections will come. What company has done? Accepted, refused. Everyone accepted, refused. Now what is the procedure followed by the company when refusal happened is a section subject matter. Clear or not, everyone? Listen, I will first explain you the point. After that you read. Shall I continue? See here. Number 1. Whenever private company refuses to register the transfer of shares, whenever private company refuses to register the transfer of shares, it shall give a notice. It shall give a notice to the transferor and transferee. It shall give a notice to the and I will ask a question now. First tell me, who is the party 1? Who is the party 1? Very good. Who is the party 2? Common sense then you can answer. Who is the party 2? Very good. Whose shares are transferred? Huh? Very good. Transferred. Okay. Next, who paid consideration? As on today, whose name is there in the register? Huh? We sent it for? We sent it for? Company accepted or refused? Refused what? Refused the? Now tell me, you use common sense if any and answer. I don't want you to listen any kind of wrong answer for this. Who is the most affected party now? Transferor or transferee? Transferor, why he is not unhappy? Do you know why? In the register of company, whose name is still there? Answer, sir. So I am not in risk. And moreover, I got a double advantage. What is that? Money also received. Who is at the disadvantage now? That's why transferee only will go for appeal. Who will go for appeal? I like that you have to remember. Okay. So first tell me, where a private company, fast. Where a private company refuses, whether in persons or power contained in articles or otherwise, to register transfer or transmission, it shall give a notice of refusal. To whom I should give notice? Transferor and transferee. In case of transmission, person giving intimation of transmission. Okay. Time limit for sending the notice. Who is sending the notice? Sending the notice to that person. Within how many days they have to send? Within 30 days from the date on which the transfer deed or intimation for transmission was delivered to the company. Okay. 1 minute time. Read this content. No wrong answers expected. Okay. Shall we continue? Shall we continue? See here, in a diagrammatic way, I can present the same answer. See here, sir. What section we are reading? Section number 58. Okay. First, which company we are covering? Listen first, please. First one point. If you want to cover this concept as good like in the previous concept, please put some effort in understanding this concept. Very easy. Please see the screen once. Which section we started now? See here. Don't write anything, please. Who are the two persons? First, let me know. Next, transferee. First, tell me. Who transferred the shares? Who transferred money? Huh? All this happens with a document called as what? SH4, which is called as a share transfer deed. Either of the parties will send the share transfer deed to whom? Company. This has to happen within how many days, sir? They have to send it to the company. For what purposes? Registration purposes they will send. Up to here, listen. Understood? Very good. See the screen. Now what company has to do? Company has to register the transfer of shares. If it does not register, means if it is refusing it, it can't keep silent. It has to send a notice of refusal within how many days? 30 days from what date? From the date of delivery to the company. From the date of delivery to the, within how many days? It has to register. If it does not register, at least it has to send the notice. Notice of what? Refusal, along with the reasons. Why you are refusing? What is the problem in this? You have to send. Within how many days? Please see the screen. Now the main problem will start. See the screen there. So tell me, who is the two parties? Number one? Number two? What is transferred? What is executed? What is executed? Who paid money? Who paid money? Send what? To whom? Within how many days? Company has to start what process now? Registration process has to begin. What happened? Let us see. Company has taken some time. Okay? And company wanted to refuse. Whenever you wanted to refuse, within how many days? 30 days you have to send a notice of refusal. Send a notice of refusal. Okay? Now you send a notice of refusal within how many days? 30 days. See here, I will change the diagram. Please see here. Company will have two options. See here. Two situations can arise. We waited for how many days? 30 days. Registration is done. Matter over there. Within how many days? 30 days. Tell me, what is the second option? Registration not done. When registration is not done, what should happen? Registration not done, what will happen? Notice of refusal has to come. Notice of refusal has to come. Within how many days, sir? 30 days. Now, there can be two situations again. Notice of refusal, two cases. Given. So, notice of refusal and not given. Given, not given. If given, what is given? Notice of refusal. This is the first one. See here. Notice of refusal. Time limit for sending. Read the time limit for sending. The notice shall be given within 30 days from the date on which share transfer deed or intimation of transfer was delivered to the company. Okay. It was given or not given in our case? Answer, sir. It was given or not given? Given within how many days? Second case, it was given or not given? Not given. Within how many days? If it is given from here within 60 days. Within 60 days. What will be filed? Appeal will be filed before NCLT. Appeal will be filed before NCLT. Okay. Next. So summarize everything. It takes time, but once it implants in your brain, at least till exams you will not forget. See there once. See the process. So please be attentive in the class. See there. Point number 1. How many parties are involved? One. Second. What transferor has done? What transferor has done? Transferred the shares. What transfer he has done? This all happened orally or in a written form? What form? Send it to the. For what? Within how many days? What company has to do? Within how many days? Done or not done? First case, no problem. Second case, done or not done? If company is not doing the registration, it has to send the notice. Within how many days? Within the same 30 days time. First case, given or not given? Given or not given? Given. Sir, if I am okay with the reasons, well and good. If I am not okay, what I can do? Appeal. Within how many days? To whom? 1 point over. Very important is the second case. Notice of refusal given, not given. Notice of refusal given, not given. In that case, up to here everyone understood clearly? Everyone? If it is not given, sorry, 1 second. Sir, up to here you understood the concept clearly, yeah? Up to here. Okay? Now see here. Total, sir, very sorry. This is also how many days? 30 days. If company is not doing the registration and the notice of refusal is not given, see here, see the line. From this date, within 60 days, you can file an appeal before the NCLT. See the complete procedure. I'm very sorry, this is not 60 days. This is also how many days? 30 days. Now see the complete procedure. See there one by one. First one. Who is the party number one? What he done? Transferred what? To whom? Very good. What transfer he paid? What is executed? What is executed? Inform number? Sent to the? Within? This is called as a delivery time to the company. Delivery time to the? Can I send within 20 days? Can I send within 20 days? 10 days? 50 days? 60 days? 65 days? The maximum is 60 days. Understood the point? Very good. Transferred. Company has taken how many days time? In the 30 days time, what is also done? Answer. So when, no problem. Her problem doesn't happen because the refusal is not done. Okay. Next, how many days is completed? And registration completed? Not. Not completed. That means there is a refusal. There is a. And the notice given or not given? Answer. If the notice is given by whom? To whom? Transferor and transferee about the refusal. If I am okay with that reasons, very good. If I am not okay, who will go for appeal? Appeal to whom? What is the full form of NCLT? National Company Law Tribunal. Make a complaint to the NCLT. Within how many days? 30 days. I am very sorry, I have written 60. It is 30 days. Up to here, everyone understood? See the entire process in a different angle now. Who transferred? To whom? What he transferred? What is executed? Sent to whom? For? Some date we will deliver this or not? Company has to complete registration within? Registered or not registered? Registered, not registered? What should be given? That is given or not given? Once 30 days completed, once it's completed, registration not done, notice also not given. In that case, within 60 days from the date of delivery of transfer deed, within, repeat, don't sit idle, within 60 days from what date? Date of delivery. Delivery of what? Share transfer deed. From this date, within how many days? 60 days, file an appeal to NCLT. Understood the point up to here? Now matter will go to? See here, see the screen. In both these cases, matter will go to NCLT. Please listen. NCLT will do two things. Mainly, what it will do? Here to both the parties. Who are the two parties in this case? Transfer, yeah. Who are the two parties? One is a company, second one is the transferee. Two parties. It will hear to both the parties. It will dispose the case. This will dispose the case, means it will complete all the arguments. Okay, na? So once it dispose the case, it can be of two ways. Judgment may come in favor of company. Judgment may come in favor of transferee. If judgment comes in favor of company, refusal is acceptable. If it comes in favor of transferee, then registration should be completed within 10 days. Registration should be completed within? Everything in this area is over now. Now please answer, not just seeing this diagram. First tell me what we have to do. First tell me, who is transferring? To whom? What he transferred? What he received? Consideration. What is executed? Share transfer. That share transfer deed is submitted. Delivered to whom? For what? Within. How much time company should take? First case, registration done, not done? Refusal is there, not there? Second situation, registration done, not done. What company has to do? Notice must be given within that 30 days period. If notice is given, notice is given, then who can make an appeal? Can make an appeal to whom? Within how many days? Very good. After that, next one. Tell me, if notice of refusal is not given within 30 days, who can make an appeal? Can make an appeal within 60 days from what date? Date of delivery of share transfer deed to the company. Okay, na? Both the cases will finally go to what NCLT will do? First, hear to both the parties and close the case. While closing the case, two situations can come. Number one, favor of company. Then what will happen? Refusal is accepted. If favor of the transferee, registration, all the procedures has to completed within 10 days. Understood or not? This is for private or public? Don't write anything first. Tell me private or public? Like this we have to study again for public now. Everything is same. Only one change. Substitute this 30. Listening everyone? This 30 is common. Listening? This 30 is common. This 30 substitute with 60. This 60 substitute with 90. Are you listening? First 30 same. After that, instead of this 30, you have to write how much? 60. That's why I got confused and I have written 60 beginning. Next, this 60 will be substituted with how much? 90. Means what? Everything is same in a public company. Public company, the procedure will be bigger. Lot many numbers will be there. Na? Therefore, tell me, appeal time, general appeal time, how many days they will give? 30 or 60? 60. If no notice is given, you can file within how many days? 90 days to NCLT. Everyone understood the point clearly? See here once. See here. I want every one of you, please read the content on the book and tell whether all the points are covered or not. First, read this point. No, read yourself. Maximum 10 seconds time I am giving. Firstly, brush to the concept, complete it. First point completed. Next. Notice to whom? Same. Next. Time limit. Very good. Contents. Contents. Appeal to whom? By whom? Transmission time, the person intimating the transmission. Time limit. Within how many days? No notice is given. Within how many days? 60 days from what date? What tribunal will do? Then what it will do? Dismiss the appeal or dispose the case. Okay, na? If tribunal may direct the transfer or transmission to register by company, company has to register within how many days? Or else punishment. Next, this is for private. Now tell for the public. Tell for the public. Same concept. Original date will be instead of 30, 60. 60 will be remaining. Everything is same. Answer is over. Section 58 is also over. Understood the point clearly? Yeah. What section we completed now? 56 and 58. Now, you people will answer this question. See there, exam question, May 2018 for 5 marks. Read. Read. Harsh purchased 1000 shares of Singhania Limited from Pratik. See, how story we built, same way they will ask questions in exam. Read. How many persons? Who is the first one? Purchased from Pratik. Which company? Singhania Limited. Who is the transferor? P na H. Transferee. And send those shares to the company for transfer in his name. Now continue. The company neither transferred the shares nor sent any notice of refusal to any part within period of stipulated in Companies Act. What is the time frame which the company is supposed to reply? Does Harsh the transferee have any remedies against the company for not sending the intimation? Can you write this answer or not now? Yes, everyone? Yes, if you know the concept, that much easy it will be. A 5 marks question, just you can complete in 2-3 minutes now. Tell the procedure now. Tell the procedure. How many parties are there? In November 15 and May 2018, both are exam questions. Okay, now this and this are same. This is much bigger than this. Now let's read this. Okay, now. So tell me now, who is the first person? Transferor, transferee. P is the transferor, H is the transferee. Okay, now all transaction completed. Share transfer deed also sent to the company. But company registered or not registered? Given notice or not given notice? Do you remember our table diagram? From when I can, this is a public company or private? So write the answer for public limited company. Public limited company, first I have to go for an appeal within 60 days from date of notice if it is given. Here notice is given or not given? So I can go for appeal within 90 days from the date of delivery of share transfer date. That's what you have to write here. That's all. Answer is over. Did you know, understand? Are you all confident with the answer? That's it. See here. This is how you need to write. Okay, just for the case of understanding I have given. Full answer you have to write. Everyone understood the concept? Okay, done. Next, what is the next one we are going to see? Rectification of register. What is the section number? See there? 59. Okay. Very easy. Sir, mark 59 important. I am guessing this question will come in exam. More than these two, I am guessing this question to come. Mark it very important. Section number 59. See here. Shall we? Read. Listen, let me first explain what is the modus operandi of this section. What is the cause, effect, everything. Let us see this section first, please. What is the section number? 58 or 59? 59. What are the sections we completed? 56 and 58. Now we are coming to 59. Okay. First, let us see. What is this section 59 talks about? Rectification of register. Rectification of? Not rectification of transfer. Rectification of register of transfer. Listening everyone? Now listen carefully. Whenever transmission happened, what is the most important event in that? Registration. It's not buying, selling. Sir, for example, you might know. If your parents bought any house, buying date, selling date, all these are not important. Always what is most important? Registration is important. Am I clear or not? That day only we will always see muhurtam, all these. On what day we are paying, all these things are not important. Most important one is the date of registration. That day is very important for anyone. Listening or not? Because payment date is not in our hand here. You will give check today, presented after 3 days. At that time Rahu Gandam is there. What you can do? Are you understanding or not? Listening? You will pay money for real estate property in cash, in check? Answer. Sir, both means I can't do anything. Okay, if you are doing the transaction, I can't do anything. Normally, ideally, under the law, legally, how to do? Check. At least some amount you will give on check or not, even if you are most illegal. Some amount you have to give through check. Correct or not? Sir, you gave a check. Check worth 1 crore you have given. You gave check today. Today is an auspicious occasion. That idiot submitted to the bank after 5 days. On the day exact solar lunar eclipse on same day. Okay, he is a Rahu Gandam day. That day he submitted to bank. Bank also approved payment on the very same day. Now tell me, payment made on auspicious occasion? As per you? No, not an auspicious occasion. Are you understanding or not? At that time you have done. It's not an auspicious occasion. What you can do? That's why no person will have sentiments on payment of advance, payment of all this. What is the most important day? Registration day. If after that housewarming festival. You understand? The most important one is the registration, because that is there in your hand. No one can control that. The day on which you fix the registration, that day only registration will happen. Clear? Now like that same, you will go for registration. Problem is with registration of the transfer or transmission, whatever has happened. Listening everyone? Please see here, let me explain the point first. What happened? 59 will get attracted in 4 cases. How many? 4 cases. Loudly, how many cases? 4 cases. Do you know what are the 4 cases? Very easy to remember. Number 1, name of any person is entered into the register. Name of? Entered into the register. I didn't buy the shares. My name is there in the register. Means Partly paid example I told, na? Like that. Okay, first one. Name of any person is entered into the register. Please everyone, name of any person is with the sufficient cause or without? Without sufficient cause, name of a person is entered into the register. Now tell me, I bought or not yet bought? Now having my name is a problem or not having my name is problem? Reply one more time. I bought, I didn't buy. I didn't buy. But what is there? My name is there. Now not having my name is problem or having my name is problem? Number one. I didn't transfer, but my name is omitted in the register. Now having my name is a problem or omission is a problem? That's second one. Name of any person is omission. Simply to tell, first one, inclusion is a problem. Second one, exclusion is a problem. Clear? Next, number 3, read. Default or unnecessary delay is being made in entering in the register of members the fact of any person having become a member. Sir, delay if you do, already we read the section. That section is refusal to register. They didn't refuse, they said registration is accepted. But my name is not in the register. 3 situations we read. Inclusion, omission, delay. This is not the way you should respond for a revision class. Start again. Number 1. Inclusion. Number 2. Exclusion or omission. Number 3. Delay. Which kind of delay? Again, unnecessary delay. Which delay? Unnecessary delay. Okay. Unnecessary delay in what? Entering in the register. Entering in the register. Okay. Of having becoming a member or not becoming a member. Become. Everything is same. Ceased to be a member. In that also you are making delay. I sold shares. Registration also over. Still my name is only there in the register. Listening or not? Tell me how many cases will 59 will get attracted? Number 1. 1 second. Start again. How many cases the section 59 will get attracted? Tell me all the 4 cases. Number 1. Inclusion. Number 2. Omission. Number 3. Unreasonable or unnecessary delay in including. 4th one. Unnecessary delay in exclusion. Tell all the 4 one more time. Inclusion. Omission. Unnecessary delay in inclusion. Unnecessary delay in exclusion or omission. Everyone understood the point? In all these cases, any aggrieved person means the person who is hurt. Okay, that person can go for appeal. Same concept again. Appeal will be filed with the answer tribunal. Same tribunal will hear 2 parties, dismiss the appeal, rectify the register. Everything is same. Up to here, everyone understood the point clearly? Yeah. That's all. These are the important points in section number 59. With this, full transparent transmission concept has been completed. Everyone understood the concept clearly? Yeah. Everyone in the class reply. Understood the concept of transparent transmission clearly? Okay, very good. Now we have completed the concept of transfer and transmission of these particular shares. Sir, first of all tell me, before the revision class started, what clarity you have on transfer transmission? Now what clarity you have? Is there any difference in your understanding? Yes, understood the full concept now? Yes, exam questions you can solve or not? Yes, please read transfer transmission differences. May 2018 this question was tested. What is a voluntary act? Transfer. What is the involuntary operation of law? Execution of transfer deed is required in? No transfer deed is required in? Stamp duty is payable if there is a transfer. So the form may not there means from where the stamp duty will come. No stamp duty. Consideration will be there for transfer. No consideration for transmission. Had we know all these 4 differences or not? That's all. With this, the main concept has been completed. Let us go with the next area of importance. Please come to section number 43. Come to the beginning now. Main agenda topics are over in this share capital. Let's come to small areas and try to complete them. Sir, not all the sections are equally important. Most important ones only we are going to cover. Okay, let's not waste time in reading all small sections. Okay, first, see here. Kinds of share capital. What is the topic name? Kinds of what capital? Share capital. Okay, listen here. First I will explain. After that you read or whatever you wanted to do, you revise whatever you want to do. Give me first 5 minutes time. Each concept I will explain for 5 minutes. After explaining for 5 minutes you read. Then you can understand. Later you can revise. Shall we start? Listen to me. There are two types of share capital. One is equity share capital. Second one is a preference share capital. Number one. Number two will be equity share capital not defined. Preference share capital is defined. That's why what is equity share capital? Any capital other than preference share capital automatically will become equity share capital. What is defined? Preference share capital. Name lone clear, preference, priority, importance is given. Listening? Importance is given in what? On what you are giving more preference? Listen. Importance is given in two situations. Number one, payment of dividend, repayment of capital. Repayment of? From your knowledge in FM, you tell me. Tell the income statement format. Sales minus cost. EBIT. Fixed variable, forget about it. Sales minus cost. EBIT. Minus EBT minus EAT minus then earnings available to equity shareholder. From that you will pay the dividend. Means from the earnings, who is given more preference? Compare with equity only. Don't compare with all others. When you compare with equity, who is getting first payment? That's why they are called as preference shareholders. They will get the first payment than equity. Then don't tell, sir, preference shareholder, before him, government is taking tax, debt holders are taking interest. That means they are given more preference. We have to compare share capital with another share capital. Again I say, donkey should be compared with donkey, not with monkey. We are comparing what and what? Equity share capital. Compare with preference share capital. Debenture is not a share capital. Don't compare with that. Clear everyone? Now tell me, who is most important in a company? Equity or preference? Equity is important. Preference is important only in two cases. Number one, payment of dividend, repayment of capital. Loudly, payment of? Repayment of? Okay. So that dividend can be fixed rate or can be fixed amount. Any dividend can be there. Dividend can be of a fixed rate or dividend can be of a fixed amount. It may be with a tax, it may be without tax. Do you know why? So today, income tax rule is without tax. Maybe income tax may impose tax on preference dividend in a later date. Do you know why? Equity dividend is not taxable 2 years back. Now equity dividend is also taxable in India. Are you understanding or not? Means how Companies Act lawmaker will know whether preference dividend is having a tax impact or no tax impact depends on the country situation. Clear or not everyone? Now tell me, preference shareholders will be given preference in how many ways? All the ways are only 2 ways. Number one, payment of. Second one, repayment of. Payment of dividend and repayment of capital. Tell me, payment of dividend can be of fixed rate or it can be of fixed amount. Second one, payment of dividend may be subject to tax or may not be subjected to tax. Understanding? Next, tell me, company go for winding up. Company go for? At the time what we will sell? What we will sell? What we will pay? What we will pay? Now tell me, assets came to 1000. Liabilities came to, say for example, 950. Example, first what we will pay? First outside liabilities including your workmen you will start. First pay to workmen, next pay to office employees, next pay to secured creditors, next pay to the unsecured creditor, next pay to the government, next pay to normal creditors, then pay to preference. Lastly, if anything is available, then you will pay to the. Now tell me, who is given last preference? Who is given one step before? But when you compare with equity and preferences, who is given more preference? That's why it's called as a preference share. The answer. Everyone understood the point? So tell me, what is a equity share? Any capital of the company other than automatically called as that is point number 1. Everyone understood the point? Second one, that is called as a equity capital. Next one, preference share capital will have preference in how many ways? Number 1, payment of dividend. Number 2, repayment of capital. Payment of dividend can be of a fixed or of a fixed. Next, maybe with tax or maybe without the tax. Next one, payment of capital can be made either at the time of winding up of earlier you can make. At the time also who will be given more preference? Preference share. But very important one point is that please listen carefully. Preference shares are of 2 types. General preference shares, participatory preference shares. Everyone, number 1. Next one, participatory. Listen carefully, what is a participatory preference share? Tell me, when you pay the dividend, first paid to whom? Tell the income statement, sales minus cost, what you will get? Minus interest, what you will get? From that minus, what you will get? From that, the entire amount is earnings available to. That amount completely belongs to whom? Wrong. In that amount also, after paying some dividend to equity, still some amount is available. On that amount, participatory preference shareholders will have a right. Those preference shares are called as preference shares are participatory preference shares are. Participatory preference shares are those preference shares where the preference shareholders will get the right over and above their normal right as a preference shareholder. Sir, I have to get 10% preference dividend. How much? 10%. For that I got my 1 crore. I got my profit is 10 crore. EAT how much? 10 crore. Minus 1 crore. How much is the earnings available to equity shareholders? 9 crore. 3 crores paid as dividend. Still how much is there? In that 6 crores, either they may take full 6 crores or they may take a limited extent on that 6 crores. Those preference shareholders are called as participatory preference shareholder. These people are very dangerous in the company. Sir, when they are very dangerous, why companies bringing them? Situation. All people whom we welcome in our life are wanted. Did you understand? Did you understand the point or not? Unwelcomed people also will come in life and do all mess. From this, what you have to understand, very simply, a situation. Fate. So, the point is absolutely clear. Company is also like that. My situation is very bad. I want money. He is ready to give. He said that. What for me? You are in a low situation now. You came to me. I am in an upper position. So, do one thing. Make me participatory preference, he said. I asked, what is this? You do business. Give me fixed dividend. You take equity dividend. After that, anything is left out. Participate with me. Did you understand the point or not? So give it to me. Like this he may ask, did you understand the concept clearly or not? The concept of participatory preference share. Participatory preference share will take the profit share or assets share at the time of winding up even after their main preferential right is over. How much dividend in our example? 1 crore. You are really participatory preference share. So tell me, how much is the preference dividend? 1 crore. Paid or not paid? Paid or not? All reverse answers you are giving. Paid or not paid? Paid. Even after that, how much profit is there? 9 crore. Equity dividend par value 10 rupees. Full 10 rupees, 10 rupees dividend I paid. Even after that, only 3 crores has went out. Still how much is there? 6 crore. On that 6 crore as per the agreement. Sometimes you know what they will tell? Whatever is left out after paying to you, full amount belongs to PPS. Who is PPS? Then 6 crores, swaha. Transfer to whom? Or they will tell that in that amount 30% belong to us, they will tell. Then 1.8 crores like that they will take. Did you understand the logic of participatory preference? Tell me, winding up time, first we will sell all the, pay all the, first pay to the, who? Workmen, salaries, After that, secured creditors, unsecured creditors, government taxes and dues. After that, creditors. After that, preference capital also paid. After that, equity shareholders also taken their capital. Even after that, what is remaining? Some amount is remaining. On that, participatory preference shares will jump and they will take. Are you understanding the point? Understood or not? These kind of preference shareholders are called as a participatory preference share. That is what covered by the provisions. Okay. Any book, if you have, read that. Or if you don't have, at least see the screen. But don't sit idle. Read. 2 minutes time only I am giving for you to read. Start. Share capital is of how many kinds? First one, preference and equity. Equity, 2 types are there. With voting rights, with the differential rights. I told you differential right rules. Very important. We will read. Next. What is a preference share? It is a... At least read the underlined content. It is very difficult for you to read. Kada. I will underline, read that, repeat. It is a very good. Having in all situations, 2 situations. One, rendu. Next, preferential right as to the payment of. In case where dividend is declared, the preference shareholders have a preferential right. Okay, it may be subject to tax. That depends on government regulations. How Companies Act tell that. Next, preferential right as to the repayment of capital. In the repayment of capital also. Next, it is super. Read. Nice people these are. Read. Read. Full fun will come. Read. Participation in what profits? Surplus profits. And that profit don't even belong to you. But still you are asking, why you welcome such a person in life? Read. Right to participate with the equity share capital in surplus profit in case of payment of dividend. Are you understanding? Listening? Next. Right to participate with equity share capital in any surplus which may remain after entire share capital has been repaid in case of winding up. What is equity capital? Share capital which is not preference share capital is termed as equity capital. Next, section 43 applies to all the companies whether public or private. With this, section number 43 has been completed. So differential rights I didn't discuss separately. We will discuss about differential rights. Okay. Why? Everything I will tell you. After a short break I will discuss. I am not telling that I am giving break now. I said after that short break I will discuss about that concept. Okay. Now. No break. These are not regular classes. Regular classes means I will come on time first. So first point number 1. Let me complete. What happened? Coffee, Bring. Break for me, not for you. Thank you very much. Hey. 2 minutes, I will leave you. Okay. See here. Listen here, please. Come to section number 47. In your study material it is there, page number 4.15. 15. If any have study material, open that. If you don't have, at least see here. Okay, see here. First point number 1. Why we are discussing about this? Please listen. Sir, 4 sections in this chapter are not applicable for your exam. 44, 45, all these sections are not applicable. That's why, though in the notes I am not dealing about them, because 4 sections in this chapter are not applicable for your exam. Are you listening? Read applicable ones. Okay? First read applicable ones properly. After that we can discuss about non-applicable points. First let us read properly the applicable ones. Please see the screen here, please. Start. Point number 1. What is the concept we are going to learn? Voting rights of shareholders. There are 2 types of shareholders in a company. Number 1, equity shareholders. Number 2, preference shareholders. Equity shareholders will have 2 kinds of rights. right of dividend, right of voting, right of, first one right of, second one right of, means first one is that right on the profits, second one is a right on the decision making, right on the, who don't have a right to vote? Preference shareholders do not have a right to vote. However, preference shareholders will get a right to vote only in two cases, only in case number one, when, first, sir, please don't interrupt me, please let me explain first. Preference shareholders will get a right to vote only in two cases. Case number one, when the rights of the preference shareholders are directly getting affected. When the directly getting affected. Examples I will tell you how questions will come in exam. Preference dividend agreed as 10%. Agreed as? 10%. But company is not in a good financial situation. It can't pay 10%. It can pay 8.5%. Now I wanted to change that to 10 to 8.5. Now tell me, who is affected because of this? Preference shares will get affected, or equity will get affected. Then whose permission you should take? Answer. Preference shares permission I have to take. Correct or not, everyone? From this what you have to understand? Who is getting the problem? That fellow you should ask. Correct or not? If he is in problem, you will ask another person to give judgment. No. Therefore, try to understand clearly to the point. Point number one. Preference shareholders will get a right to vote or no right to vote. Generally, preference shareholders do not get any right of vote in the general meeting. They will get their right to vote only in how many cases? Case 1 I told you, when any decision of a company directly affects the interests of the preference shareholders, they will get the right to vote like this. Listening? You change the dividend rate, permission required. You change the redemption value, permission has to be taken. You change the life, permission has to be taken. Like this, anything relating to them, if you change, permission is mandatory. Listening? Second situation, if company is going for winding up. Company is going for? Which kind of winding up? Voluntary winding up. Which winding up? Voluntary. Do you know what is a voluntary winding up? Voluntary winding up means it is like announcing the company to be dead with a suicide. Are you understand the point or not? Literally, voluntary winding up is like a suicide. Company is committing the suicide. Court is winding up. Court is? Loudly, court is? As a normal death. Are you understanding or not? As a normal death. But suicide? Voluntary winding up. I am only telling kill me. Are you understanding? Can company die? Can legally you can kill. Can company marry? Yes, merger. Amalgamation, yeah? Don't think creatively. I am talking normally. Legally can company merge or not? Merger is a corporate marriage. Liquidation is a corporate death. What's wrong in that? Namaste. So now tell me, can company go for liquidation? How many kinds of liquidation are there? Number 1, voluntary liquidation. Number 2, compulsory liquidation. Compulsory liquidation means who will take? Court will take. According to law, it will go on. Voluntary winding up also according to law, but procedures are different. Now tell me, voluntary winding up decision will be taken by equity shareholders. But who is getting affected because of that? Preference. Therefore, tell me, preference shareholders generally have voting right or no voting right? Everyone? Everyone? But they will get voting right in how many cases? Case 1. When their rights are directly affected, they will get right to vote. Second one, in case of winding up. Two situations. Everyone understood? However, preference shareholder will get right to vote on all resolutions in the company. Right to vote on? Means from the first resolution to next resolution, every resolution. Like equity shareholder, he will also come with you and sit and tell, hi mama. Who? Do you know when? If you don't pay their preference dividend for 2 years or more. If you? Very bad response. If you? For a period of 2 years or more. And you paid arrears. Arrears for how many years? 2 years or more. Means they are receiving dividend or not receiving dividend? Now you tell me. Who will get variable dividend? Answer. Who will get fixed dividend? Fixed dividend person is getting dividend and not receiving dividend. And he is on par with whom? Therefore, you will get all the rights. Are you understanding or not? You are labeling me as a preference shareholder, but treating me like a equity shareholder. Therefore, treat me in voting right also. Are you understanding or not? Now he will also sit along with you in the general meeting. Here who is sitting? Here who is sitting? Who want to vote in favor? Raise the hand. He is raising. I will sit like this. After that he will sit, come, I will raise the hand. Arey, please do what I say. No. You didn't pay me dividend, na? Whatever you do, exactly. Reverse I will do. Needed, ah? Needed, ah? That's why don't mess with preference shareholders. Okay? So now tell me, preference shareholders will get a right to vote, will not get a right to vote? Normal cases la will get a will not? In what cases they will get voting right? All the 3 points I want you from you answer. If their rights are affected. Second one, winding up. Third one, they will get right to vote on all the resolutions like equity shareholder. If their preference dividend is in arrears for 2 years or more. 2 years or more. Next. Last point before you take a break. Whenever I say share, one share will have one vote. Everyone, one share will have one vote. That means any resolution you place before the meeting, every shareholder of one share will have one vote. 1,000 shares, 1,000 votes. 1 lakh shares, 1 lakh votes. This is the rule of law. Clear? Please read now. Every shareholder will have every which shareholder? Right to vote on every resolution. On poll, voting rate of every equity shareholder will be in proportion to the paid up capital. Means one share, one vote. Voting rights. Every preference shareholder shall have a right to vote on such resolution which directly affects his right. Or if you go for repayment of preference capital. But poll, one share will have one vote. But if the dividend is not paid, for how many years? 2 years or more, then every preference shareholder will have a right to vote on. That's all. With this, the main content of this particular section is also completed. Everyone understood the main concept of section 47 or not? That's all. Take a break and come. 10 minutes. 5 o'clock we will start again. Please don't take lengthy breaks. Okay. So see here. Let us start with the next area called as a share certificate. Section number 46. Name of the concept is share certificate. Very easy concept. Rarely tested in exam but tested. So let's not take any kind of risk. Okay. See here. Hey, listen. Share certificate. See here. First point number 1. Let me explain you the concept said under the Companies Act. Once that is completed, we can read. Please listen. There are 2 concepts in this section we need to learn from the exam's point of view. Number 1, what is a share certificate and some basics. Next one, duplicate share certificate. What is it? Duplicate share certificate. How to apply? What is the procedure? This is the second concept we need to learn here. Okay. One by one, let us learn. Please, everyone, see here. Point number 1. Share certificate. When I say, one thing is very clear. This is applicable only for the companies having share capital. There are 2 types of companies. Company limited by shares, company limited by guarantee. To which company this concept will apply? Company limited by shares. That means to have this section, first the company should have the shares. So company should be limited by share capital. That's the first point. Please read. Issue of share certificate is mandatory for every company having share capital, whether public or private. Number 1 point over. Okay. Number 2. Tell me. Please listen. What is the concept of certificate? Certificate is the concept of certifying the fact. Certifying the, I qualified CA. Proof is my CA certificate. I have a certificate called as a certificate of practice, certificate of membership, final pass certificate. Did you get the point? These are all the, not certificate, these are all the proof that, I qualified CA. Did you understand my point or not? Like that same, I purchased shares of a company. What is a proof? Share certificate is a proof. Am I clear? Okay. Now listen carefully. So first one, share certificate is a proof. Means what? Evidence of the fact that a person named therein is the owner of such a number of shares specified therein. Simply, share certificate is the fact of ownership. Next one. First point number 1. What should be there inside the share certificate? It should specify shares to which it relates. Means whether it is equity or preference, and amount paid up thereon. How much amount is paid up, how much amount is unpaid. Clearly you have to tell in the share certificate. Listen again. Examination, pass certificate of foundation, everything you might have seen. Some person from the institute will sign there or not. Like that share certificate law, who should sign? Listen carefully. Share certificate should be signed by 2 directors. Everyone, signed by? 2 directors. Loudly. 2 directors. If the company do not have company secretary, 2 directors. If the company is having a company secretary, share certificate should be signed by 1 director and 1 company secretary. Read this. Every certificate shall be signed by 2 directors or by a director and company secretary, wherever the company has appointed a company secretary. So certificate, please listen, that signature of 2 directors, director and company secretary also not required if there is a common seal. If there is a common seal. But common seal, whenever you are stamping on a paper, it should be done in the witness of a person. In the witness. Do you know what is a witness? When you are stamping, one person has to be there seeing the evidence that yes, he has really put the common seal, or else watchman also can come and affix common seal. Are you understanding or not? That's why evidence is required. In case company has a common seal, read, it shall be affixed in the presence of person required to sign the certificate. This is called as what? Witness. Next, in case of a 1-person company, it shall be sufficient if the certificate is signed by a director or the company secretary or any other person authorized by the board. These 4 points are important for us in exam. Last point is only optional point. First read all the 4. Point number 1, tell one by one. Tell me, share certificate is applicable only for which company? Please everyone respond. Company having the? Very good. Next one, it is applicable for public or private, all the companies are? Very good. Next one, what is the purpose of a share certificate? It will become the? It will become the evidence. It will become the evidence that a person is the owner of the particular number of shares. Up to here everyone understood? Next point, point number 3. Tell me now, share certificate has to be signed by whom? Number 1, 2 directors. If the company is having a company secretary, 1 director and 1 company secretary. Signatures also not required if there is a common seal, but it should be signed in the presence of specified persons. Articles you have to write who should be the witness. Those persons should be the witness when you are affixing the common seal. These are the points that we read. 1-person company, who should sign? Director has to sign, or person authorized by the board. So A, B, C, D, 4 points are over. Rules not required. Mainly the concept that is important here is what concept? Duplicate share certificate. When duplicate share certificate will be given? By the way, I will ask you one question, answer. When I say duplicate share certificate, duplicate word can come only if already there is a original. Ante original share certificate, what happened to that? It has been, read, either destroyed or defaced. Means paper is there, but the font is not at all visible. Next one, mutilated. It is mutilated. Next one, it was torn. Mutilated means becoming into pieces. Torn means not becoming pieces, but it was that's all. Simply to tell, torn represents if there is a paper is not in a proper position to read. All this comes under torn. Mutilation means already it became into small bits and pieces where evidence is not seen. So when you can apply for a duplicate share certificate, number one, if the share certificate is destroyed or defaced or mutilated or torn, and you should surrender to the company. Surrender to the company. In such case, you can apply for which certificate? Duplicate share certificate. In case of which company? Unlisted company, duplicate share certificate shall be issued within how many months? 3 months of submission of the document. In case of listed companies, it should be given within 45 days. This all story is the old story. Today the shares are in electronic form or physical form? Electronic form, how will get destroyed, mutilated, all these things will happen. Therefore, all these concepts does not apply if the shares are held in. That's what this point. Where the shares are held in dematerialized form in the records of depository, that depository itself will become the evidence of title. That's all. These are all the important points you need to read in share certificate. Rarely tested, but tested. Let's not take a chance. So fastly revise the concept and tell me what concept we completed now. Shares are share certificate. Tell me the procedure for share certificate. Everyone. What is the procedure for share? First one, tell me what is a share certificate. It is a evidence that a person is a owner of particular number of shares. It is applicable for which company? Company having share capital, public or private? Who should sign on share certificate? 2 directors. If the company has a secretary, director and a secretary. Very good. When it is not even required, common seal. But common seal should be affixed in the evidence or presence of the persons who are authorized to sign. Next, very important thing. Answer to my question. Duplicate share certificate. Can we apply for a duplicate share certificate or not? Yes. Tell me when. When it is destroyed, lost also. When you lost or destroyed or defaced, mutilated, torn, and you should surrender it to the company. In that case, you can apply for a duplicate. You applied. Unlisted company should give within listed company. These all applicable if the shares are held in. If the shares are held in depository form, then there is no share certificate also. Then what is the evidence? Records of the depository is the evidence. Listening everyone? With this we completed the another answer called as a share certificate. Please let me know one concept. Please everyone see here and tell. All sections are not required. Main sections, what is important for the exam, let us complete. Had we complete section 43? Yes. Anyway, these 2 are not applicable, but still we read. Nature of shares. Shares is a movable property or immovable property? We read at the beginning or not? That was taken from this section only. Share certificates can be of 2 types. Physical, Demat. Physical certificates can numbering will be there. Digital certificate means electronic Demat form, there will be no numbering. That's what said in 45. Certificate of share certificate, did we complete or not? Yes, just before the break, had we completed voting rights on shares? Yes, tell me how many kinds of shares will be there? Number 1 will be. Number 2 will be. Who will get all voting rights? Who will get voting rights only in specified cases? What are those 2 specified cases generally? When it affects the right or when you go for winding up or reduction. Okay, over. When preference shareholders will get right on all the resolutions? When their preference dividend is paid arrears. For how many years? Very good. So with that 47 also has been completed. Up here everyone understood. After that what we completed? 56, 58, 59 also completed. Correct? Okay. Listen, from now fastly I will revise all the sections one after another. Please revise along with me. Clear everyone? Suddenly in the middle debentures also will come. Debentures chapter also will complete simultaneously as I already promised. Shall we continue? Please put your presence here. Important. You know exams are very near and it's a high time for you to revise. Please see the concept. First I will cover the most important ones from the syllabus. Later I will go on priority. Okay. First come to section number 63, 62, 63. Go on importance basis. Section number 62. Okay, please come to section number 62. Very big section you can see there. Either study material or you can see this material anywhere. Whatever material you are following, section 62 is one of the biggest sections in our syllabus. Okay, first I will give 1 minute time. Anyone in the class, whoever wanted to tell what is there in section 62, you can tell. Take 1 minute time. Don't immediately tell because that will be definitely wrong. Tell me what is there in section 62. Read it, no problem, I will wait for you. So all the students over the Zoom live, did you understand the concept up to here clearly? There are around 400 students are there. How can they reply? Sir, okay. Tell me now. Answer. What is the concept? Tell me what is the concept governed by section 62? No, that's first point. Don't see the heading and get misinterpreted. Understanding sake I kept a heading like that. But the idea is, see here, in a company can raise money in two forms. Number one, privately within the company. Number one is going for a public offer. Going for public offer. What is the name of the section really? What is section 62? Further issue of, everyone, further issue of the first thing, further issue of shares. Any kind of further issue of shares in a company has to comply with section number 62. But what is this section 62 of Companies Act? Let us first try to understand. This section covers all kinds of further issues of capital in a company. It covers rights issue. It covers employee stock options. It covers, first one it covers. Second, it covers employee stock options. It covers further issue of capital in case of preferential allotment. It covers any other kind of private issues happening in the company, including conversion of loans into capital. Clear? Since people cannot understand all these, in a easy way people tell section 62 means rights offer. But no, section 62 is not talking about rights offer. One of the concept inside section 62 is rights offer, but that is not the only concept in this section. Did you get the point or not? I repeat one more time, listen carefully. 62 lo there are so many concepts. One of the concept is rights issue. Okay, first let me show you what are all the concepts covered here. See the screen once. See the screen. What is the section? What is the section? This 62 is applicable for which company? Company having share capital. Company having? This is applicable, this concept is applicable if the company is going for further issue of shares. Going for? Second point also over. Okay. Number 2. Next one. What is the second point? Read the heading. That concept is called as what? This is all the concept relating to right shares. Next, offer of shares to the. Next one, further offer other than to the existing shareholders, other than to the employees comes under any person category. Which category? Any person category. Okay. Next one is what? Conversion of loans and debentures. Next one is also conversion of loans and debentures upon the orders of what? All these are the concepts. So one by one, first tell me, what is there in section 62? 1. Rights offer. If you want, you write somewhere or at least repeat with me. First one. Rights offer. First one is? Second one, employee stock options. First one. Second one. Third one, issue of capital to other than existing shareholders and employees. Issue of capital to other than existing shareholders and next, number 4. Number 4, conversion of loan into shares. Conversion of. Fifth one, conversion of loan into shares by government. Conversion of. How many are there? Tell all the 5. First, right shares. Employee stock options. Issue of shares to any person other than existing shareholders and employees. Number 4, conversion of loan into shares. Conversion of loan into shares by government. How many are there? All the 5 are governed by section 62. Very, very important, most biggest section. There are 3 big dinosaurs are there in share capital chapter. Do you know the names of all the dinosaurs? Dinosaur number 1, buyback. Dinosaur number 2, inga paru, ide. Okay. Dinosaur number 3, reduction of share capital. 3 dinosaurs we are going to discuss now in a sequence. Listening, all these 3 dinosaurs completed, 85% of this chapter will be over. Remaining all the sections are jujupi. Just like that you can complete them. The main torture of this chapter is there only in 3 sections. Number 1, 62, 66, 68. 68 is not independent section. 68 is attached to 69, 70 and also 67. Therefore, this particular slot will cover around 6 to 7 sections totally. Once you cover that, substantial share capital chapter will be over. After that, really I am saying all the sections will take hardly not more than 2 to 5 minutes. But this will take lot of time to understand, and this is not time to understand the concept. I will explain very fast and I will go into the revision part. Shall we continue? Yes, listen carefully first, after that you can read. Listen. First we came to know that 62 is having how many parts? Number 1. First let us discuss about rights. Number 1. What is this rights concept? Company, before going for issue of shares, it will first ask the existing shareholders whether they are ready to give the money or not. I will give one example to you. See here. I gave same example also in regular class if you remember by chance. Do you know what is the example? See here. There is a family containing 4 persons. Listening? One of the person wanted to bring his friend to home for 2 days and he or she will leave after 2-3 days. When there are 4 members in a family, if you wanted to ask your friend to come and stay for 2-3 days for some work in the city, you will ask the parents or the persons already there. Correct or not? So or else you are staying in a room with your friends And if you wanted to call any of your friend to stay with you for 2-3 days, you will ask the existing members or not. Are you comfortable if I call my friend? Or your parents, you will ask, are you comfortable if I call my friend? He or she will stay only for 2-3 days and they will leave. Even for temporary 2-3 days also, we will ask the existing members in the family or in the room whether you are comfortable if I call a new person, correct or not? In a company, 20 years, same shareholders are continuing. They are managing that company, they are giving money whenever required, correct or not? Suddenly you are telling that I will go for a public offer, new persons will come in. So, do you think we are fools? So, always it is a courtesy for the company to tell the existing shareholders, dear existing shareholders, we want money for expansion. If you people are ready to give that entire money, fantastic, I will take money only from you. If you cannot give the money, then I will go for public. Are you okay for that? Did you understand my point or not? They will not behave sadistically. We will not give, don't go to them. So point is, either you have to give or let us to go with the public. Then rights issue concept will come. For example, listening everyone? Yes, for example, company want 5,000 crores money. Existing shareholders are ready to give 100 crores. From where I will get remaining 4,900? From here I will get no, I should go for public offer. That's how 100 crores they will go for a rights offer. 4,900 crores they will go for public offer. Do you understand the concept or not, everyone? Yes, answer. Yes, tell me, what offer we are reading now? Everyone? Rights offer. So tell me, point number 1, rights offer will be made to outsiders or existing shareholders? Answer. What will be given to them? What will be given to them? Offer letter will be given to them. What will be given? Akkade problem came. Everyone has a wrong understanding. Rights shares will be given. No, asal there is no concept called as rights shares. There is a concept called as a rights on the shares. Rights on the shares. See here, I am company. Who are you? Which shareholder? Existing equity shareholders. Who are you? Please be here, keep the senses here. Company will send the offer letter. What it will send? To whom? All the existing shareholders. Company will send the offer letter. You received the offer letter. Open. You saw company going for a public offer. This much amount we want. But to our existing shareholders, we are issuing at a discount. Share is now trading in the market at 1,000. But we are offering only at 920. Listening? Each and every existing shareholder can subscribe. So show your acceptance or rejection within minimum 15 days, maximum 30 days. Minimum? Who am I? What I sent you? What you received? Offer letter. You have to either say yes or no. Not for 100 years. I will minimum give you how many days? 50. Minimum. Maximum. That's all. In the period of 15 and 30 days between, you should either say yes or no. Who should say yes or no? Who should say yes or no? Should say yes or no to whom? What I sent you? You should either say accepted or rejected by sending back the same letter to the company. This all should happen minimum within, maximum not exceeding, and a minimum 15 to 30 days between. Shareholder should show his acceptance or rejection to the company. Did you understand? Now see here, all of you are there in the class. Let us say 200 people are there. 200 offer letters I sent. 180 offer letters I received response. Means either they said yes or no. Remaining how many are there? I didn't receive any response from them. If no response is given, we will deem that they have rejected the offer. Accepted or rejected? Loudly? Because here silence will not be taken as an acceptance. Silence will be taken or will not be taken? Will not be taken as what? Up to here, did you understand what I said? Everyone in the class? So now tell me, rights offer letter will be given by whom? To whom? Now existing shareholders will have how many rights? 3 rights. Either right to accept, right to Decline. First one, right to? Right to? The third one is the most important one, right of renunciation. Right of? Right of? What is the right of renunciation? See here. Company sent you what? Huh? Offer letter. You are whom? To the existing shareholders, I will issue at the same price or lesser than market price. You are ready to buy or not ready to buy? Not ready to buy. At least you give that offer letter to some other person like your friend or etc. At least that person will subscribe. This concept of transferring the rights offer letter. Don't tell right shares. We are not, shares not yet issued here. We are transferring rights shares. We are transferring rights offer letter. What we are doing? The transfer is also called as what? Renounce. Is also called as a renounce. Renounce to whom? Some other person. That fellow will subscribe to that particular shares. So tell me, every existing shareholder will have how many rights? Number one. Number one. Number two. Next one. Renounce to whom? Any other person. Unless articles say no, renunciation is generally given to every shareholder. Understood the point up to here or not, everyone? So one last time, fatafat give the answer. Who sent the offer letter? To whom? Who sent? Company can send by post, registered post, speed post, email, anything you can send. Response should be given by? Back to whom? Minimum? Maximum? If no response is received within the time period, it will be deemed that you have accepted, declined. Tell me, what are the three rights to the existing equity shareholder? Right to accept, right to decline, right to renounce. Understood? Okay. So please read from here. Start. Let us complete rights offer concept. Start reading. First, I want every one of you read these 2 points first. Read. Don't read out. Normally you read and confirm whether you understood or not. Have you read the first 2 points? Do you know what is the meaning of the first one? Always rights shares are issued as a ratio. Rights will have a ratio. 2:5, 1:5, 2:7, like that. Means existing, if you have 5 shares, then you will get 2 shares. Are you understanding? Existing, if you have 5 shares, then you will get how many right shares? 2 shares. Are you understanding? That means if I don't have 5 shares, what will happen? You won't get even single certificate also. Did you understand the point or not? That's the point. Okay. Tell me, what are all the 3 rights of an existing shareholder? Number 1? Number 2? Number 3? Now you answer my question. I am accepting shares. I am accepting offer. That's all. Every time it is offer. Everyone understood? What can be transferred from one person to another? Offer letter will be transferred. Very good. Next. Further shares shall be offered to existing shareholder by sending to each of them, either by way of, sir, fastly, fatafat give the answer. First one. Second one, speed post, electronic mode, courier, or any other mode. Okay. Next, main important thing is the time limit. Minimum how many days? Maximum can't exceed. That's the main point. Next. A statement that if the offer is not accepted within time specified, offer shall be deemed to have been declined. Deemed to have been declined. Okay. Next, you should clearly mention that, sir, answer my question. You already attended regular session or you read this section already. Therefore, you know that there is a concept of renunciation. How come a normal shareholder will know that there is a concept of renunciation? If I cannot buy, others can buy. How would a person will know? That's why a statement that every shareholder has a right to renounce the shares offered to him to any other person, unless the articles restrict such right. Up to here, everyone understood the concept? Rights offer is completed. First tell me the answer. Fatapat give the answer. Point number 1. Rights shares is applicable for company having share capital or not having share capital. This is applicable for public or private, all the companies are. Very good. After that tell me, rights offer letter, rights shares will be accepted, offer letter. Who will give offer letter? To whom? What are the 3 options available? Accept, decline, renounce. Accept what? Decline what? Next, renounce the offer. Offer letter to whom? Any some other person, unless the article restrict you. Understood the point? Tell me, who will send the offer letter? Send offer letter in what form? Either you can send by the registered post, speed post, courier or electronic mode. Any other mode you can transfer. Okay, na? I should give a reply minimum within. Maximum not exceeding. If I don't give the reply, it will be deemed as accepted, declined. That's all. With this, rights offer is completed. Okay, not section is completed. What is completed? Rights offer is completed. How many concepts are there? In that, how many completed? Next, how many are there still? 4. What is the next one? Exam ke employee stock option rules are not applicable. Study material also you can check, it will not be there. Just they will mention that employee stock options also can be forming part of section number 62. Are you understanding or not? You can see the study material also. Just they will give one point and they will leave. Clear or not? A small chart will be given there. That's all. More than that, they don't give anything. So not needed. For exam, just remember that employee stock options, who will issue? Do you know what is employee stock option? Yes, everyone? Yes, it's there in your syllabus? Yes, account syllabus, sir? Not there. Then salaries chapter you might have heard, taxation. In old syllabus it is there. Sorry. Old new keep away. 1 minute. Please. Sir, we don't have time to argue where it is. Let me first explain what is the concept. Exam can even not applicable. Just remember the main content. What is the concept we are going to deal with? Name lone clear. ESOP. Employee stock options. Listening? Let us say for example, he is a very much a skilled employee in my company. I don't want him to leave my organization. I should make something luring for him to stay back in my company. I wanted to retain him. What I will tell to him? I will tell, dear employee, I will give you one option. If you follow that, you will be given a bumper offer. The bumper offer is as follows. You stay for another 3 years. Stay for another 3 years. Okay, na? Today our share price is 4,400. 4,000? It may reach by maybe to 8,000, 9,000 after 3 years time. Maybe 10,000 also can happen. Sir, let us say it will reach up to 8,000 to 9,000. In over a period of how many years, sir? 3 years. Okay, na? TCS is standing somewhere at 2,300, 2,200, 4-5 years back. Now it came to 4,500. 3 years, like double it has become almost. Correct or not? There is no surplus if it doubles in another 3-4 years. So I said to him, dear employee, now share price is 4,400. It may become almost somewhere around 7,000 to 8,000 in another 3 years time. By that time, if you wanted to buy the shares of TCS, you have to spend how much? 7,000, 8,000 you have to spend. Listening? Yes, you stay with me for another 3 years. Another 3 years. After completion of 3 years of time, I will give you 1,000 shares of TCS, our company, at 4,400 only, or at 4,200 only, or at 4,500 only, irrespective of whatever the price prevailing on that day. It can be 12,000 also. I will give you only at 4,000. Listening or not? Yes, this all happens subjected to what condition? Subject to what condition? 3 years you should stay with the company. Subject to that condition only this option will be given to you. Listening or not? Now tell me, listening everyone, tell me, company is issuing the shares today na after 3 years? Answer? After 3 years. What it going to issue? Shares. To whom? Every employee with whom we entered into this agreement will continue for 3 years. Doubtful. May be there, may not be there. Whoever is there after 3 years, for them we have to issue the shares at the same price or lesser price. Because we agreed at 8,000 or 4,000. At that price only you should issue. That concept is called as an employee stock option. Now you tell me, 1,000 employees, 600 stayed for 3 years. Now what should the company should do? 600 share. How many employees are there? 1,000 totally. In that, how many stayed for 3 years? How many didn't stay? And for those 400 I need to issue the shares or need not? But for the 600 employees, what I should do? Issue shares. Each person should be issued with how many shares, sir? 1,000. Answer, sir. 1,000. 600 into 1,000. 6 lakh shares I have to issue or not? 6 lakh shares, existing shares I will give a new shares to be issued. That's why it comes under 62 again. Did you understand the point or not? This is also coming under? This is also coming under further issue of shares. Coming under further issue of shares. See the screen now. Easy concept here, dead easy. Just 1 minute. Please read this. Read. Further shares may be issued to, may be offered to the employees if such further shares are offered under employee stock option. Which resolution has to be passed? Special resolution. By complying with such conditions as may be prescribed. When I say as may be prescribed, what is the meaning? Answer. But rules applicable for example, not applicable. Not applicable, forget about them. In case of public company, instead of special resolution, ordinary resolution shall be sufficient. In case of which company? Public company. Unlisted public companies ki instead of special resolution, what is required? Ordinary resolution. That I will tell you when it is required. As of now, remember what resolution? Specially required. Ordinary required only in one case. That one case we will see in deposits chapter. Which chapter? There is a linking concept to that. So now tell me, what are the two concepts we completed now? Number 1? First one? Second one? Tell me, employee stock options, what are the two important conditions? Number 1? Offer of securities to whom? Answer. Very, very important. Second one, which resolution has to be passed? Shareholders by passing a special resolution in a general meeting. Everyone understood the 2 points? Answers are everyone in the class? Very good. Next one. 2 things we completed. What is the third one? See here. Offer of further shares to any person. Please listen carefully. See here. If you want to issue shares other than to the existing shareholders in the form of rights issue or employees in the form of that means you are issuing to whom? You are not issuing to existing, you are not issuing to employees, and then you, to whom you are issuing? Public. When you are going for a public offer, automatically share capital chapter does not apply. Which chapter will come? Prospectus. That's why section number 123 to 42 shall apply. Are you understanding the point or not? Which resolution is required again? Special resolution. That's all, answer is over. Tell me what are the 3 concepts we completed now. Number 1, rights offer, ESOPs, public offer. Start again. Number 1, number 2, number 3, first one. Tell me, rights offer is given to the ESOPs given to the other than these 2 will go under public offer. For that, which sections we have to comply? 23 to 42. Which resolution is required to be passed? Special resolution is mandatory for that. Clear everyone? How many points we completed? 3. What is the next one? What is the next one? This I will explain first. After that you read. Dead easy concept seems to be bigger like other concepts what we read. But stuff, nothing. Listen carefully. Point number 1. So what is this concept of conversion of loan into shares? Banks will give loans to the companies. In 100 companies, at least 5 to 6 companies will become defaulted companies. Which companies? Defaulted. What do you mean defaulted companies? They will pay na, will not pay na. Those are only called as a defaulted companies. Listening everyone? Now tell me, when the company become defaulted, generally what will happen? When the company become defaulted, generally what will happen? They will go for liquidation, insolvency, or one. All nonsense happens in company. Correct? To avoid that, most of the companies or banks, whenever they give loan to the holding companies, they don't go for liquidation because court generally don't allow liquidation of holding companies. Do you know why? Tata Group, there are around 300 subsidiaries are there. Around annual return, if you see, around 300 subsidiaries, so 480 associates are there for them. So that auditor will die. That fellow has to do 700 questions every year. Are you understanding? On 700 companies, you have to prepare P&L balance sheet, means how many question and answers you have to do? 700 question and answers you have to do. Dirtiest thing is he will write question and he will only write answer. Because he only has to prepare everything, he only have to write audit report for that. So there are around 300 subsidiaries, so 400 associates are there below the group Tata. Because they are having branches throughout the world. Wherever possible, they are having the contracts. Now BSNL also added. Clear? So wherever collaboration is required, they will collaborate, they will start doing the business. So now the concept is very clear. Most of the banks, when they give loan to the holding company, they don't like you to die. They like to acquire. Now you tell me, example, it should never happen also. Just for example I am saying, LIC is there. Which one? You wanted LIC to close, you wanted LIC to be under your control, means generally what banks will say? You want LIC to close, you wanted to control LIC. Everyone in the world, I mean talking about companies. One company wanted to control another company. No company wanted another company to die. We wanted you to control. That's why lot of acquisitions will happen around us. Are you understanding or not? Big companies, including CA institutes, also going for acquisition. One company will acquire another company. Why? We don't want to die. Everyone wanted to control another person. The greed to control another person will always make you to acquire another company. Clear? So what will happen? Bank is giving loan for example, Tata Sons Limited, holding company for all the group Tata. Which company? It defaulted in making, it will not. In dream also it don't happen. But for example, it will happen. Tata Sons Limited defaulted to the bank. Bank will go for court. Tell that court, please close that company. Court will tell that please go out and play. Why? Are you a fool or what? That company defaulted, I agreed. Below that there are 700 companies are there. Did you understand or not? How can we wind up that company? We can't wind up, court will tell. Obviously court will tell the same answer. Correct? Sir, I told you very clearly, India execution cases are very less. Execution means hanging. Do you know why? Our judiciary don't agree to kill a person. Listening? 1,000 cases, one case also execution don't happen in India. Liquidation is a corporate death. The same logic they will apply. Don't kill the company just like that unless there is a good reason to kill. Listening? So courts don't just like that tell, kill the company, close the company, they don't tell. You see one concept, there is one case happened in the Supreme Court of India. I don't wanted to tell that and waste your time, but listen carefully to the conclusion. There is one company, Tata Iron and Steel Company Limited. There is another company, Micro Forge Limited. Two companies are there. These two companies, Tata Iron Steel Company Limited, 1972, one very big strike happened with the labor union. Labor union in Tata. They didn't work for 6.5 months. Production stopped completely. Money not generated. Microforge is a financing company. It gave money to Tata Iron and Steel at that time. Listening? They didn't pay interest properly. Because of labor issues, everything, money is not there. They could not pay. Microforge went to the court. Are you listening? Since there is a default exceeding 1 lakh, close the company, it said. Do you know what court said? When you don't get the money from Tata Iron and Steel, you should ask money to come back. Why you are asking that company to die? Sorry, I will wind up. I will wind up. Court said, we will wind up. There are 11 lakh employees. You feed them. Send food, clothing, shelter every month to them. Okay? Tata Iron and Steel Company Limited is paying around 10,000 to 12,000 crores of tax every year to the government. You pay the tax to us. Then we will kill that person. What is that sadism? Always say kill that other person, kill that other person. It's a company or it's a human being. Killing is not a concept in India. Are you understanding or not? Our corporate death courts don't entertain. With a lot of experience, I have done 84 NCLT cases. Nowhere in India NCLT don't entertain the winding up of companies. You ask anything, it will honor, except winding up. Do you understand the point or not? So winding up courts don't entertain. NCLT don't even consider your winding up petitions. So what happens shall I tell you? See here. Whenever company go for a public offer, 23 to 42 will apply. Correct? Most of the companies, for example, bank gave loan to TSL, Tata Sons Limited. And Tata Sons Limited is not paying the loan properly. Bank will try to wind up TSL. Bank will try to acquire TSL. Do you know how they will acquire? Convert this loan into equivalent amount of equity share capital. Convert. See here. I will give you one example. Please be here in this world here. What is this? What is this? Balance sheet. Okay, na? Please see here. In the balance sheet, equity share capital, how many crores? Debt, how many crores? Answer, sir. 200 crores. Totally balance sheet, how many crores are there? Very good. This is paid or not paid? Answer. They said that convert us into 200 crores of capital. Convert. Okay, now tell me, debt will become how much? Answer. Now company will give new equity shares to how many people? How much worth, everyone? 200 crore worth shares they have to issue or not? Now tell me, further issue of shares happened or not happened? Happened. Happened by getting new money, happened by conversion. This is the next case he is telling, fourth one. Conversion of what into what? Loan. Conversion of loan into? Now do you know what is the impact of that? Creditor will become the controller of the company. Creditor will become the... now tell me, debt will become the controller of the equity. Or technically, who are the real owners will not have majority control now. Who will get the more control? Who are converted creditors are there? Now, these converted creditors will control that particular company. This is the concept he wanted to deal in the point number 4. Did you understand or not, everyone? Understood or not? Now you please read this particular concept here. Start. Nothing. In section 62, restrict the power of company to allot the shares on account of conversion of loan or debentures into share, provided the terms of issue of the debentures and that or the terms of raising such loan contain the term regarding conversion of debenture. Mean at the time of taking the loan itself, there should be a term that if money is not paid, the loan will be converted into shares. Next. And what resolution you have to pass? Special. Same, instead of bank, if you put the government in that, it will become the next point. That's all. With this, we completed section number 62. The one of the biggest section in your syllabus. Summarize everything. I will clap for you. Listen. Answer my point now. You answer properly. First, how many issues are governed by 62? Number 1. Rights offer. ESOP. Any offer other than rights offer to the existing shareholders and ESOPs. Governed by which chapter? Chapter number 3. Sections 23 to 42. Very good. Next. Conversion of loan into debentures. Next. Loan into shares. Next one. Conversion of loan into shares, and the loan is given by the government. Same conditions, everything is essentially the same. Everyone understood the concept clearly? This is what they have said here. See, this is the question given. If you do one question now, you will get full clarity. Sorry, see, this is a May 2017 question. Read the question first. Start. Sir, if you do one question now, you will also get clarity how questions will come. Read. ABC Limited is holding total equity shares in SVS Company Limited. Very good. Next. The board of directors of SVS Company Limited decided to raise share capital by issue of further equity shares. The board of directors resolved not to offer any shares to ABC Limited on the ground that it was already holding a high percentage of total number of shares already issued in SVS Company Limited. Articles of Association of SVS Company Limited provides that new shares be offered to existing shareholders of the company. On March 1st, 2014, new shares were offered to all shareholders except ABC Company Limited. Referring to the provisions of Companies Act, examine the validity of decision of the Board of Directors of SVS Limited of not offering any further shares to ABC Limited. This is the concept we want to discuss now. Please listen, I will tell you what they wanted to tell. What is the name of the company issuing the shares? Not ABC, SVS. I didn't tell what is the first name. What company is issuing the shares? In that, who is the existing shareholder? Already holding how much? Now company SVS Limited is going for further issue of shares, rights. Correct? Whenever rights is issued, you should issue what letter? Offer letter to whom? Which existing? Selected? All. Now he is trying to tell that already you are holding 46. If I issue further shares, you will become majority shareholder. Therefore, I will not issue. Is that there in the section that you can do like that? No. So that intention to do like that is right or wrong? That's what the answer. See there. Read. Understood the answer? Okay. Next, I will show you another question. Try to answer the same question, sir. Everything is essentially the same. Hopefully you understood how the questions will come. Everyone in the class? Yes, okay. So this is how the questions will be tested on rights offer. Next question. What is the next one we are going to discuss? Bonus. Just 2 minutes concept. Very short concept. Just see this. One exam question also is there. We will see. See here. Everyone first tell me. Make me to understand the concept. Bonus offer is given to new persons or existing? Answer. Bonus shares are issued in bulk in a ratio. 1:10. What do you mean by that? For every 10 shares held, one bonus share will be given. That is the meaning of 1:10 bonus ratio. Everyone understood or not? What is 1:10 meaning? For every 10 shares held, one bonus share will be issued. Okay, na? What are all the conditions? Let us see. Point number 1. First, who should allow? Very good. First one over. Next one. Before going for bonus offer, first whose permission we need to take? Answer. Both. Board of directors permission is required. Next one we will go for whose approval? Shareholders. By passing which resolution? Ordinary. No special. Forming which resolution? Ordinary resolution. Answer my question. Dividend who will propose? Hey, please hear. Dividend who will propose? Who will approve and pay? Same. Bonus issue is another form of dividend. Bonus issue is another form of. So do you know what is a bonus issue? Another name? Stock dividend. What they call? And instead of paying the dividend, what you can do? Issue the bonus shares. Therefore, bonus issue in the markets, generally people call it as a stock dividend. Dividend in the form of stock. Dividend requires whose proposal? Recommended. Whose approval? Therefore, same applicable also for bonus issue. Who will recommend? Who will approve? Tell all the 3 conditions. Number 1, where bonus issue should be approved first? Where it should be okay. Very good. After that, whose recommendation? Next, whose approval? Very, very important. From where you can issue bonus shares. Read. Bonus shares may be issued out of free reserves, securities premium account, capital redemption reserve account, not out of revaluation reserve. Out of a, not out of a? Shall be a, shall not be a? Tell all the three. Point number one. First, where it should be allowed? Number one. Number two, who should propose? Who should propose? Who should approve? What are the sources of issuing the bonus shares? Free reserve, securities premium account, capital redemption reserve. What reserve you cannot use? Very good. Next one. Sir, bonus issue will be made if there is a deficit, extra profit, surplus. Answer. If you have that much a surplus, there are a lot of defaults in your company. First clear them and then go for bonus offer. Therefore, no bonus shares can be issued only if it has not defaulted in payment of principal sum or interest on fixed deposits or debt securities issued by. Simply to tell, if there is any default in the debts, either principal or interest, can it go for bonus or cannot? Same applicable also for which dues? Statutory dues like provident fund, gratuity. Employees has to be paid provident fund. When they are leaving organization, you are not paying them and you are telling I will issue bonus shares. If you have that much profit, first you should clear the defaults or not. Simply to tell, when there is a default in debts, when there is a default in statutory dues, you cannot go for bonus offer. Now tell all the 6 conditions. Totally 8 conditions you should tell. In that one condition I am asking first. Start. Who, where bonus issue should be authorized? Number 2, whose proposal? Bad response. Start from the beginning. Where it should be allowed? Proposal. Approval. Bypassing. In a. Very good. Next one. After that, what are the sources of issuing the bonus shares? Free reserve, securities premium account, capital redemption reserve account. What reserve can't be used? Cannot be. Very good. After that, bonus issue can be made unless if there is no default in debts. Default in debts. Principal and interest both. Both. Next, there should be no default in. Up to here, everyone understood the point. Next one is a rules complaint. That is not important. Bonus issue will be made to outsiders or existing members. Existing. Bonus shares must be. Means if it is partly paid, remaining part you have to pay or not, then why it will be called as a bonus? Understood the point? Bonus means it should be absolutely free. There should not be any payment again attached to that. Clear or not, everyone? That's the point. Okay. So these are the important points that you need to understand. One question is there given in examination. I want every one of you to answer first. Sir, one important observation. First thing you answer me, whose permission we need to take? And first, where it should be written that bonus offer is allowed? If articles is silent, can you go for public offer? Can you go for bonus offer? Answer. You cannot. What you have to do? Alter the articles and then only you can go for a bonus issue. What you have to do? Again start here. Please, you are slowly losing the momentum at the time when peak concepts are coming in this. Please answer again. Company going for which offer? It can go only if who allow you? Articles is silent. It is not saying that bonus is allowed. Can you go for bonus offer? You cannot. If you can go in that case if and only if alter the articles and go for bonus offer. Number 1. Okay, complete. Next one. I have some questions to ask. Fatafat give the answer. My company authorized share capital. What is that? Authorized share capital. 1 crore. 10 lakh shares of 10 each. 10 lakh shares of 10 each. Authorized capital means what is issued, maximum you can issue. Maximum you can issue. As of now, I issued 7 lakh shares of 10 each. I issued 7 lakh shares of 10 each. Now I wanted to go for one-on-one bonus offer. One-on-one bonus offer means 1 share for every 1 share held. Okay, now tell me, how many shares are there? 7 lakh, how many shares I will issue? Answer. It will become how many shares? 14 lakh into 10 becomes how much? 1 crore 40 lakh. But maximum allowed is how much? First you have to alter the capital clause of memorandum. First you have to alter the and alter which capital? Issued capital, subscribed capital, paid up capital, which capital? Authorized share capital you need to increase up to 1 crore 40 first. Thereafter only you can issue that. Did you understand how the exam questions will come? Now I will show you one question that is given in examination. Please see here, answer. If you answer this, pakka, we'll go to the next one. Start. Equity share capital, 3 lakh shares of 10, free reserve securities minimum, CRR revaluation. Directors of the company seek your advice. Whether company can issue a bonus shares of 1:3. Tell me. Observe the question, yeah, what's wrong with you? How many shares are there? Answer. Here how much is the total amount? 1:3 means what? What do you mean by 1:3? For every 3 shares, I will give 1 share. Correct? Okay. 3 shares ki 1 share mean 3 lakh shares ki how many shares? 1 lakh shares. Correct? 1 lakh into how much? Totally how much? First you see whether 10 lakh fund is available or not. Tell me how much is a free reserve? Here. Here. Useful or not useful? Which is not useful? Revaluation reserve. So totally how much is useful now? How much? Very good. How much? 12 lakh. So now you answer my question. 12 lakhs can be used within the company for bonus offer. Correct? I want how much? How much I have? Can I go for bonus offer? Pakka you can go. Now you tell me what is this? What do you mean 1:2? For every 2 shares you will get 1 share. So now tell me 2 shares ki 1 share mean 3 lakh shares ki how many shares? 1.5 lakh into how much? How much amount? But how much is available? Cannot? That's the question he asked here. 6 marks question given in exam. Okay, read the question. Read the answer, sorry. Did you at least understand how questions will be tested? They don't ask you directly, write about bonus shares like that, they don't ask. They will ask a practical question like this. If you listen to the class properly, you can write and get the 6 marks. But that you have to do properly. That's a problem. Did you understand? Understood the answer? That's it. Next. Now we are going into the main Enter the Dragon. What is the concept we are going to discuss? Buyback. The most important one in the entire company law. Highest number of times, a question which came for 17 times in exam. What is the concept? Buyback. Buyback lo 2 partitions are there. Purchase, buyback. 2 things are there. I will ask one question first. Tell me. Buyback sections are 4. 67, 68, 69, 70. Repeat. 67, 68, 69, 70. How many sections? 4. 4 sections are there. 67, 68, 69 and 70. These 4 sections are the hardcore sections of buyback related things. Okay. Buyback concept is very easy to understand. But the only problem is you have to remember 12 points. How many points? I will make you to write in some paper all the core contents. But first very important thing is 67. Mark it important. This attempt 99% chance is there. Everyone will prepare 68, 69, 70. He will ask 67. How many of you know about 67? First tell me. To whom you are asking which question, sir? Sorry, okay. No problem. Please listen. Shall we? Listen carefully. I will put it before you. Then we will discuss about this. Exceptions not required. Okay, first let us see this. See here. What is the name of the section? Purchase by company of its own share. Section number? People generally think that this is buyback. This is not buyback. I will give you one example. Tell me. See here. X Limited is there. So please listen carefully. Please. Balance sheet. Equity share capital. 10 lakh shares of rupees 10 each. How many lakhs? 100 lakhs. Is the equity value of which company? X Limited. Up to here, understood? Start again. What is a company? Left side, what you have written first? Equity share capital. Okay. How much is equity share capital? Repeat, yeah. 100 lakhs. What is 100 lakhs? Equity share capital of this company. Listening, this company is going for a buyback. This company is going for buyback. Means that company will buy its own shares. If it buy its own shares, do you know what will happen? The problem that happens is investment, the same company will be there. Listening? Who is buying? Buying whose shares? Answer, sir. Own shares. So, let us say if it purchases, how much? 20 lakh. This 20 lakhs is a part of this 100 or not? Therefore, this 20, in this 20 will be cancelled and it become 80 lakh. Did you understand the point or not? I given debit of how much? 20. I gave credit of how much? 20. Both will cancel each other. The capital will come from 100 to how much suddenly? 80 lakhs it will come. So first logic of buyback, did you understand? This is one way. Are you listening? This is called as a direct buyback. Which buyback? Direct buyback. This is governed by section number 68. Governed by section number? Now you tell me. Buyback means company is investing in its own shares. Therefore, asset and liability to that extent will cancel. Will cancel. First point everyone understood? Let's go to the next very, very important point. See here what will happen. Shall we? Yes, see here. You are all my employees. Okay? I will give you loan. I will give you loan. I asked, you are employee. You came to me. You said, sir, please sir, I want loan. I said, how much? You said 10 lakh. For what? I asked. You said, sir, I wanted to buy our company shares. Did you understand the point? Loan is given by? The answer, yeah, loan is given by? Company. Given by? Company. From, now very good. Tell me. Company will get money from cash, stealing, robbery, yeah. From where it has to get the money? From its cash box only it should get the money. Answer, yeah. Who are you? Who are you? What you are asking me? For what? My shares. I will give loan. From where I will get loan? From here. Loan means money will come. What I should do? From my cash box I took 10 lakh. Who are you? I gave to you. With that money what you have done? Bought my own shares. And technically what is happening? Company using its money to buy its own shares. This is also governed by same 67. Right, do you understand the point or not, everyone? How many of you are listening this for the first time? Honestly speaking. Hey. Truly. How many of you are listening for the first time? Okay. Remaining people, you are listening already, yeah? Sir, don't ask such questions, sir. You continue the flow. So tell me, point number 1 you answer. First, company is giving loan to whom? For what? For buying its own share. That also amount to? No, that's not buyback. That's a purchase of own securities. It's not buyback. Buyback means company has to buy. This is indirectly the shares are bought using the money of the company. Babu, understanding or not, Chitti? I don't have that much time to explain a full background. Basic idea of section 67 understood? Whose money? Given to whom? Employees buying what? And technically, assets aside, cash is reducing, and the cash went into the share capital of that company. And technically, what is happening? Company is using its money to buy its own shares. Though not company directly buying it, through whom it is buying? That's the point we are going to cover here. 67 is talking about a different way of buyback, but not a buyback. That's why they will ask in question. Listening, everyone? Will we read now? At least shall we read? Let's read. See there. Read. No company. Prohibition. Read here. No company shall buy its own shares. Okay? No company shall buy its own shares. Second point, preferences we will see later. General rule. Read. No public company shall give financial assistance for purchase of its own shares or of its holding company. Now I told you, you gave what? Financial assistance, also called as what? Loan. To whom? Employee example I gave. Some person. That person is using that money to buy your own share. That means you are using your own fund to buy your own shares. Next. Read. The restriction applies to every kind of financial assistance, any kind. It can be loan, guarantee, security, or otherwise. Main concept, you tell me when section 67 will get attracted. When section 67 will get attracted. If a public company gave which assistance? To whom? Any person. For what? Purchase of its own share. What do you mean by financial assistance? Any financial, it can be loan, it can be guarantee, it can be security, anything. Are you listening to the point? Answer? See there. But the next one is the exception. When I say exception, financial assistance is permitted in that case. Before going into that, first explain me. I am not believing in you whether you understood or not. First tell me, point number 1. What is governed by section number 67? Purchase of own shares. Directly by the company or through other persons? First tell me, company is giving what? To whom? This person is what? Buying what? Shares of the company. And technically, whose money is going out? Answer. Company's money. And use it to purchase what? Own share. That means company money is used to buy its own share. Allowed or not allowed? Allowed, not allowed? Financial assistance means what? It can be a loan, it can be guarantee, it can be a security. It can be a security. Anything, it can be any kind of financial assistance. Now we are going to see there are how many exceptions? 3 exceptions which are very, very important for exam. Let us see. Please read. See here now. Shares of LIC, shares of SBI traded or not traded? Hey. Unexpected answers you will give sometimes. Shares of SBI, shares of LIC traded or not traded? Do you know why I got hurt? Not because of the reason that you told wrong answer, because of the reason that I am shareholder of those 2 companies. And you are telling that no. LIC public offer I bought, SBI normally I bought. Both the company stocks I am having in my Demat account, you are telling that both are non-tradable. And now I have to check myself what happened to my stocks. Start again. State Bank. Why are you laughing here? You gave utter flop answer and you are laughing. Tell me now. State Bank of India stocks are traded or not traded? Answer? Traded in the market. Means can I buy the shares of SBI? Answer? What is SBI? State Bank of India. Where a level? Where a level? Where a level domination? What is SBI? Bank. SBI full form, who will ask you? What is SBI? It is State Bank of India. Tell me, what is SBI? Bank. What is the purpose of what bank will do? Give loans or take the deposits. Anything they will do. Correct or not? Now tell me, listen now. Sir, whoever open one account with SBI, for them they will give the loan. Do you know what is a personal loan? Have you heard personal loan? What do you mean personal loan? Don't ask reason, are meaning. Don't ask reason. Personal reason I am telling. Then why you are asking why? My personal I should tell to you. That's why we call it personal loan. What do you mean personal loan? Reason unlisted. You don't need why I took. I will use for whatever purpose I want. What you want? What? What you want? That you take. Why you are asking reasons? Why I am using it? I will distribute. I will give like Mr. Beast. I will distribute that money. Free petrol I will give. Why you are bothering about that? I will do whatever I want. What do you mean personal loan? Reasons listed or not listed? Vehicle loan for what? Housing loan for what? Personal loan for what? Then why you are asking why? Don't ask. Now tell me, I went to SBI, 12.5% personal loan. I am okay with it. Because I am investing in stock market which will give me 24% return. 10% financial leverage I want. Listening? I went to bank. I asked a 10 lakh personal loan. Bank said that okay, take. They asked what is the reason? Personal loan. So they asked okay, thank you very much. Write in the agreement to sign the documents, everything over. I took 10 lakh. I purchased shares of SBI now. Are you understanding the point or not? What is SBI? What is the ordinary course of business? Lending and borrowing. Now you lend money or not? That means whose money came? Bank money came to me. Use it to purchase the bank shares. When I take personal loan, how bank can stop me? That's why exception number 1. Babu Chitti, recognize the efforts, Chitti. Understood the point or not? You are listening as if for the first time in life. Really? Like that section is? Like that you are seeing. So tell me now, point number 1, understood the first one clearly or not? Who lend money? To whom? Some person. That person used it to buy the own shares. But bank ordinary business is what? That's all. In that case it is exempted. Or second one. Tell me. What was given? By whom? Not banking company. Not banking, normal company, TCS. In accordance with any scheme. Approved by the company through which resolution? Special resolution for the purchase of what? Fully paid up shares of the company. But being the purchase of shares by the trustee for the benefits of employees. Very, very important, sir. Let's be serious. Listen carefully to the concept. Read it. Take a minute time. Read it properly first. Subham. Okay? Right? First point number 1. Tell me, what do you understand? I understood that. I didn't understand. Tell me, what you understand from that? Don't read. Don't translate that. Tell me what is the meaning? Shall I tell you? Listen carefully, sir. Please listen. Just 2 minutes. Why I am more concerned about this means, first point number 1, you are not understanding ICAI properly. They don't ask a question. Write about section 67. Write a brief notes on section 60. It did not become exam. They don't ask direct questions. They create a case study on that. The problem is, I will tell you, if there is a question already asked in examination on that, you are safe. At least you know how the question will be tested. Question not tested in exam till now. If a new question comes, dumb. Therefore, you should know how question will come first. Are you understanding? Listen carefully. Please be here. There is a company. That company is providing a financial assistance. Financial? To whom? Other point. Listen carefully. There is a concept called as a trust. What concept? Trust. Trust means obligation. Trust means a? So I don't wanted to tell about trust to you in this class, but just listen carefully to what is a trust. Trust, the main person is a trustee. Main person is a? Trustee. Who will create a trust? Author. Loudly. Author. Who will create? Author. And obligations who will discharge on behalf of author? Trustee. Shall I tell you what is the relation of a trustee with a trust? Karta to a HUF. Karta to a? HUF is Karta, na? HUF is the representative of, Karta is a representative of HUF. Like that. Trustee is the representative of trust. Karta? Representative of HUF. Trustee, representative of trust. Representative of? That's why, akkada HUF la Karta, ikkada trust la trustee, both in income tax, they will be taxed under representative SSA category, section 160, subsection number 1, class number 5. Okay, in trustee capacity, they are taxable. Income tax act la. So, forget about income tax. First try to understand which SSC they are. Representative capacity la they are taxable. Who? Trustees. Do you know who is a trustee? Now he will work. There is a company called as a Tata Iron and Steel Company Limited. Huge profits it is getting. Okay? It has one policy. Whoever completed 15 years of their experience in Tata Iron and Steel, really I am telling, not example. There is a policy in TISCO, 15 years if an employee completed continuous service without a break. Without a? For their children, free education, Tata hospitals free medical checkup or free medical treatment, any disease. There are recognized 150 or 160 diseases are there, including cancer. All those free treatment in all the Tata authorized hospitals. Did you get my point? Huh? Next, if an employee completed 25 continuous years of service, listening? If they want, they will give a plot of land. Or you can choose money. Or you can choose other kinds of benefits. So Tata is giving that from the very beginning. From 1904 they are doing this till today. If you work in any of the industries belonging to Tata, not being software, it should be manufacturing industry first. Are you understanding or not? This doesn't work for TCS, work for TISCO. The policy is for TISCO, Tata Iron and Steel, because it's a heavy duty mechanized environment. Labor work will be there. Listening? Now you answer my question. Tata Iron and Steel Company Limited is there. That created a trust called as a Tata Trust. Which one? Tata Trust. Do you know what Tata Trust will do? Tata Trust, whenever employee completed his 25 years of service, immediately bulk amounts this Tata Trust will transfer to him. Okay? From where Tata Trust is getting all that money? From the holding company called as Tata Iron and Steel Company Limited. Tata Trust is an entity. That entity will get money from Tata Iron and Steel Company Limited. Are you understanding or not? I will give you an example. Listen carefully to the point. See here. Tata Iron and Steel Company Limited. Visualize my example. Tata Iron and Steel Company Limited. Transfer money to Tata Trust in the name of CSR. In the name of? Repeat again. See here. Understand the diagram properly. Tata Iron and Steel Company Limited transfer money to the Tata Trust in the form of loan or whatever the name you want as a CSR. Financial assistance they will give to the trust. Listening everyone? That trust using that money will buy the shares of TISCO. Will buy the shares of TISCO. Whenever employee is going out, they will sell these shares, get the money, use it for the benefit of employees. Do you understand my point or not? Observe the cycle again. Start. Tata Iron and Steel Company Limited will give money to Tata Trust. Tata Trust will use this money to buy the shares of TISCO. Whenever one employee is going out, Tata Trust will sell the shares of Tisco. What he will get? Given to the employee benefits. Now tell me, who is giving financial assistance? Company is giving. To whom? Trust. Other trustee. Trust means inside that who will be there? Trustee. Why they are giving money for whose benefit? That is exempted, he is telling there. Are you understanding the point or not? Question they don't ask you directly, they will ask case law like that, you should remember at that time. Listening everyone? Now read. Read. First one. Provision of money according to a scheme approved by, and this should be approved by, and Tata Iron and Steel Company Limited, the shareholder should first approve that. Approve by a? Very good. Purchase of what shares? Fully paid shares. Being the purchase of shares by trustee for the benefit of, this is permitted. Everyone understood the concept clearly? Nice. Next one. What is the exemption number 3? See here. What is the next exemption? Let us see this. First, tell me, what we are giving? What we are giving? By whom? To whom? Employees. To whom? Other than whom? Directors or KMP. It's not offered, directors or KMP. For an amount not exceeding their salary or wages for a period of 6 months. With a view to enabling them to purchase fully paid shares in the company or in its holding company. Simply to tell, can company give loan to its employees to buy its own shares? Yes. But that loan amount should not be more than 6 months salary. Not more than. That's all. With this, section 67 has been completed. Everyone understood the concept clearly? Everyone understood the concept clearly? Tell me, what is 67? Company giving financial assistance to buy its own shares. Permitted, prohibited? In how many cases it is permitted? Tell the summary. First case, banking company, because its ordinary course of business is lending and borrowing. Understood? Next one. Number 2. No, don't tell like that. Tell me. First, a company has given financial assistance. To whom? To the trustee for the benefit of. But that opportunity should be approved by shareholders by passing a in the company. Everyone understood the concept clearly? Answer, sir, everyone? Yes, sir. Next one. After that, in what case it is allowed? What is the third exception? Company is giving? To whom? To buy it, sir. But the loan amount should not be exceeding 6 months salary. In employees, who will not be included? Directors or KMP. Perfect. This is the end of section number 67. Everyone got the clarity? Everyone? When you read, fastly read that and complete when you are preparing. Listening, everyone? So the last topic for today, with this we will close. Tomorrow's session will complete. Listen carefully. Tomorrow's session, I promise you, by hook or crook, whether I take extra 1 hour, 2 hours or 3 hours, I don't know. We have to complete 4 targeted chapters tomorrow. All 4 are small chapters. Number 1, debentures. Number 2, deposits. Number 3, charges. Number 4, accounts. Listening or not, everyone? Such that let us put the target and complete. Since they are small chapters, easily we can complete and brush through them. Listening or not? So target has to be reached, because in this 4-day, my efforts will be, you may see from the morning I am shouting like this. I have to, because we promise that I will definitely complete that particular substantial part of the syllabus. Tomorrow's session, dedicatedly I will put the efforts only on small chapters which you leave. Listening? Each chapter maximum 35 minutes, 40 minutes we will put. We will fastly revise the important concepts, go to the next chapter and complete them. Do you understand the point or not? First, if possible, I will start with the preliminaries also. Some kinds of companies are there applicable for your exams. Those companies also first I will cover. Once after that, those small chapters if I cover, next 2 days we can put our complete efforts on the big chapters. Listening or not, everyone? Sorry. Buyback, let me first put out a summary of what you have to understand, because buyback concept is not new. Every one of you might have read at least 2-3 times before this. Okay, but I don't want to take even a 1% chance. Let me first explain what are the important concepts in buyback. See here once. By the time you do that, I wanted to ask you one question. Buyback of security, you see there. This is a question they asked. After that, they tested so many questions. See, these are all the various questions they asked on buyback. So I don't want to put all before you. Important concepts I will ask one by one. Let us read. First one. What is the point number 1 we need to read? Sources of buyback. What is the first one? Sources of buyback. Buyback can be made out of 3 very, very important sources. What is the first one? Second one? Next one, proceeds of fresh issue. Tell me what are the 3 sources of buyback. Number 1. Number 2. Number 3. Just remember the fresh issue. So tell me one by one. What are the sources of buyback? Free reserves, securities premium, fresh issue. Number 1 over. Next. Important concepts only let us read. First, who should authorize the buyback? Who should authorize the buyback? Very good, but listen carefully. Always try to understand. Buyback requires authorization by passing which resolution? However, special resolution is not required in one case. Means only whose approval is required? Board of directors at a board meeting only required. Means what resolution is not required? Special resolution is not required. When? See the screen. Buyback shall not exceed, read 10% of aggregate of paid up equity share capital plus free reserve. If that is not exceeding this limit, what resolution is not required? What resolution is enough? Special resolution is not required. Board resolution is enough. Understood or not, everyone? Repeat, everyone understood? Yes, very good. Tell me what is the first one? Buyback shall not exceed how much percent? 10% of what? Paid up equity share capital plus free reserves. Very good. Next, see here. Buyback is authorized by special reserve. Even if you go beyond that limit, it is permitted. But please see these 2 points. Read. Buyback shall not exceed 25% of paid up share capital and free reserves. Next condition. Buyback of equity shares in any one financial year shall not exceed 25% of paid up equity share capital. See both the limits. MCQ they will test both the questions. Answer mine. Generally buyback require which resolution? When special resolution is not required? If the amount of buyback is not exceeding 10% of paid up equity share capital plus free reserves, if that amount is not exceeded, buyback require only what resolution? What resolution not required? Very good. Second question. Special resolution you pass. That does not mean whatever amount you can go. There are 2 important points here. In the life of a company, everyone, in the total buyback cannot exceed how much? 25% of total paid up share capital plus free reserve. In 1 year it cannot exceed how much? 25% of equity share capital. Read properly. You didn't read. Everyone is reading as if this is the first time you are reading. See the limits properly. Tell now. What are the sources of buyback? Free reserves, securities premium, fresh issue. Very good. Next, who should authorize? Next, every buyback. First, whose approval is required? Board of director. First, whose approval is required? Board of director. Next, when you can escape special resolution? If the amount of buyback does not exceed 10% of paid up equity share capital plus free reserves. 1 point over. If it exceeds, which resolution required? Now let me, by passing special resolution, I wanted to go for 100% buyback. Then company go for winding up. So not permitted. So how much is only allowed? 2 conditions you have to satisfy. Total buyback should not exceed 25% of paid up share capital plus free reserves. That's a total buyback permitted in the life of a company. In the next, in 1 year how much is allowed? 25% of total equity share capital, paid up equity share capital. Everyone understood the concept clearly? These are the two. Next, notice of general meeting, you have to clearly mention. Tell me, special resolution should be passed in which meeting? Very bad response here. Special resolution should be passed in which meeting? General meeting. Before you conduct, what you have to give? Answer. In that notice, what you have to mention? Explanatory statement. Which statement? General meetings chapter, there are two types of businesses. One, ordinary business. Number two, special business. Which business require explanatory statement? Special business require explanatory statement. In that explanatory statement, you should mention these material facts. Why you are going for buyback? Which securities? And equity shares, 2-3 types will be there in company. Which one you are going for buyback? And how much amount you are going, and within what time you are going to complete. Listening or not, everyone? Next. After buyback, debt equity ratio should not exceed 2:1. Next. Buyback is possible only for which shares? Fully paid up shares. Everyone understood the concept? So summarize the points up to here and complete. Tell me, sources of buyback. Without buyback concept completion, we won't leave. You have clarity now? Complete now. Point number 1. What are the sources of buyback? Fresh issue of shares. Very good. Next, who should authorize? First, who should propose? Board of Directors has to give the permission. Next, to go for shareholders by passing a special. When shareholders permission not required. If the amount of buyback is not exceeding 10% of paid up equity share capital plus free reserve. Total in the life of a company, buyback should not go beyond 25% of paid up share capital plus free reserve. In 1 year, buyback should not go beyond 25% of the equity share capital. Understood the point, everyone? Done. Next one. After that, debt equity ratio should not go beyond. Answer. Do you know what does it mean? That means the debt should not be more than twice the capital. Debt should not be more than twice the capital. Next. Buyback is possible only for fully paid up shares. Only important concepts let us discuss. Listen. Which resolution is required to go for a buyback? Amount is not exceeding 10% means? Ordinary resolution. Amount not exceeding 10%. Board resolution. Amount exceeding 10. If amount not exceeding 10, board. If amount exceeding 10, special. If amount is not exceeding 10, board resolution will be passed now. From that date, within 1 year, you have to complete the buyback. If special resolution is also required, from the special resolution date, within 1 year, you have to complete the buyback. Because first special resolution and next board, first board and next special. First board and next special. From the date 1 year. Also special resolution is not required means from the board resolution 1 year. What you have to do in this 1 year? You have to complete the entire buyback. Listening, everyone? No question. Sir, from whom we will buy? Buyback, okay. From whom will make a buyback? Number 1, existing shareholders or open market. Open market means what? Directly buy from the stock market. Randomly from the people you buy. That is an open market purchase. Or purchase from the employee. What you give to the employees? ESOP. Take back. Give them money. You can also do that way. Understood the point or not? Summarize. Tell me. 3 questions I will ask. Bonus shares, buyback is possible for fully paid or partly paid? Next one. I should complete the buyback process within 1 year from date of passing board resolution or special resolution as the case may be. More than 10%? Hey! More than 10%? From there 1 year. Less than 10%? Board resolution 1 year. Understood? Next. Tell me. Buyback from whom? Do you know what I mean existing shareholders? One-on-one. I will give you offer. Accepted. 1. Accepted. 1. Not accepted. Remove. Accepted. Like that from each and every offer letter will be given like rights. Offer letter given like whoever accepted from there I will make a buyback. Listening? Or like a normal shareholder will buy from the open market. Listening or not? Like that also you can do. Okay, next. Tell me, listen carefully. Suddenly, whenever company go for buyback, go for? What is reduced in the company on the asset side? Use this. Cash. On the liability side, equity capital will come down. Tell me, on the liability side, what will come down? On the asset side, what will come down? Both are simultaneously coming down or not? That means company liquidity will be reduced or not. Therefore, company has to give a declaration of solvency. Declaration of solvency means company will tell to SEBI that I am solvent, enough cash is there with me even after paying the buyback, no problem, I will not become insolvent at least within the next 1 year. Everyone understood the concept? If it is a physical share, you have to destroy the shares within how many days? 7 days. Within how many days? 7 days. Next. Gap between one buyback and another buyback must be at least 1 year. At least 1 year. Sir, we are going for buyback means we are issuing the shares, we are taking back the shares. Don't go for fresh issue within next 6 months. Don't go for fresh issue within next. So many concepts we are loaded now. One by one I will ask, answer. Maximum debt equity ratio after buyback. Fully paid, partly paid. Completion of buyback procedure within 1 year from what date? Date of passing board resolution or special resolution as the case may be. More than 10%. Less than 10%. Very good. Next one. Buyback from whom? Or from the open market or even from the employees. Very good. Next one. What declaration I have to give? Declaration of solvency. That I will not be insolvent within next 1 year. Next one. Within 7 days, what I have to do with the physical shares? Destroy them physically. Next one. What is the gap between two buybacks? Now I go for buyback. Can I go for further issue? Then why you went for buyback? That's the question. Therefore, how many months you are prohibited? But in that 6 months, you can go for a bonus issue because bonus issue, the money outflow is not there. The inflow is not there. Did you understand or not? Okay. Next. These are all the important points that you have to remember. This is all procedures only. They don't ask in exam. But very, very important connected section is there. Please listen to the 2 minutes and we will close. There is one section called as a capital redemption reserve account. Which account? If you remember original classes, we will spend around 2-3 hours to understand how CRR is created. But now that much time is not there. Just understand the procedure. Repeat. If the buyback is? Repeat. If the buyback is made out of free reserves or securities premium account, then an amount equal to nominal value of shares bought back shall be transferred to CRR account. Now repeat the answer. If buyback is made out of free reserves or securities premium account. What do you mean by that? It is not out of fresh issue. It is not out of. Continue. Then what we have to do? Then an amount equal to nominal value of shares bought back shall be transferred to an account called as CRR account. Transferred to an account called as? CRR account. How much we have to transfer? Nominal value of shares bought back. For what purpose CRR will be used? CRR can be used only to issue bonus shares. Only to issue the? Okay, logic everything. Let's not discuss and waste our time. Understood the point or not? This is said in section number 69. Connected section 70. Very, very easy section. Just listen. Sir, why company go for buyback? Can you explain me? If there is excess cash or less cash, first tell me. If you have excess cash, clear the defaults. There are a lot of statutory dues. Bank you didn't pay properly. Preference shareholders ki redemption not done. Debenture holders ki interest not paid. Employees ki PF not paid, gratuity not paid, bonus not paid. You are telling I am going for buyback out of free reserves. If you have that much reserve, first clear those defaults. And the answer is over. Nothing great. Prohibition on buyback means if a company is having a subsisting, means existing default in debts, default in statutory dues, default in preference, default in dividends, default in any interest payment, principal payment, etc. At that time, that company cannot go for buyback. With this, sections are completed with this area. Clear or not, everyone? Still, another 4 sections I have to discuss in this chapter, share capital. Okay, sir, very big, vast area which is taking 40 hours in a normal session. We have to complete in a 3 hours means we made maximum attempt to complete this very big chapter for 12 marks. So first, what our target is, main concepts we completed. Still there are 3 sections, not 4, sorry. There are still 3 sections. 1, differential rights. Number 2, variation in shareholders' right. Number 3 is reduction of share capital. Number 3 is these 3 are again most important 3 sections. Those also I will cover. What I will do is tomorrow's session target, let us put, first I will cover small chapters. Listening, first I will start with debentures. Next, deposits or charges. Next, I will go for deposits. First I will start with debentures, deposits, charges. Let's complete 3 chapters in a set. All important concepts I will cover. Once I complete, you will also get a peace of mind. Big chapter like share capital, again another 3 small chapters will be done. Yes, then I will go for accounts of company or any other law, or dividends I will start another small chapter. Which one? Dividend. So target for tomorrow will be 4 chapters. Last 35-40 minutes I will cover the remaining concepts of share capital. Yes, listening or not, everyone? Last 35-40 or 45 minutes we can spend and we can complete. So tomorrow, if you permit me, I will extend to whatever time you wanted. I will complete the syllabus and we will leave. Yes, clear? Yes, whatever the time may be, at 1 hour, 1.5 hours, even I don't know. Our efforts should not stop at any cost. So let us put the maximum efforts possible. Human being, what efforts we can put, let us put everything. Let's try to complete as much syllabus as possible. Yes, clear? So tomorrow's session target is how many chapters? 4. 3 small chapters, 1 medium chapter, let us complete. Okay, now, and definitely we can target and complete that because those are not a magical chapters. Those are easy, but out of those 4 chapters, 3 questions will come in examination for 12 to 14 marks in exam. Last attempt and a previous attempt, the charges came, deposits came, dividends came. You understand or not? Like that combination, any 3 chapters will come. So therefore, let us target properly. How many chapters? 4 small chapters let us complete. Targeting for 12 marks in exam. Is any 12 or 15 marks they may come in exam. So let's target on those chapters properly. Once after that, the share capital balance last 45 minutes we'll put in, we'll complete off. Clear, everyone in the class? So thank you very much. Meet you in the next class again. Thank you. So very good afternoon, everyone. So in the last session, we started with the chapter called as a share capital. Main substantial area of share capital chapter has been done. Now in the today's session, as I already promised, first let us complete all the small chapters. Okay. First we'll complete the dividends. Next we go to the concept called as a debentures. Next we will complete the chapter charges or deposits. Next we will come to the chapter charges. So this is a sequence in which we are going to move on in the today's session and complete. Clear? First we will complete all these things. And let us put a timer of a time for completing each of the topics. Once completed, we will go into the next topic immediately. Shall we? Okay. First, we are going to start first with the dividends chapter. Time allotted for dividends chapter is 45 minutes. Okay. Let us start with the concept. Whatever the book you are using for the dividends chapter, please open that. Okay. Shall we start with the concept? Okay. See there. See the screen. Declaration and payment of dividend. This is the name of the concept. Declaration and payment of dividend. Name of the concept is declaration and payment of dividend. Okay. Let us first understand one important point in this regard before we start with. Declaration and payment of dividend chapter, there are following sections. 123, declaration of dividend. 124, unpaid dividend. 125, investor education and protection fund. 126, dividends kept in abeyance. 127 will be punishment for failure to distribute the dividend. So see here first. First, weightage of this chapter will be 5 marks to 6 marks. Compulsory question will be there in the exam. 100% question will come in examination. So let us start with this discussion. Listen carefully. Again I am telling. Today's agenda, lot of concepts we are going to cover. Dividends. Next one, debentures, deposits, charges. We are going to put a target and trying to complete all the concepts. Listening. 4 chapters we will complete in this particular area. Listening or not everyone? So let us begin with the concepts. See there. Point number 1. Declaration of dividend. What are all the various concepts? Before going into that, let me give you a small intro to the chapter. Dividend is called as a distribution of profits. Dividend is called as a distribution of profits distributed to the shareholders. We call it as a dividend. Dividend is nothing but distribution of profits to the shareholders of a company. Point number 1. There are 2 types of dividend. Proposed dividend, final dividend. Everyone tell me. Proposed dividend, final dividend. When it comes to dividend, there are 2 types. Okay. Dividend can be of 2 types again. On the basis of the payment. On the basis of proposal, 2 types. Proposed dividend, final dividend, also called as a proposed dividend, approved dividend, or declared dividend. Or declared dividend. On the basis of declaration, there are 2 types again. One is interim dividend. Second one is a final dividend. First one, second one, final dividend. Let us come to the point. First one, dividend includes any interim dividend. What do you mean by that? Dividend includes interim dividend means all the provisions of law as applicable for the final dividend will equally apply also to the interim dividend. That's a point number 1. Okay. Next, sir, what is the difference between interim dividend and final dividend? Final dividend will be declared at the AGM. Everyone, final dividend will be declared. Interim dividend will be declared between 2 AGMs. Interim dividend will be declared. Today is the AGM. Today I declare dividend. What dividend it is? Final dividend. Listening? Example, today I declare dividend. Today is not the AGM. Today is the AGM. I declare dividend. What kind of dividend it is? Loudly. Today is, say example, June 5th. Example, today is not the AGM date, but I declare dividend. Which dividend it will be? Adi. But so many concepts are there inside this interim dividend that we will discuss in section number 123. Before going into that, let me revise one more time. Point number 1. Interim dividend is a dividend which is declared between 2 AGMs. Understood? Next. Who will recommend the dividend? Who will recommend the dividend? Who will declare the dividend? Who will declare the dividend? This is next point. Dividend is recommended by the board. Members will declare the dividend. Next one. Very, 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 very important. Regular. So let's continue. See here. Any dividend that is declared between 2 AGMs is called as what dividend? Interim dividend. Dividend declared at the AGM is called as what dividend? Final dividend. Next one. Who will propose the dividend? Who will declare the dividend? Who will declare the dividend? Shareholders. Where? In a general meeting. In which meeting? They will declare the dividend. Next, very important thing you need to understand. See here. There is a provision saying like this. Please read. Members may reduce the rate or amount recommended by the board, but they cannot increase it. Tell me, Board proposed 12% dividend. Board proposed 12% dividend. Can it be reduced to 10 by the shareholders? Yes. Can they propose, can they declare 12%? Board proposed. Can shareholders declare 10, 11, 12, 13? That's not possible. Means if the board proposed a rate can be reduced by the members, but rate cannot be exceeded by the members or increased by the members. This is another rule of law. Everyone understood? So summarize everything. Dividend on the basis of timing. There are two types. Number one, proposal. Number two, declaration. On the basis of declaration, again there are two types. Number one, interim dividend. Number two, final dividend. Dividend declared at the AGM is called as. Dividend declared between two AGMs is called as. Everyone understood the logic? That's it. Next. Interim dividend is declared by the board of directors. Interim dividend is declared by the board of directors. How and why? Everything we will discuss. Next one. What is the next one we are starting with? Section number 123. So first one, the basic concept everyone understood clearly. Yeah? Yes, sir. Very good. Next one. See here. Shall we? Yes, sir. We have to spend 20 minutes time on this section. 15 minutes time almost. Then only we can complete this, because this is a lengthy section and the most important section among all. Let us start. Sources of dividend. What is that? Means from where we can pay the dividend. From where we can pay the dividend. Dividend can be paid only out of, read, what is the first one? Profits. Paid out of? Profits. Cannot be paid out of capital. Dividend should be paid out of profit. I will ask a question. If I pay dividends out of the capital, what will happen? It becomes a buyback. Buyback should be as per section 123 as per section number 68. As per section number 68. Or else it will become reduction. It should happen under section 66. We will read today. Are you with me? Yes, dividend should be paid out of profits. Two types of profits you can use. First, current year profits. Second, past accumulated profits. Past those only we call as a free reserves. Loudly. Everyone. Don't use securities premium. Securities premium can be used to declare or issue bonus shares. But securities premium cannot be used to declare the dividend. You can never use securities premium to declare the dividend. Reasons are very clear. Let me explain. What is a securities premium? You don't know. What is the share premium? Yeah? You are issuing the shares at a discount of premium. You are getting 100 rupee share price. You issued at 200. What is the premium? 100. That 100 rupee premium is a P&L profit, a capital profit. Everyone? Profit. Dividend is a capital profit, a P&L profit. How come you can use that for this? Understood the logic or not? It's a capital profit. This is a revenue profit. Dividend should be paid out of revenue nature of profits, not out of the capital nature of profits. Everyone understood the concept clearly or not? Everyone in the class? Yes, tell me, dividends can be paid out of dash. Profit. Which profit? Current year profit, past accumulated profit. That past accumulated profits popularly we call as a free reserves. Everyone understood up to here? Next one. Sometimes government can give a guarantee. Sometimes government can give the guarantee for the payment of dividend. If government gives the guarantee, then that government money will be used to declare the dividend. That will be the source number 2. There are two sources. Number one, profit source. Number one, government source. Number one? Number one. Number two? Profits, again there are three parts. Number one, current year profits, past accumulated profits, or both. Sir, why government will give? Sir, I told you in regular classes very clearly, hundreds of times. Listen carefully. There are so many companies established in SEZ. Established in? SEZ, FTP. Like that, there are so many areas in India which are not developed areas. In that area, if you start a company, shareholders will not be ready to invest, because in that area, business is not happening properly. But if no one comes and start the business, how that particular state or place will grow? Did you understand the point or not? Therefore, government will recognize as a SEZ. Recognize as a Once it is recognized as a cess, what will happen? People will start putting their amounts into that. I will give one classic example. You can understand very well. Since I am from the city of Hyderabad, I can tell you one good example for you to understand. City of Hyderabad, outskirts, once upon a time, there used to be a place. Okay? That place name is Gachibowli. Very, very popular today. Once upon a time, what happened? Let me explain. I'm talking 22, 23 years back. Early 2000, 2001 time. It was a barren land in the city of Hyderabad. Barren land means you can imagine how much barren it is. One crop also, one leaf also you can't see there. That is the situation of that place. Which year? 2000, 2001 year. At that time the central government has started IT, revolution in India. 2000 is the game changing for the India's internet generation. Which year? 2000, millennium starting. 2000 is the year where IT revolution started in India at a higher level. Which revolution? IT revolution. Then government of India started doing a lot of research throughout India. When they started doing research throughout India, they found that the place where IT should grow should not have any kind of seashore affecting it, because natural calamities will easily affect the cities having seashore. Did you understand the point or not? There is a great advantage in the form of exports and imports of manufactured goods. That is okay. IT sector I am talking about. IT sector, do you know what is the most important? Power supply. It should not be interrupted by natural calamities. Do you understand or not? Natural calamities should not affect that city. A city should be selected for IT in such a way. Natural calamities should not affect that city. Clarity to the point. That's why even in USA, New York is not the city for software. California is the city for software. Are you understanding or not? It is 270 kilometers away from the seashore. Did you get my point or not? You may know that 6 months back only I came from that. So San Diego, San Francisco, San Jose, all these places, Cupertino in California, all these places are extremely popular for software. They are 300 kilometers away from the shores. Did you get my point or not? Why? People are not mad. A city to grow as an IT segment should have certain qualities. One of the most important quality is seashore should not be there, because it affects many things in the form of natural calamities. Number one. Number two, climatic situations. It should not be extremely hot. Do you understand? Do you know why? Servers. Yeah. Servers generate lot of heat. Place already it is moist and humidity is there. Those places won't grow as an IT sector. Are you understanding or not? That's why extreme cold temperatures they have to put. At least, if not extreme cold temperatures, at least the city should have a moderate temperatures. So this is reason number two. Reason number three, there should be cosmopolitan cities such that people from various places should come and live in that city. Ecosystem of the people, the climatic conditions, the culture, everything should promote that. Like that, government of India saw entire north. They found that north, none of the places are perfectly suitable for the development as an IT segment. Then they found two cities in south. One, Bangalore in Karnataka. Second one, Andhra Pradesh at that time in Hyderabad. They're the two places that were selected. After selecting these two cities, in the city of Hyderabad, since I was from there, I can tell you the example clearly, the place. There is one place called as a Gachibowli. Government of India, what they have done, do you know? They recognize that area as a cess. Area as a? Till today it is a cess. Till today it is a cess. How it became a cess? Cess means a special economic zone. Means what? You come and start software company in Gachibowli. Do you know what facilities government of India or state government at that time has given? They said land will be given at 10% of the cost. What cost? 10%. What do you mean by 10% of the cost? For example, if it is 100 crore, we will give you at 10 crore. Take the land. But start the venture and business in that place. Listening, huh? Today there are 4,780 software companies only in Gachibowli. See the magnitude of growth. People, whenever they see Gachibowli now, it is looking like a New York now. That's just because of one reason, the revolution of information technology that happened in that city, also in the city of Bangalore. Why? Both the cities suddenly boomed up in the last 20 years. That's just because of CES, not because of IT. Since CES was announced, you know, one of the biggest IT segment company in the world is Microsoft. Correct or not? You Google, what is the first headquarters of Microsoft after USA? It's in Hyderabad. They started their venture in Hyderabad for the first time because of that CES announcement. Do you know what they said? 100% land is free, but you start the company there. Like that only all these software companies came to the city. Did you get my point now? Like that the boom has come to the city like in such a way that it grown multiple times, 100 times, 1,000 times. Sudden growth happened. Now at 24 kilometers, one area itself in Hyderabad is called as financial district. That entire area is announced as a district itself. What will be there? Nothing will be there except computers. It's a total IT sector now. Did you get my point or not? Generating billions and billions of dollars of revenue to the state. The reason, very clear, it's just because of SS. Do you know what happened? Initially, when they started CES announcement in the city of Hyderabad, none of the persons came forward. Means people are not ready to invest. They thought that when it has to get developed, it will take 100 years to develop the city. Slowly it will get developed. At that time, some Indian companies also taken initiative and came. Classic examples, Wipro. Wipro started its unit in Hyderabad city at that time when that was announced. Listening, like that, so many small software companies, startups we call them popularly. Like at that time startups came. Means I am a software engineer. I have a very good skill of developing a software. You are all software colleagues. You are all my friends. What we can do, we will start one company now. But we don't have. Government will sponsor money for you. Listening or not? You start, we want people to develop the software. That IT sector has to grow. So you come, you start the company. Listening? Okay. All of you are shareholders. All of you are. Why you will put money when there is a company like TCS? Why you should invest in my XYZ Limited? You won't. Government will give you a guarantee. Do you know what guarantee government will give? Dear investors, invest in this newly startup company in CES. If you put your money in this company, dividend is guaranteed by the state of Andhra Pradesh. Means what? Whether company makes a profit, company makes a loss, every year 5 rupee per share we will pay you dividend. Now did you understand the point or not? Now tell me, dividend is paid out of profits of the company or government guarantees? If company makes profit, they will pay. If company makes a loss, government will pay. Did you understand? Like that, hundreds of software companies ki state government of Andhra Pradesh has paid dividends at that time. Did you understand or not? They paid dividends. Dividend to whom? Shareholders. Now shareholders will have a satisfaction. Okay, it's like a fixed revenue for them now. If I invest 5 lakh rupees at that time, 5 lakh rupees ki I will get a fixed revenue of 25,000 every year. Mean at least they will come forward to invest in the company. Clear or not? That's why this point came. Why I am explaining all these things is, learn in a proper way, you can remember for a longevity of a period. Tell me, out of what sources you can pay the dividend? Profit source, government source. Profit law how many again? Current year. Past accumulated. Next. Or combination of both. Very good. Money provided by state government or central government in persons of a guarantee given. Next one. Up to here everyone understood the point clearly? Everyone in the class? Yes, dividend should be paid out of? Dividend should be paid out of? While calculating the profit, depreciation shall be considered. Means that profit should be after deducting dash. Everyone? Number 1 over. Next, while calculating the profits, these things should not be included. One by one read. What is the first one? Unrealized gain, notional gain, revaluation gains, or fair value gains. What gains? Fair value gain. Easily remember 4 points. Number 1, unrealized gain, notional gain, revaluation gain, fair value gains. Tell me, what are the 4 gains? Loudly. Do you know what is unrealized gain? I will explain. Please listen carefully. Fatafat give the answer. Point number 1. Listening. Our company invested in shares of another company. Shares of 100 rupees I invested. It became 120 rupees. 100? Previous year balance sheet, how much is the value? 100. Now in the balance sheet, how much is the value? 120. How much gain I got? And really you got the gain, value increase. అది unrealized gain. Understood the point, everyone? Number 2, my company, listening, my company is having a factory. My company is having a, that building belongs to me, own building. Okay, another competitor is there, that, listening, that competitor company is leasing a factory. He has to pay what rental? Lease rental. I need not pay the lease rental. Then I said that what cost you have, the same cost I don't have, therefore I am having a notional gain of rent. Those gains you should not consider. Notional gain will not pay the dividend. Clear or not, everyone? Next one, number 3. Answer, sir. What is revaluation gain? Land and building will have same value, changes the value. Now today land and building value is 2 crore. Next year it became 2.5 crore as per the government value. I increased it by how much lakhs? 0.5. Really you will get 0.5 lakhs income? No. Those also you should not use. Same also with the fair value gains. So also with the, do you know what is a fair value gain? Guess the answer. Fair value gain we call NPV. What is NPV? The morning you heard FM class, afternoon you are forgetting. What is the concept? NPV, full form. Net present. Morning. Morning we considered FM class. NPV calculated. What is DISCI called as? Discounted cash inflow is there na? We can call it as what? Fair value. What is the market value? Example of 1 lakh is the market value. 1,27,340 or 240 or something is the fair value. Correct? Yes, what is the NPV? 27,340. That is a gain of fair value over and above the market value. That called as a fair value gains. What is this torture here? Everyone answer. Yes, what gain it is? Fair value gain. Now you answer. Fair value gain. I will give you an example. Morning session I discussed about this. Column number 1 what you are writing? Year. Column 2? Those are guaranteed cash flows, estimated. Then how can you take that gain? Yeah, that gain is not guaranteed gain. Are you understanding or not? Therefore, now tell me, what gain should not be included into the profits? Number 1. Notional gain. Fair value gain. These 4 gains should be considered, should not be. Because these are real profits, not the real profits. What is the moral of the story now? Only realized cash profits has to be considered. Loudly. Only unrealized will be coming, may be coming, estimated to come. Don't take that for the payment of dividends. We should not use it. Clear or not, everyone? Next one. Next one. Read. What is the next one? Past year losses and depreciation to be set off. Listen. This year I wanted to pay dividend. This year I wanted to pay. Tell me what I have to do. From where I have to pay? From where I have to pay? Profits after depreciation or before? After tax or before tax? Answer, sir. After tax I have to pay what? Depreciation. No words. You are beyond imagination. Pay depreciation? How can you pay depreciation? Start again. You are laughing. Tell me, everyone please, seriously follow here. You are breaking the flow. Tell me, from where you have to pay the depreciation? From where you have to pay the dividends? Answer. Profits. Profit after deducting and after deducting and after deducting unabsorbed depreciation and unabsorbed losses. Read. Losses of any previous year. This is called as a unabsorbed business loss. This is called as unabsorbed depreciation. Lot of concept we'll discuss in regular class. Don't ask questions. Conclusion you remember for the exam. Tell me, while calculating the profit, what should be deducted? Normally you will deduct depreciation, taxes, everything. You will get profit after tax, correct? Yes, from that deduct what? Unabsorbed business loss, unabsorbed depreciation. And then you have to, and still if there is a profit, then you have to pay the dividend out of it. Clear or not, everyone? Next. So depreciation means I can provide whatever depreciation I want. No. Companies Act depreciation ki one schedule is there. What is the schedule? Schedule 2. Follow that schedule and pay the depreciation. Next one. Transfer the amount to reserves. Tell me. What? First tell me. Company get the profits. What you have to deduct first? Just now I said. Depreciation. Tax. Sorry, forget about unabsorbed depreciation business loss. Depreciation you have to deduct. Interest costs, taxes, everything you will deduct. Finally what you got? Some amount of base profit will come. Correct or not? From that what you have to pay? Now question arises. Before paying dividend, is it mandatory to transfer the amount to reserves and then pay the dividend? It is optional. Who should decide? Board of Directors should decide whether to transfer the amount to reserves before you pay the dividend or not. Is at the complete discretion of whom? If they want, they can transfer to reserves. If they don't want, they need not transfer the amount to reserves. Are you all listening or not? Yes, sir. Next. Completed. Next one. Declaration of dividend out of reserves. 90%. Sorry. This question will come. Take it for granted. 2 questions I will tell from this section. 1 question generally can come now this time. Number 1, interim dividend. Number 2, this concept. That's why this concept I will discuss at the last to this section, not to this day. Okay. First, tell me, from where dividend can be paid? Which profit? Previous profit. First. Next. Next. Tell me now. Previous profits means I can pay out of what? Capital reserves? Capital. Tell what I ask. Don't tell beyond, don't tell lesser. Just tell what I ask. Can I use capital reserves? No. Can I use revaluation reserve? No. Fair value gain? No. Unrealized gain? No. Notional gain? No. Actual gain? Yes. No. Notional gain? No. Unrealized gain? No. Fair value gain? No. Gain on gain? Gain on gain. That concept is not there. My point is very clear now. Why I am asking is, listen, I am not asking for joke's sake, but my point is, when I say previous year profit can you pay? Previous year reserves can we pay? When I say reserve, it should not be revaluation of capital reserve. It should be free reserve. It should be free reserve. What is a free reserve? Can you explain in one line? Don't tell Mahabharatam for that now. I'm not interested to listen. What is a free reserve? Free reserve is a reserve which is available for freely to distribute the dividend. Freely to distribute the? Tell me, what is a free reserve? Reserve which is freely available. Reserve which is freely available for distribution of dividend. And that can be used directly for payment of dividend. That reserve we call as? So tell me, when I say past profit, any past profit, free reserve profit? That also said here. Read this. So book, if you read properly point by point, half minute if you spend half an hour, you can complete dividends chapter. Easy chapter, 5 marks are coming from this. Understood up to here clearly? Next point. Yesterday we discussed the bonus issue concept. Do you remember? Company is having a default in debts, deposits, etc. At the time, can it go for bonus issue? Cannot go now. Everyone? Go. Why? What is the reason? Buyback also we read the same. Prohibition for buyback. Why they cannot go? Sir, you are going for bonus issue because the funds are excess. You are going for buyback because funds are excess. When you have that much excess fund, what should you do? What you should do first? Pay the defaults which are already there. Same reason. Before you pay the dividends, see there. Read. No dividend shall be declared on equity shares if the company has not complied with section 73, section 74. Simply default in deposits. That's all. Okay. Next. Payment of dividend to whom? Dividend will be paid to whom? Dividend will be paid to you or me or to whom? Abba. Aha. Easy answer. Which shareholder? shareholder. If not to shareholder, to Narendra Modi will pay. Shareholder. See there. First one, registered shareholder. Or directly to the banker you can pay. Simple answer I will give you. See here. First one is registered shareholder. What do you mean by a registered shareholder? Let me explain. Unlisted companies, private companies, beneficial, registered, two concepts are not there. Which company? Unlisted, private companies, all these companies will be there. In the companies there is no such concept. Okay. So directly there is only one person called as a registered shareholder. Do you understand? But when the company is a listed company, your shares are not held by you. Your shares are held by depository. Yesterday only we discussed. Your shares are held by. So who will hold your shares? Who is the registered owner? Depository. You are which owner? Beneficial. Listen. I told you yesterday. Whenever company wanted to know who their members are, from whom it will take the details? Who am I? Company. Who are you? Depository. Who are they? Shareholders. I have to pay dividend to them. Now I will go to the depository. I will ask depository. Depository, please give the list of my answer. Shareholders. Or I will tell depository, if you give the details, if you give the details, I will pay directly to them. Actually, we should pay to whom? Actually, company should pay dividend to whom? Registered shareholder. Which shareholder? In the company register, depository name is there. In the depository register, shareholders' names are there. Tell me, company register, depository register. Therefore, company will be paying to whom? But depository will tell that don't pay to me. I will give the list of all your shareholders. I order you to pay to them. That's called as order of registered shareholder. Are you understanding or not, everyone? Or sometimes, listening? Or sometimes company can pay directly to the banker of the registered shareholder. Banker of the registered. Directly, not this, directly one bank account we will attach to that bank account, company will be continuously paying the amounts. These are the three things. First point, everyone understood the concept clearly up to here or not? Yes, tell me, dividend to whom? Registered shareholder, order of registered shareholder, banker of registered shareholder. Now tell me, how can I pay dividend? Instead of paying dividend of 1,50,000, can I give an iPad to all the shareholders? Answer. Because dividend cannot be paid in kind. Dividend should be paid only in cash. Sir, cash means physical cash is not the point. 100 rupee note is called as currency. Cash illa. Currency. It's called as currency. He said cash or currency. Cash. Cash means what? Cash in bank or cash in hand or cash at bank. Therefore, whenever I use the word cash, cash represents a check, warrant or any electronic mode. Electronic mode, you know na? Net banking. Next one. Phone pay na. A company on a friend, mama, transfer 1 lakh rupee to phone pay means company won't transfer. Phone pay. I didn't ask what you know. I asked what electronic payments will be used by corporates. I am asking. Phone pay, Google Pay, corporates will use. Tell me. RTGS, National Electronic Fund Transfer, NEFT, all these things will be used. Okay, na? So tell me, when I say use the word cash, cash means currency, cash through banking system. Tell the names. Check. Normally you tell check, warrant, electronic mode. Check. Done. We completed. Next one. Tell me. Company mandatorily should pay dividend every year, optional. Everyone? Can company issue bonus shares instead of declaring the dividend? Hey. Yes. I am telling yes, so you are telling no. So listen carefully. Listen. Regular class I used to tell one thing. A company may issue bonus shares instead of declaring dividend. A company cannot issue bonus shares instead of declared dividend. A company can issue bonus shares instead of declaring dividend. A company can issue bonus shares instead of declared dividend. No. Why yes, why no? You should understand the verb we used there. Are you understanding or not? One is a future tense, one is a past tense. Company cannot issue bonus shares. Company cannot issue bonus shares instead of declared dividend. What I said? Entire sentence you tell, yeah? Declare. Start. Arey, why I sounded like that means you will remember. Take a deep breath. Tell me now, what company cannot do? A company cannot issue bonus shares instead of declared dividend. Why? Dividend is already declared. You must pay only in cash. If you issue bonus shares, it will become kind. Allowed, not allowed? Next point, second one. A company, loudly, a company may issue bonus shares instead of declaring dividend. Now tell me, declaring means instead of declaring dividend at all, you can declare bonus shares on that basis. Tell me, what is permitted, what is not permitted, you tell me now. Can bonus shares be issued instead of declared dividend? No. Can a company issue bonus shares instead of declaring dividend? Yes. Permitted. That's what you want. Do you know what is a bonus shares issue? In this pocket, cash is there. Okay? Sir, pocket and not there, don't tell. Example, that's why. Sorry, in this pocket, yeah. Okay, na? Sir, tell me. In this pocket, I have money. In this pocket, empty. I will take 500 rupees I have. 500 rupee notes. In the 200 rupee notes I will take and I will keep in this pocket. Total money available will change or will be same? Answer. Will change or will be same? Will be same. It will not change. Ade bonus share. This pocket is reserves. This pocket is capital. This pocket. This pocket. From what I have taken money? Where I kept? That's why it's called as a capitalization of reserves. Read. I know your sound. What you are trying to do also I know. That's why I only did that. What it will be called? What is this? Reserves. Where I am putting this? That's why we call it as what? Capitalization of reserves. Read. It is permissible to capitalize the profits or reserves by issue of bonus shares or by making a bonus call, anything. Next. Read. Deposit of dividend in separate bank. Listen. Important point, MCQ important. See here, there are some time limits. Yesterday's time limits you tell me, not class time. Time limits for transfer, transmission, tell me. Whenever transfer, transmission happen, how many parties are involved? First party, second party, who will transfer share? To whom? What transfer you will pay? White paper, stamp paper. Form? Attach what to SH4? Submit all these things to? Who can submit? Within how many days? 30 days. To whom I should submit? What company will do? If it does not register within, it should give a. From that day, how many days I should make an appeal? Where to make appeal? If it does not give a reply at all, I can make an appeal within. From the date of. From the date of delivery of. Answer. Share, transfer, deed. To whom? Do you remember or not? See, this is the power of a revision properly if you do. You will remember till exam. At least till exam you will remember. After that you forget. No problem. No one cares whether you remember or not. You do revision properly, you will remember. Shall I show the magic of revision now? Don't see the answer. Fatafat give the answer one by one. Don't see. I'll ask question. First one. Sources of paying dividend. From where you can pay the dividend? Profit. Which profit? Past profit. Both are government money. Now tell me. Profit, past profit means which profit? Which gains should not be there? No, first one, unrealized gain, notional gain, fair value, revaluation gain, fair value gain. After providing for what? Whenever you pay the dividend, first we need to deduct. Normal depreciation anyway do. Previous year related, what you need to deduct? Unabsorbed business loss, unabsorbed depreciation. If at all a profit is still there, then you have to pay the dividend. Up to here clear? Next one. Dividend will be paid to whom? Order of registered shareholder, bank. Mode of making the payment. Cash includes what? Check, warrant, electronic form. Electronic form. Depreciation should be provided as per schedule. Very good. Next one. We have to deduct mandatorily what before paying the dividend? Depreciation. Next one. Transfer to reserve. Reserves transfer is optional, mandatory. Whose discretion? Next one. This we will discuss now at the last. Dividend will be paid only out of what reserves? When you cannot declare the dividend. If you have a default in what? Deposits, either principal or interest. Next. Payment of dividend to whom completed? Mode of payment also completed. Dividend payment is optional, mandatory. Instead of declaring dividend, what are the options available for you? Bonus shares is called as what? Capitalization of profits or reserves. Capitalization of profits or reserves. Next one. What is the next one? Ide concept, last concept. Everyone revision la pakka, everyone understood? What is the concept? Deposit of dividend in a separate bank account. So what is this concept? Let us understand. Whenever company declare dividend, within 5 days, the entire amount of dividend whatever declared should be transferred to a separate bank account in a scheduled bank. Start again. What we have done? What we have done? Declared what? Within how many days? What we have to do? What we have to do? Transfer. Transfer what? The dividend amount to what? Separate bank account in a scheduled bank. From there money we should be going to all the accounts. Are you listening, everyone? This is the point here. With this we have completed this particular section except transfer to reserves and interim dividend concept. That concept separately we will discuss at the end of these sections. Clear? Because it takes time. We have a lot of exam questions also on that. Listening? See, you will see the difference in your learning also once after completion. Which section we completed now? Section number 123. 124. Which section we completed? 123. Okay. Now, so please. You cooperate with me, we will complete fast. Next one. Come to section number 127. Come to section number 127. Hello, I didn't give any break to you. Open section 127. Listen. 2 to 3 minutes we will complete 127. Listen carefully. Listen please. Whenever dividend is declared, within how many days we need to transfer to a separate bank account in a scheduled bank? From there, 25 days. And from the first day, 30 days. From where 25? After 5 days, 25 days. And from the beginning? Within 30 days of declaration of dividend, amount should be paid to the respective shareholders. Dividend declared or not declared? Declared or not declared? From then within how many days? Entire amount should transfer to 5 days la amount transfer to bank account. From there it should go to shareholder. Simply to tell, dividend declared today but not paid. Dividend declared today but not paid. We didn't pay it. We just declared. The moment you declare, do you know what will happen? Guess what will happen? If I declare dividend, the very next moment, what accounting treatment you have to give? Babu, Chitti, have you seen cash flow statement? Yes, say. No, never you say. You are very nice kids. Tell me now. Balance sheet la liability side in cash flow statement, have you seen proposed dividend? Some people are not even saying yes, sir. Then now what I should interpret? How dare you ask me cash flow statement? Huh? So tell me, have you done cash flow statement in accounting standard? You are in group 1, you attended law, means you are in group 1 only. Except if you get exemption in accountancy. I'm asking you, have you done cash flow statement any time? Yes, cash flow statement la balance sheet will be given. Yes, liability side provision for tax, proposed dividend you will see. Yes, have you seen that word or not? Yes, you will see proposed dividend in liability side or asset side. That's what I am telling. Dividend becomes a liability once proposed and declared. Proposal a liability means declaration is obviously liability. Clear or not? Dividend once declared. Loudly. Dividend once declared. Will become debt due by company to the shareholder. Logic is what? Simply it is like a loan taken. Simply it is like a whose loan? Shareholders have given the money to them. Understood? Repeat one more time. Tell me, whenever dividend is declared, it becomes a debt due by company to the shareholder. Listening? Now tell me, debt dividend will be there, debt interest will be there. Debt will have interest, debt will have dividend. Answer. You take loan from bank, you will pay dividend to bank, you pay interest. So debt carry interest or dividend? That's why whenever dividend is not paid on time, directors are responsible to pay interest on that. That's the reason, because it's a debt. Dividend will get converted into debt. The moment 30 days is completed, what will happen? That amount of dividend will get converted into dash. Immediately on that, interest will start counted, because it's a debt due by you to the persons. So that much serious the issue will be. Did you get the point or not? And moreover, not just that. There is one section in Companies Act, section number 164, subsection number 2, clause number B. Do you know what that section says? Where a company has declared the dividend and it's not paid within a period of 1 year from the date on which it was declared dividend, any person who is or has been a director of the company on the date that was declared and 1 year has been completed, all the directors of the company shall be disqualified for a period of 5 years from the date on which the said company fails to do so. Section number 164, subsection number 2, clause number B, disqualifications of a director. Sorry, even though you don't understand anything, summary is non-payment of dividend on time will lead to disqualification of directors. Once disqualified, section number 167, subsection number 1, clause number A, the office of the director shall vacate. Means all the directors of the company, piche mode. Over, gone, go out of the company. That much serious it is. Don't take it as a joke. If you are defaulted in payment of dividend, no bonus issue, no buyback, no differential shares, no preference share issue. These many complications will come. So dividend payment means, no problem, just like that we will give the promise. Promise once made, you should honor it, or else don't make the promise. Are you understanding? With the shareholders at least, because they believed in you. Clear or not, everyone? They believed and they came to you. Don't make unnecessary promise. If you make promise, keep the promise. Honor the promise and do that. We didn't ask a dividend. You only came and said we are proposing dividend. We declared dividend. Later you said that Tucha, I am not paying. You have to pay me interest. Along with that, all these consequences will get attracted. Yesterday only you saw dividend declaration, a default is there. You can't go for bonus. You can't go for buyback. You can't go for preference issue. You can't go for differential shares. Directors are disqualified. Bonus la vacation. These, along with that, imprisonment for 2 years. Adi additional. Understood the point? How many years? 2 years imprisonment. Fine per day 1,000 minimum. Minimum. You hear my words properly. Minimum. How much? 1,000 per day for each director. 50 directors, daily 15,000. 100 days you delay, 100 days function. Are you understanding the point or not? These many complications are attracted to one concept in Companies Act. What is it? That's why dividend is one of the most celebrated concept everywhere. Law la dividend, AFM la dividend decision, income tax la deemed dividend. Where dividend is not a celebrated concept, dividend is one of the most celebrated concept in CA course. Do you understand or not? Why I am telling all these things is, don't take this chapter as very simple chapter. There are a lot of complications involved in that. So the point is, whenever dividend is declared, within how many days transfer to a bank account? Very good. If after transfer, within how many days? 25 days. And from the beginning date, how many days? 30 days. What you have to do? Pay to the respective bank accounts. Bank accounts of whom? Shareholders. At least dividend warrant you have to post. If this is not done, read. Imprisonment maximum 2 years. Fine. Minimum, not maximum. Minimum. How much? That can go up to 1 crore per day also, depending on the magnitude of company. Big listed companies with crores of capital. Recently, do you know one of the company what they have done? That company declared dividend. 45 shareholders' details are mismatched, they didn't pay. SEBI imposed a fine of totally 640 crores penalty. Sir, penalty they give to me, sir. Remaining amount, let them give with them. That's the magnitude of penalty, 640 crores. You can imagine how much loss the company might have incurred. Do you understand the point or not? Like that, there are companies like Alchem Laboratories, etc. 60 crores, 70 crores penalties they paid just because of failure to pay dividend. Dividend payment is very easy. Don't declare, that's why. Don't propose. After that, you will feel bad after proposal if they reject it. Come. Oh, Anna, namaste. I am talking about dividend. In this hard moment of exams also you are thinking, means that heart should live for 100 years. I am talking about shareholders here. You are also talking about shareholders only. Oh, nice. Sir, tell me, who will propose? Sir, change the topic. You are unfit to answer this question. So tell me, if you declare, listen, you declared, but paid or not paid in this case? Not paid. Within 30 days from what date? Transfer to account, declaration. Maximum punishment will be how many years of imprisonment? Fine or no fine? Fine. How much minimum? 1,000 per for each officer on default. Okay? Next. Punishment along with the, sir, moreover, this is a punishment for directors because company can't be imprisoned. Listening? Company can't be imprisoned. Along with that, for the good the company has done, it has to pay 18% interest per annum. You can imagine 18% interest. Bank also don't give. Not bank, share market also don't give sometimes. But that's why always you pray the God, my company should declare dividend, but it should not pay. Then you will get 2 types of benefit. Benefit number 1, dividend at some time you will get. Benefit number 2, interest also you will get. So this is how we can think in a positive way whenever dividend is not declared. But 18% interest, that's why amounts will go to 65 crores, 600 crores, 500 crores, like that. Why they will go? Along with interest, it will multiply every day. Listening or not? Next. After that, exceptions. Very, very important exception. Please listen carefully. In the 5 cases you are seeing on the screen, though dividend is not paid within 30 days, punishment will not be levied. Though punishment will be there or not there? Not there. Though dividend is not paid. That means you paid dividend or not paid dividend? Even then there is no punishment in these cases. Why? genuine cases of default. What are those? Let's see. See the screen. Number one, dividend could not be paid by reason of operation of law. Dividend could not be paid by reason of operation of law. I will give one example. Yesterday only we read no operation of law. Transmission, you read na? A is the shareholder. A is the shareholder. B is the son. September, 1 second, please listen. Company declared dividend today. Company declared dividend today. Maybe 1-2 days before A died. 1-2 days before A died. A expired. 2 days or 3 days before the declaration of dividend. Already that family is in extreme sorrow and grief. They didn't inform company. Sir, when a person dies, first we will inform company. No one will inform like that. We will inform other persons when a person dies. TCS? Mr. A died, do you know? Like that no one will tell. Do you understand or not? Obviously, why we will inform you? We will inform companies at the last when the settlement of assets and something come. Then we will see his wealth is belonging to which company. Then we will inform. The moment a person dies, immediately they will call all the companies in which he is a shareholder. No. A died. 1 minute, yeah. A died 2 days before declaration of dividend. Okay. B didn't inform the company. When you die, automatically they will inform whenever the person die. 2-3 days after 2 days, the bank managers and all these persons, if they come or some way, bank come to know that this person has died. Listening or not, everyone? Bank has noted that this person has died. Bank operations has to be suspended immediately. Did you understand the point? Bank operations are suspended. Bank account is under suspension. 1 week after, company declared dividend. Company declared dividend. It tried to pay the dividend to the bank account of this person. This is bank account. Company transferred dividend. It is going to bank account, but it is not going inside the bank. It is coming back again. Why they came to know that the bank account is inoperative? Because of death of this person. Listening? But I cannot transfer to B because B is not the registered shareholder in the records of the company because the transmission he didn't apply yet. Yesterday only we discussed. He didn't apply. Now tell me, to whom I should pay? To A I can't pay because he died. Bank account inoperative. To B I can't pay because not yet transmitted. Then to whom I should pay? In that case, even after within 30 days, if you don't pay, there is no default because it is by operation of law. That's the first case. Listening or not? Next. Read the second one. Where the shareholder has given directions to the company regarding payment of dividend. Stop. Who gave instruction? Gave instruction for the payment of? To a particular? To a particular company. Read again. Where a shareholder has given directions to the company regarding payment of dividend. Who gave instruction? Gave instruction to whom? To pay to whom? A particular person. A particular? And continue. But those directions cannot be complied with. By whom? Can comply, cannot comply. And the same has been communicated to the shareholder. Listening? That means, see here. I am a shareholder. I said, pay dividend to Mr. What's your name? Kanna. Fate. So tell me, I transferred to Kanna Bujji Babu. Okay. To this person I transferred. I said to the company, transfer to Mr. Kanna. Okay. So now listen carefully. This fellow became insolvent. When he is insolvent, his bank accounts will be operative or suspended. Now listen carefully. I am the shareholder. I said to company, don't pay to me Kanna, pay to Kanna. I said to whom? Company. Company tried to make to Kanna. Kanna account, what happened? Suspended. Now tell me, company can comply with my instructions or cannot comply? Now there is a mistake of company or no mistake? Mistake if you don't inform me that you can't pay. That's why, read the last point. The same has been communicated to the shareholder. If you don't communicate, it's a mistake of company again. Listening everyone? So tell me, what are the 2 reasons under which default will not be there? Operation of law. Shareholder has given the direction. Directions cannot be complied with. And it is communicated back to the Shareholder. In these two cases, punishment or no punishment? Third one, please read. Third one. Where the dividend is lawfully adjusted by company against the sum due to it from the shareholder. Simply to tell. Please listen. Do you know allotment, first call, second call, final call? Do you know, have you heard about a word called as a calls in arrears? Yes, calls in arrears? Yes, what is a call in arrear? What do you mean by calls in arrears? Call made by the company but paid or not yet paid? Such case is called as? Such case is called as calls in arrears. Now listen carefully. Calls in arrears is a situation where call is made by the board of directors but not paid. 5 rupee call is made. I am a shareholder, I didn't pay. At that time, company declared 5 rupee dividend. How much? Instead of paying me dividend, what company can do? This 5 rupees, it can adjust to the call money and it can close the call. That is a C. Are you listening or not? Next, what is a D? Where there is a dispute regarding the right to receive dividend. This you remember, I will discuss in the next section. Okay? Simply remember, dispute in right to receive dividend. Dispute in? Bad response. Dispute in? Again, dispute in? Last one, any other reason not due to the fault of company. Any other reason not due to the fault of company. In all these 5 cases, punishment or no punishment? Tell me all the 5 reasons. Before that, tell me, whenever you declare a dividend, it becomes what? Dead. Due by? To whom? You have to pay within? From the date of? Very good. If you don't pay, imprisonment? Fine? Minimum or maximum? How much? 1,000 per? On whom? On each officer in default. Company will be liable for interest for amount of 18% per annum. Next one, very important. Second one, in what cases punishment will not get attracted? How many cases are there? What are the 5 cases? Don't see. Number 1. Second one, shareholder has given directions but it cannot be complied with and the same has been communicated to the shareholder. 2 reasons. Number 3, adjustment of calls to the dues. Adjustment of calls to the dues. Next, number 4, there is a dispute to right to receive dividend. There is a dispute in right to receive dividend. Number 5, any other reason not due to the fault of company. Everyone understood? Now do one thing. 123, except what I didn't discuss, leave those. Remaining concepts of 123, 127. Just in 2 minutes you revise. We go to next section called as section number 126. So students over the Zoom live, everyone understanding the concept? Students over the Zoom live. So today at any cost, we may stay for extra 1 hour or 45 minutes, I don't know. We have to complete all the targeted 4 chapters. So that's for your benefit only, sir. I am there from the morning, I have to shout. It will be satisfactory also for me. If I complete most of the syllabus, then I will also be happy. That is, the sessions will be useful for you. Are you understanding? Let us target and complete all the 4. Don't put the pending for this. Because in the YouTube also I didn't make videos on this. FEMA, full session I kept. Even if not covered, no problem. But these are also not there. It becomes a problem for you. Did you understand what I said? Repeatedly what is already there, if I repeatedly concerned about that, again your time waste. If I cover new concepts, it will be useful for you. Did you understand why I am covering charges, deposits? It's for you only, because I didn't keep that. Clear? So therefore, if I have a new topic covered, it will be useful also for you. What is already there, even if the time is not permitted, you can visit there and you can listen. FEMA, full session I kept 6 and 7 hours. That's why I said 6 or 7, exactly now you will tell. 6 hours, 18 minutes, 21 seconds. What is the penalty? That we don't remember. So, 6 or 7 or in between some amount is there. Full topic is there. Even if I didn't cover, you can listen there, no problem. But deposits, debentures, charges, all those things are not there. Clear? So let me cover those first, such that you will be in a safe position. Listening? Read. What are the two sections I asked you to read? 123 and 127. Read first. Exam questions are there, that's why I'm asking you to read. We will do some exam stuff such that you will get a clarity and confidence. Those who completed reading 127, see this exam question also. Once you complete, one 123 completed, read 127. 127 also you read. Shall we do one question? Will you try? See the screen. Read. ASR Limited declared the dividend at its annual general meeting held on 31/12/2020. Dividend warrant to Mr. A shareholder, was posted on 22nd of January. Due to postal delay, Mr. A received the warrant on 5th February and encashed. Can Mr. A initiate action against the company for the failure to distribute the dividend? Yes or no? Postal delay will come under exceptions or will not come? Postal delay will come or will not come under the exceptions. Postal, if they delay, what is my mistake here? Company declared the dividend warrant is posted to you or not? Whose delay? What should I do? I declared, I posted to you 2 days immediately after 20. See there, when dividend was declared? 31st December. Posted on which date? 22nd. Within 30 days or beyond 30 days? I posted within 30 days or not? Who made the delay? That is also my mistake. Then that's what he wanted to tell. This comes under exception 1. Operation of law? No. Instructions which cannot be complied with? No. Subsequently adjusting the amounts of this particular dividend to the calls? No. Dispute and right to receive dividend? It comes under which category? Any other reason not due to the fault of company. Like that they will ask question. See here how to present the answer. Read. This is how you need to present your answer. Read. The last date for payment of dividend was 30th January 2021. That is 30 days from the date of declaration of dividend. ASR Limited has posted dividend warrant on 22nd. Dividend warrant was received on 5th February. ASR Limited has not made any default since it has posted the dividend warrant within 30 days of declaration. Continue. Since it is immaterial that dividend warrant was received by shareholder on 5th February. Since Mr. A cannot initiate any action against ASR Limited, since ASR Limited has not made any contravention of section 127 or any other provision of the act. Everyone understood the logic clearly? Everyone in the class? Which section we completed now? Section number 127. Are you all satisfied up to here clearly? Next one, come to section number 126. Dividends held in abeyance. See here. Small introduction before we go into dividends kept in abeyance. You already know about this. Nothing great. Easy concept. Transfer transmission. I want full class. Everyone in the Zoom live also please participate. Everyone answer. Just a minute. All the students in the Zoom live, put me a message. Have you all understood up to here? Shall we continue? See here now. Tell me the transfer transmission procedure. How many parties will be there? Tell me, who is the first fellow? Transfer to? What he will transfer? In return, this fellow will give you? What he will give? Consideration. What is completed? Transaction completed. What is not yet done? Registration not yet done. Now, either transferor or transferee will send SH4 called as a share transfer deed, also called as a instrument of transfer. All these we read in the last class here clearly. Instrument of transfer. We will transfer to whom? Company. What company will do? Registration company has to do. Correct? Now the real story started. Please see the screen. Company registered this. Let us say, for example, this all happened. Wait, from here I will take. See the screen. Company is there. They submitted to the company within a period of how many days? 60. Let us say 60th day only they sent to the company. That means on dot they sent to the company and it reached the company also. 60 days before the 60 days from the date of execution of the share transfer deed. Do you remember? Na? It should be stamped and executed. Executed means what? Signed by whom and whom? Transferor and transferee should sign on the share transfer deed. Both of them signed, they sent to the company within 60 days. 60th day it reached the company. On time it went. Now what company shall start? What company shall start? Now listen. Two situations let us take. Situation 1. Company completed the procedure of registration. This is D0. This is D0 means it went to the company and reached the company today. From today, within how many days? 20 days. How many days? What is done? Registration is done. This is which situation? Situation, everyone, situation 1. Let us take another situation. Day 70. Day 70. This is situation number 2. Understand the full story properly. Start from the beginning. Who are the two parties? Who transferred the shares? Transferor. To whom? What date? On a particular date they transfer that. Okay. Who paid the money? To whom? Then they executed what? Executed what? Transfer deed. Also called as what? Instrument of transfer. Form number. Send it to the within. Then it reached the. From there our story started. That is all the story of this share transfer. Now the real story started now. So now D0, the date on which company received, within how many days it completed the registration? Next one? 70 days. Clear? This is a situation. Now see the scenario. Shall we continue? Listen. Company declared the dividend. Everyone repeat. Company D1, D2. Let us take two situations of dividend. Company declared a dividend on D10. Company declared a dividend on D20. So D20 is here, na? D25. D25. Look at the chart properly. From here, very much a complicated concept will start. Examiner, they can ask the same diagram in the form of dates and analysis. At that time, fuck if you don't listen properly. Listen carefully, start from the beginning. Beginning means start from D0, not from the first one. Tell me, D0, what happened? Company received your? Next, company within how many days it declared dividend? Answer. D1, how many days? 10 days it declared the dividend. Registration is completed or not yet? It completed on which date? D? Once registration is completed, who will become the owner, registered owner? Loudly. To them they will pay the dividend. Answer is over, everything is correct. Are you listening? Yes, now come to situation 2. That means forget about situation 1. Listening? Yes, tell me, what is a D0? Date on which company received your instrument of transfer. Okay, na? D1 forget. D1 situation 1 forget. Those two are not there now. Directly, company registered your shares on which date? D70. Everyone, D70. On the day what happened? Registration done. Who done registration? On which date? On which date? Now tell me. D25. D25. And from here, 25th day, what company has done? Declared what? Declared what? Now you answer my question. On the date on which D25 and the company declared the dividend, registration is done, pending? Loudly? Pending. Now tell me, to whom I should pay the dividend now? Transferor or transferee? Loudly? Then transferee will cry saying that I paid money, he is again taking the dividend also. Who took money? Loudly. Who took money? Who is taking dividend? Enna pakshapatam? And he will only take the consideration, he will only take the dividend. So pay to. Then transferor will cry, I am the owner. As per the rule of law, as per section number 123, subsection number 5, you only said the dividend should be paid to the registered shareholder. I am the registered shareholder. How can you pay to him? Who is correct? Both are correct. Both are correct. See the screen again. D0 what happened? D0 what happened? Asal first tell me situation 1 everyone understood? I am erasing situation 1. Unnecessary confusion will come. This is all done. Tell me now. Company, when you sent the form, company refused to register. It registered after 70 days. After you make an appeal to NCLT. Do you remember? 30 days you should make. Do you remember or not? Like that it went for appeal. After refusal, so many days after, then 70 days after company registered your shares. Okay, na? Now answer. Exactly on what date dividend is declared? Loudly. By that time, registration is completed, pending. Who is the owner? Records law owner is transferor. Technically, who is the owner? No. Who is having a real right? Both are having a right. Transferee will tell that I paid money to you already, therefore I am the owner. Transferor will tell that records law I am the owner. Whose argument is right? Both arguments are right. Both are under a dispute now. Who are under dispute? Both whom? Transferor and transferee. Transferor will tell that pay to me. Transferee will tell that pay to me. Listening? Transferor will tell that I have the right on shares. Transferee will tell that I paid money, I have the right on shares. Who is right, who is wrong? Both are right. Therefore, what is going on between them? Answer. This dispute will be resolved only if the registration is completed. Only if the registration is completed. Now tell me, when this dividend is declared? D? When registration is completed? Between this, what is the gap? 25, 75. How many days gap is there? Now tell me, dividend is declared within 30 days. It is paid or not paid? Paid or not paid? This is not paid because there is a dispute in right to receive the dividend. That's the fourth point you read in the previous section. Did you now understand the point or not? 127 law, you have read the exceptions or not? In that one of the exception is what? If there is a dispute in the right to receive, they are disputed. So in this case, section number 127 will get attracted or will not get attracted? Will not get attracted. Asal first, did you understand the point clearly or not? Okay, I am erasing the things. Please see here. See here everyone. Not yet completed. Tell me now. When company received your IoT? When dividend is declared? When dividend is declared? When it was actually registered? D? Very good. Now tell me. Now first tell about 127. Gap between declaration and payment is 30 or more than 30? Gap between declaration and payment is 30 or more than 30? But there is a punishment or no punishment? Because it is attracting a exception. What is that exception? Dispute in right to receive the dividend. That is according to 127. Now come to 126 section. Tell me. Dividend is declared. It will be paid to the transferor, transferee, none of them. Two situations will arise. Listen carefully. There are two situations here. Situation 1, situation 2. Please see here. Who is this? Gave a to the to transfer. Continue. Tell me. What happened? Who gave intimation? Oral or written? Who made? What he made? To whom? To do what? Transfer what? To whom? Then what is the problem for you? I am only telling you to transfer it. Who am I? Original holder. Who am I? Original holder. I am only telling that pay to whom? Then why unnecessarily company should create a dispute? I am only telling transfer to him. Clear or not? In this case, dividends can be stopped or should be transferred? Next case. Next case. No intimation. In this case, who is the real owner? Transferor or transferee? Both are having a dispute now. In this case, dividend will be transferred to unpaid dividend account. Unpaid dividend account. Everyone, unpaid. Now, tell me, how beautifully you understood, I should know now. Tell me one by one. When you transferred the share certificate, share transfer deed, loudly, company declared, number you forget, company declared, registration is completed, not yet. Can I transfer to transferor? Can I transfer to transferee? You can transfer to transferee only in one case. What is that one case? Who should give intimation? Should give. To whom? To do what? Transfer what? To whom? Then dividend should be transferred to the transferee, even though what is not completed? Registration is not completed. Sir, if registration is not completed, how can company transfer, sir? Order of registered shareholder. Order of. When I say that pay to him, what is your problem? Pay to him. Understood the point? Now let me explain the next point. Please listen. Just we are away from one single point here. Tell me. D25 in our example, what is declared? Answer. Therefore, you are transferring it to unpaid dividend account. If suppose, if dividend is not declared, but bonus shares are declared on that day, then you can't transfer to unpaid dividend account. At that time, that bonus shares will be kept in abeyance. Company will appoint a trustee, that a trustee will hold all the shares till registration is completed. If registration is done, I will release to the Demat account of the transferee. Listening or not, everyone? And the dividends, bonus shares will be given and allotted to the person. It will be kept on hold till the completion of what? That's called as a bonus shares kept in abeyance. This is all the concept of section number 126. Now you read picture wise, you will get all the concepts in the text. Read now. Applicability. Read from the screen here. Don't read any other book. Read this first. Start. Section 126 applies where a transfer deed is delivered to the company for registration. Remember the diagram. Registered or not registered? In the meanwhile, what happened? Dividend is declared or bonus issue or rights issue is made. Continue. Dividend in relation to such shares shall be transferred to unpaid dividend account. However, Dividend shall not be transferred to unpaid dividend account, but shall be paid to the transferee when, if the registered shareholder has authorized the company to pay dividend to the transferee. Next, this is applicable only for dividend, also for bonus shares. Read. Any offer of rights or bonus shares made by the company shall remain pending. That's called as a dividends kept in abeyance. That's all. This is the main concept. We completed section number 126 also. So the main concept have been completed. Tell me what are the sections we completed. Everyone loudly. 123, 127, 126. Okay. Next one. Please. IEPF, I will do one thing. I will tell you what will be there in IEPF. Later at home you just read and leave, because 10 attempts or 1 attempt they will ask IEPF. That too they may ask only in MCQ type. Which one? Sir, what will be there in IEPF? What are credits to IEPF? What are debits to IEPF? Sir, listen. IEPF, full form. Investor Education and, loudly, Investor Education and, this is an account maintained by SEBI. Account maintained by SEBI. Debits means expenditure to the fund. Credits means income to the fund. Government grants, bounties, all these things will go to the credit to the IEPF. All kinds of spending on awareness of investors, payment of any salaries to the SEBI, etc. All these will come under the category of debits. Just debits and credits you need to read and remember what will come on to the debit side of IEPF, what will be coming to the credit side of IEPF. Just tell me one point. All expenses to the IEPF will come under debit. All incomes given by the government or income generated by IEPF will come under credit. Later you just put some mind and read and remember the content. I am going to section number 124. Another very important section, expected question for the next coming exam, unpaid dividend account. Mark it important. May 20, September 24 exam, chances are there. Because that question was asked long back. Mark unpaid dividend account as important for the coming exam. Okay, shall I continue? Okay. Wherever you wanted to draw this diagram, you can draw. But I wanted to explain the full-fledged concept of unpaid dividend account in just 2 to 3 minutes. See the screen. I don't want any disturbance. I don't want any interference. Both, please, for your sake only, see the screen. Don't write anything now. Let me explain full-fledged all the concepts. See there. You know the date clearly. When I ask you, tell me. Tell me now. Whenever dividend is declared, I call it as a D0. From this date, within how many days I should transfer to scheduled bank account? D5. This is a time. Next. Within how many days I should transfer to the, I should pay the dividend? Pay dividend within 30 days. Up to here understood? Next. From here 30 days I have to declare. If you could not declare any dividend within 30 days, within the next 7 days, within the next gaps, I will put the numbers. How many days? How many days? How many days? 7 days. What I should do within these 7 days? In this 7 days time, what I have to do in this 7 days time? This is a time for transfer to the unpaid dividend account. Unpaid. Okay. Now, from this 30th day, D127, and a gap is how many days? 90 days. Within 90 days, prepare statement. Answer, yeah, prepare statement of unpaid dividend account with all the details. Unpaid dividend account with all the details. And you have to file it with the SEBI. File it with the SEBI. What we have to submit? Sir, unpaid dividend of whom? Of Koushik Mukhesh, of some other person, of Mr. A na, Mr. B na. How much amount, how many shares are there? All the details you should prepare one statement and send to the SEBI. That is should be submitted within how many days? Start from the beginning now. Tell me, whenever dividend is declared, within how many days you should transfer to the separate bank account? Within how many days you should pay? 30 days from the date of declaration. If it is not paid because of any reason, you have to transfer to which account? Within how many days? Once you transfer, within how many days you need to prepare a statement? What you have to prepare? Containing the details of unpaid dividend account, full details, name of the person, how much amount is pending to him, where you transferred, full details you have to maintain. Reason why it is not paid, everything you have to tell there. Listening everyone? Very good. So you have to prepare a statement and submit. Okay? Now starts the real story. From here. For a period of how many years? 7 years. It will stay in which account? Unpaid dividend account. On expiry of how many years? 7 years. All the amount will be transferred to IEPF account. Which account? IEPF account. That's all. Section number 124 is completed. This is what 124 section wanted to convey. Tell me one by one, step by step. Tell me, once the dividend is declared, you have to transfer to a separate bank account within how many days? From the beginning, within how many days you need to pay? If not paid, you should transfer the amount to which account? Within how many days? Next one. Whenever you prepare, whenever you transfer to unpaid dividend account, within how many days I need to prepare a statement? Prepare a statement and file it with the central government or SEBI, as the case may be. Okay. Next, after that, there in unpaid dividend account, it will stay from today to how many years? In this 7 years period, anyone who is the owner can claim this dividend and he can take. 7 years of time is completed. The holder of the shares will lose the right to receive the dividend. Did you get my point or not? Within 7 years, I will wait. After 7 years, I will transfer this entire amount to which account? IEPF account. IEPF account, just now I said, credits law, what will be there? This is the income for the IEPF. All the unclaimed dividends after a period of how many years? 7 years will be automatically transferred to IEPF credit side. Did you understand the point or not, everyone? This is the point I wanted to convey. Everyone understood 124 section clearly or not? Okay, but small 2-3 new points are there. Those points, if you understand, UPD account concept is over. I will ask you to read certain points. Read and confirm whether we completed that or not. Just one thing, one important thing. Shall we? Which account you should transfer all these? If you don't transfer to unpaid dividend account, how much amount? 12% per annum, simple interest you have to pay. Okay? That point only I didn't discuss. Read all the points you are seeing on the screen. Take a minute time, complete it fast. So those all in the Zoom live also, did you understand the concept clearly? Sir, fast. If you read, tell me, I will continue. Completed? Next. Payment of unpaid dividend. Sir, when the amount is in unpaid dividend account, when the amount is in unpaid dividend account, can the original owner can claim the dividend during the time period or not? Yes. Next. After that, I will transfer after 7 years. To which fund I will transfer? Money transfer to unpaid dividend account of the company which remains unpaid for how many years? 7 years from the date of transfer shall be transferred to the IEPF account. Okay. Next. All the details will be maintained by SEBI. Next. These are the 2 points that we need to remember. Listen. IEPF account ki what will be transferred? Unpaid. Not only unpaid dividend, shares with respect to unpaid dividend. Everyone, shares unpaid dividend will also be transferred in the name of IEPF. IEPF ki they don't transfer in the name of IEPF. Government only will hand over all the shares. Means government will take them as a treasury shares. Government will sell the shares. Money comes and they will use for the benefit of the government of India. Listening or not, everyone? I repeat one more time. UPD account la your dividend will be blocked for 7 years. After where you have to transfer? IEPF ki credit ki what will go? Answer. Unpaid dividend will go. Unpaid dividend is relating to a share, na? That share is also not claimed by anyone. Those shares are not transferred to IEPF account. They are transferred in the name of IEPF account. Who will hand over those shares? Government can hand over. Listening everyone? Government will hand over those shares. Government can sell the shares and get the money. Listening? So the main points end with this particular point from the exam's point of view. So see the screen and tell me, dividend declared within how many days we need to transfer to a separate bank account? Fatapat, give the answer. From there, within how many days? From the beginning, 30 days. What I should do? If I could not pay by any genuine reason, I have to transfer it to? Within how many days? Prepare the statement within. If I don't transfer, what is the interest I have to pay? Answer, 12% per annum. Next one. Once you transfer to UPD account, you have to prepare a statement and submit to the government within how many days? Very bad. Within how many days? Next. From the date of transfer, how many days it will stay in unpaid dividend account? After 7 years also, no one claimed the amount of unpaid dividend. Then it will be transferred to the IEPF creditor, debitor. To the credit of IEPF, we will transfer dividends or shares in respect of dividend. Shares in respect of dividend will not be transferred to IEPF. Will be transferred in the name of IEPF held by the government. Held by the technically SEBI. Whenever SEBI needed, they will sell the shares and get the money. Did you understand the point or not? This is the main concept that we need to read in section number 124. With this, 124 section is also completed. Sir, what is the only section that is left for us in this chapter? 123, 124, 125, 126, 127 sections are completed or not? But 123 section, we didn't cover 2 things. Number 1, payment of dividend in case of losses. Payment of dividend in case of losses or inadequate profit. And the next one is interim dividend concept. Which concept? Let us start with that. Please see here. Main concepts of this particular topic has been completed. Please see this area. Please, please. No noise, please. Whenever we talk about payment of, sir, I am listening, noise, please. Listen, I will complete it very fast. Just give me 5 minutes. See here. Whenever I say dividend paid in case of inadequate profits or no profits, there are 4 conditions. There are how many conditions? Remember these 4 conditions. Example, they will test. Whenever company is having a loss, it will pay dividend out of what? Whenever company has a loss, it will pay dividend out of profits or losses. From losses it can pay, na? No. Therefore, from where I have to pay? From reserves I have to pay. From what? Reserves. So, this is called as what? Which profit? Accumulated. This full box is accumulated profit. Okay, na? Now listen. This full box is having what? Accumulated profit. Imagination is main. See there. Yad bhavam tad bhavati. How you think is how you see. Okay? Imagine. That's all. There is no chance because I can't bring accumulated profits and show you. See there. Ade accumulated profit. That full box is containing accumulated profit. My company is making a profit or loss. Or if it makes a profit, it is making adequate profit or inadequate profit. Profit is there. 1 rupee 25 paisa. How much? What you will do with that? Chocolate. Nice. So now the point is, at least you agreed the dividend can't be paid. You buy chocolate or biscuit, I don't know. According to your need, you do with that 1 rupee whatever you want. But what you cannot do? That means profit is there or not there? Hey, there. Profit is there. But what kind of profit is there? Inadequate profits are there. In that case, can you declare dividend or cannot declare dividend? Cannot declare dividend out of the profits. Means you can declare dividend out of losses. Out of what? Accumulated profit. Accumulated profit means which reserve? Can I use unrealized gain? Notional gain? Fair value gain? Revaluation gain? Free reserves? Capital reserve? Revaluation reserve? General reserve? Dividend equalization reserve? Yes sir, you don't know na. Dividend equalization name lone clear. Dividend equalization reserve. Dividend? AFM la yesterday I told you one concept called as a linters model. Do you remember? What is the idea behind the linters model? Every company should not pay whatever the earnings they come as a dividend. You have to maintain some reserve such that equivalency should be there in payment of dividend. With the same logic, this concept came. Tell me, dividend equalization reserve. Why dividend equalization reserve? Company should pay consistent dividend. Should pay? Therefore, dividend equalization reserve came. Sorry, I'll ask a question. Tell me, can I pay out of general reserve? Yes, dividend equalization reserve? Yes, very good. Capital reserve? No. Revaluation reserve? No. P&L account credit balance? Yes. These are all the free reserves through which you can pay the amounts. Clear everyone? From that the problem started. This box is what box? And this contains what? This contains what? Accumulated profits. So what will be there? General reserve, dividend equalization reserve, P&L account credit, like that so many amounts are falling into it. This is the box. Can I use this entire box, flush it out and pay everything to the shareholders? No. What they said is, see the screen, see the screen. They kept a limit. Listening? Condition number 1. Rate of dividend shall not exceed average rate at which the dividend is declared in 3 immediately preceding financial years. Tell me, what is the first condition? Bad response. Start again. The average rates at which the dividend is declared in the 3 immediately, don't use past, 3 immediately preceding financial years. Start again. 1 second, what we are reading? You don't know the question, you know answer only. What is the question? Payment of dividend in case of inadequate profits or no profits. 0 is also taken. Inadequate profit means profit is there but not adequate. Losses means negative. Then to whom you will give 0? That's why law never use the word loss. It use the word no profit. 0 is also no profit case. Tell again. When you will use this model? When there is inadequate profit or no profit. In that case also company can pay dividend or cannot pay the dividend. Out of the profits, out of the accumulated profits. Any reserve, only free reserves. What dabba this is? Accumulated profits dabba. In this dabba, can I use entire dabba to pay? No, entire dabba you can't use. You can use only to some extent. Correct or not? First condition number 1. How much only you can use? What is the rate maximum you can pay? The rate of dividend shall not exceed average rate at which dividend is declared in the 3 immediately preceding financial years. Understood? Second condition. Shall we? Listen, see there. Amount drawn. Everyone. Shall not exceed 1/10 of paid up share capital and free reserves. What is the second condition? Amount drawn shall not exceed dash 1/10 of paid up share capital and free reserves. Condition number 2. Up to here, everyone understood? Condition number 3. Whenever you draw the amount from this amount, you have to reduce the current year loss. The current year loss. Which condition this is? Condition number 3. Tell all the 3. Tell. Can you pay dividend in case of in case of inadequate profits or no profits? Yes. Condition number 1. The rate at which the dividend is declared should not exceed average rates at which the dividend is declared in the 3 immediately preceding financial years. Condition 1. Next. Amount drawn should not exceed 1/10 of paid up share capital and free reserves. Over. The amount whatever you draw can be immediately used for payment. No. From that what you have to deduct? Current year losses you deduct. If there is any amount remaining, that only you can use. Listening? And the final condition. Tell me, what is this full box? Above that pink color or purple color thing, above that is called as? Everyone. Amount available to draw. What is this below box? Below box is the balance after withdrawal. This amount shall not be less than 15% of paid up share capital. That's all. These are the 4 conditions you have to comply and write in the exam. Start. Everyone answer. Point number 1. What is the condition number 1 to pay the dividend in case of inadequate profits or no profits? Number 1. The rate of dividend should not exceed the average rates at which dividend is declared in the 3 immediately preceding financial years. Number 1 understood? Next. Number 2. Amount drawn should not exceed 1/10 of paid up share capital and free reserves. Number 2 condition. Everyone satisfied? Number 3. Amount drawn directly don't pay them. From that what you have to deduct first? Current year losses. After that any amount remaining you pay. But amount reserves after should not fall below, means should not be less than 15% of paid up share capital. Any question they give, apply these 4, you'll get the answer. Everyone understood the concept clearly? Yeah? Yes. Everyone? Yes. Same rule applicable also for interim dividend. Applicable for? But these many conditions are not applicable. Only first condition is applicable for interim dividend. Only whenever company is making a loss in the quarter preceding to the payment of interim dividend. For example, if you are paying interim dividend this quarter, previous quarter, if loss is there, if what is there? Loss is there, you can't declare interim dividend at whatever rate you want. The rate should not exceed average rate at which dividend is declared. That's all. Remaining all the concepts, interim dividend, final dividend, both are same. With this, we completed the chapter dividends completely. Everyone understood the concept clearly? Dividends chapter. Next, please open the chapter called as a deposits. Debentures. Debentures you can directly see in the chart. No break. (4:30), 5 o'clock we will take the break. 5 to 5:10. I am also taking class from morning here. Please, I also want break. But still, we have no choice. Only 2 days left. Please see. What is the next chapter we are going to start? 5. By the time we will complete this chapter debentures and then we will take a break. Okay na? Answer. Yes, listening? Yes, 5 or 5:10 or completion of this chapter, whichever is later. Not earlier. Like this only you should think. So whichever is later. Let us start. What is the concept we are going to start with? Debentures. See the, sir, everyone have the charts with you? Telegram I kept this, na? Sir, whatever charts I have, I am not asking you to take it directly. I kept in my Telegram group, openly available. Whenever new charts comes, I will put there. New content comes, I will put there. Consistently for finally interview you are seeing in the Telegram group every day, I will do that. So, take it and see. At least if you could not see now on phone or mobile, whatever the case, maybe you at least see the screen. Shall we start? See there. First thing, what is the concept we are going to see now? Debentures revision. Which chapter? Debentures. Let us first understand, with respect to the debentures chapter, what is very important for exam. Exam, there are 3 points which they ask in exam. Number 1, debentures, first one is a basics relating to debentures issue. Basics relating to the debentures issue. How to issue debentures question will be there. Next one, what is the next one? Debenture trustee. If my imagination is not wrong, this time 8 marks question will come from the debentures. Because last 4 attempts they didn't test a question on debentures. Obviously, stereotypic student will feel that this chapter is unimportant and he will go. He will give 8 marks question. That's all. Kel katam duknam band. Next attempt. So therefore, be very specific about this chapter, debentures. Sir, always the trend and pattern of institute, I will tell you. Deposits, debentures, charges, dividends. 3 questions will come from these 4 chapters. How many questions will come? 3 questions will come from these 4 chapters. Pakka, 100% I am sure. All 4 may not come, but 3 will come from this. Shall we continue? See the screen. What is the concept? Debenture trustee. What is this concept of debenture trustee? What is the logic behind this? Let us try to understand clearly first. First one is debentures. See there. What is the definition of a debenture? Start. What is a debenture? Debenture includes debenture stock, bonds, any other instrument evidencing any debt. First one is? First one is? Second one? Third one? You call it debenture, you call it bond, or any debt evidencing title will be called as a debenture. But debenture does not include what? Debt instrument referred under RBI Act or any other document or any instrument prescribed by the central government. Simply remember what it includes. RBI related anyway, Companies Act don't cover, RBI Act only will cover that. Mainly tell me, debenture includes what? Debenture stock, bonds, any other instrument evidencing any debt will be called as a debenture. Okay, next one. Features of a debenture. I think I need not discuss about this because cost of capital we already discussed about what is a debenture in depth. AFM LAW cost of capital. KD we discussed or not? I will ask question one by one, tell me. What is a debenture? What is a debenture? Debenture is a equity instrument, a loan instrument, given to one person, a lot of persons. Therefore, it is a smallest unit of a loan. It is a smallest unit of a loan. Instead of taking loan from one person, I will take loan from hundreds of persons. That means total loan is broken into bits and pieces. Each piece is called as a debenture. Smallest unit is called as a debenture. Read the first point. Debenture is a unit of amount of loan. Debentures will pay dividend or interest? Interest or dividend? Interest will be variable or prefixed? Who will fix? Who will fix? Company will fix. Government will fix, a company will fix. Company will fix. Okay. Debenture is a document which is movable from one person to another person. Next one. Debentures will have voting rights or will not have voting rights? Everyone. Debentures will be unsecured or generally secured? Generally secured. Next one. Debentures can be converted into what? Yesterday we have done one concept in cost of capital. What is the concept we have done? Convertible debentures. Do you remember what is a convertible debenture? We can convert what into what? Debentures into dash. Debentures into shares. Okay. Now read. Over, sir. All the features. Read. How many features? 1, 2, 3, 4, 5, 6, 7, 8. 8 features are there. Read it. Okay, now shall we continue? Tell me now. Sir, all the conditions of debenture, everyone understood clearly? Next one. See here. From here, please be serious. Exam questions will come from this area. Till now, okay. Not yet tested. I don't think they will test also. From now, the questions will start. Please be very careful. First, whenever you wanted to issue the debentures, types of approval that is required. Are you issuing a normal debenture or a convertible debenture? Normal debenture. Board of directors at a board meeting has to approve that issue. Who has to approve? Bad response? And a shareholder's approval required, not required? Not at all required. Second case, what issue you are making? Now you tell me, I will listen. Convertible debentures, in some time after, they will get converted into what? Answer? And we are welcoming debenture holders as shareholders. First, I will ask a question, answer. Convertible debenture is a debenture a share? Is a debenture a share? Is a debenture a share? Debenture a share? I will ask one question. Before answering this, you answer also that. Okay, what? Okay. Now tell me. Answer to my question now. For example, you know, leaseholder, there are two types of leases. Operation lease, capital lease, also called as a finance lease. You know, two types. What is the difference between operating lease and capital lease, finance lease? In which of the leases, substantial life of the asset will be in the hands of the lessee? 90% of the economic value and life of the asset will be in the hands of dash. Hands of dash and a finance lease and hands of dash. Lessee. Such kind of lease is called as what lease? Answer? Do you know what is the meaning of a finance lease? Finance lease works on the basic accounting principle called as substance over the form. Which one? Substance over the form. Do you know what is my substance over the form? Who is the owner? But who is enjoying the asset? For 1 year or 2 years, substantial life. Though registered ownership is with the lessee, lessor, who is the real owner of that asset? Lessee. That's why lessee will be treated as owner in the books of lessee as well. That's why if you take balance sheet of TCS, balance sheet of, you will see leasehold assets as the assets there. You will see the leasehold assets as the assets in the balance sheet. Lease asset means it belong to TCS or other person. But they will show in their balance sheet because those are all financially leased assets. Listening or not everyone? Okay. Financial lease means it will be treated as our asset only. Why I am telling this is, listen carefully to the point. Convertible debenture. Convertible debenture is like a finance lease here. Try to understand clearly. Whenever there is a finance lease, substantial life of the asset is in the hands of owner or lessee. Because it is treated as the asset owned by the lessee himself. Correct? Now listen carefully. Though asset is in the hands of lessee, lessor will be treated as owner if it is operating lease. But in a finance lease, lessee will be treated as a owner. Why I am telling this? Just to one confirmation. See here. Convertible debenture, let us come back now. Substance over form. Again, you have to apply the same logic. Substance over the form. Convertible debenture will be issued as a share or debenture. Loudly. Loudly. With life or without life? When I say conversion is there, sometime after conversion should happen or not? So, it is redeemable or irredeemable? Redeemable. On redemption, you are given two options. What is option number 1? Cash redemption or go for conversion. Go for? Sorry, I didn't go for cash redemption. I went for conversion. Now it will get converted into? Answer? Shares will have a life, perpetual life. And a 1 year or 2 year infinite life. Now tell me, 5 years it is a bond, 1000 years it is a share. Substantial life of that particular bond is in the form of share, is in the form of bond. Now substance over form, convertible bond is a? That's why shareholders permission is required. Are you understanding the point or not, everyone? That's why convertible bond issue requires whose permission? Along with the board approval, whose approval is also required for the convertible bonds? Shareholders bypassing dash. In a dash. Up to here, everyone understood clearly? Okay, next one. Now tell me types of approval. Whenever I wanted to issue a debentures which are normal debentures, whose approval is required? Bypassing a resolution at A. Bypassing resolution at A. Fantastic. Next one. I wanted to issue a convertible debenture. Whose permission is required? First, board of directors bypassing a resolution at board meeting. After that, shareholders bypassing which resolution? Special resolution at a general meeting. Tell me. Convertible bond is there in my hand. Okay? This row, convertible debenture holders. This row, shareholders. Who are you? Tell me, in my hand what is there? Loudly. Now these people, in my hand what is there? Shares are there. You will not see debenture in this. You will see future shareholders in this. Are you understanding the point or not? Who are you? What you see? Loudly. This row, what you are seeing here? You are seeing a share here. Always fear is not to the debenture holders, fear is to the shareholders, because they will feel that our existing capital won't increase. But suddenly one day, all these people will become the shareholders. Listening? This is a situation where loan is converted into shares. Debentures are converted into shares. Means debenture is a loan. Loan is converted into capital. Are you understanding? Yesterday we read one concept or not, loan converted into capital, rights issue, section 62. Do you remember or not? This is also one among that. So that's why the problem will come not to the debenture holders. Problem will come to whom? That's why shareholders, which resolution is required? Special resolution is required. Hopefully everyone understood the first 2 points. Everyone in the class? Yes, sir. Next. Rules for issue of secured debentures. Rule for issue of what debentures? Secured. What do you mean by secured debentures? Can you please explain me? 1 second. Who are all of you? Debenture holders now. Forget about the story. Over. That concept is over. All of you are? Sir, response is slowly getting diluted. Please don't crave for the break. Okay? After this, all the days break. So please listen carefully first. Now answer. Point number 1. Who are all of you? Who are all of you? What you gave me? Money. What I issued you? Now you gave me money for gift or loan? Your money is safe or unsafe? Unsafe. Happily unsafe. How can you believe me? Safe or unsafe? Pakka unsafe. When there is a safety, okay, like in SBI. Safety not there. How can you believe me? Therefore you will ask me, Koushik Mukhesh, you are taking money. We are okay. But put some security of a asset. Put some security of a land and building you have yes, give that security. If you don't pay, we will sell that and get our money back. These kind of debentures are called as what debentures? Loudly. I will ask you one question. Fastly give the answer. Okay na? Now tell me. Company, what will be kept as a security? Liability will be kept as a security. Asset will be kept as a security. Answer? Very good. Asset generates what? Sales. Asset generate? Sales will be used to pay the costs. Sales will be used to pay the costs. Loudly everyone. First one. Asset generate? Sales will pay the interest will be paid out of sales. Sir, if sales is not there, how can you pay interest? So interest you will pay out of sales. After that what you will pay? Tax. After that what you will pay? Dividends. After that you will pay to the equity. Listening? And the entire company is maintained because of assets. That's why ratios analysis, there is one very, very important ratio called as assets turnover ratio. Which ratio? Assets turnover ratio. Everyone, assets turnover ratio. Do you at least remember the asset ratio name? What is the formula? Everyone. Turnover by total assets. Turnover by total assets. All turnover ratios, turnover is in numerator. All profitability ratio, turnover will be in the denominator. Sales profitability, gross profit ratio, net profit ratio, sales is in denominator. Capital structure ratios or activity ratios, sales will be in the numerator, turnover. Ratios chapter I will explain. But why I am telling this? Listen carefully. Company, there is a link between two things. Number one, assets. Number two, turnover. Number one. Number two, turnover pay the cost. Turnover. And if turnover not there, cost can't be paid. If costs can't be paid, interest is not paid, whose assets will go out? Company. Company assets will belong to whom? Shareholders. Answer. Those assets are taken by whom? Debenture holders. Simply to tell, whenever assets are kept as a security, whenever the assets are kept as a risk is not to the debenture holders, they are secured. Risk is to whom? Shareholders. Because if something wrong happens in the company, their assets will go. Whose assets? Loudly. Now you tell me, shareholders' assets go. Let us see the interlink effect. What assets will go? Company and shareholders' assets will go out. Means assets value will reduce or increase. Turnover will increase or reduce. Turnover reduce means profit will increase or reduce. Profit reduce means the dividend will increase or reduce. When dividend is reduced, D1 by K minus G equal to P naught. Automatically price of the share will increase or decrease? Decrease. Who is affected party? That's why shareholders' permission is required whenever you are going to issue the secured debentures in the company after the board approvals are taken. Are you understanding the point or not? First, whose approval is required to be taken? Board of directors. First one, board of directors. Shareholders' approval, sir. We will see their approval is also required. So whenever company is going for debentures issue, secured debentures or normal debentures, or if you are going for convertible debentures, in two cases shareholders' permission is required. Number one, convertible. Number two, secured. Secured debentures are another place I have written the shareholders' permission concept. Up to here, understood the point clearly? Yeah? Loudly, sir, everyone? Yes, sir. Now answer my question. Whenever secured debentures are issued, what will be kept as a security? Everyone? Assets. Listen, this concept after I will give break. Okay, na? Don't see me like that. So the point is, whenever assets are kept as a security, we will create a charge. We will create a charge. Charge means creating a security against the assets of the company to the loan. If loan is not paid, charged assets will be taken by the debenture holders. Listening? Next question for you. Listening? Tell me. There is a company. See the screen. There is a company. Balance sheet. Fixed assets, land and building, only buildings, or only land. How only building will be there without land? Sorry. Only land, gold, precious metals, cash. Okay, so many other assets are there. Where in a company. Please see, 2 minutes I will leave. What is issued by the company? Loudly? Okay. Now listen carefully. Company has taken loan. Loan from whom? State Bank of India. 1 crore loan was taken. Example. To this 1 crore loan, 2 crore worth gold is kept as a security. How much gold? Gold was kept as a security for how much loan? 1 crore loan. Are you listening? Yes, 1 point completed. Second, this loan is taken from whom? So one-on-one concept is there. SBI, one gold is kept as a security. Understood. What is the next one? What is the first next one? This is 10 crores. This is 10 crores. Here 10,000 people are involved. How many people are involved? 10,000 people are involved. I am also one among. I gave 1 lakh rupee debentures. How much? 1 lakh rupee debentures I have purchased and I gave money. For my 1 lakh, none of these assets can be kept as a security. Land and building is 5 crore. Only land is 3 crore. Precious metals is 1 crore. Cash is 1 crore. Listening? Other assets are another 5 crore. Now tell me, is there any asset which is worth 1 lakh? Is there any asset which is worth 1 lakh? For my 1 lakh debentures, 5 crore land and building will be kept as a security. Yeah? No, they cannot. Now what is the thing that I have to do? How many people are there? 10,000 people ki 10,000 assets I can't keep as a security. Understood or not? On behalf of all 10,000, debenture trustee will be there. That debenture trustee favor we create the security. That's how the concept of debenture trustee deed concept came into Companies Act. Did you understand the concept clearly or not? That means all debenture holders will be treated as one unit in the name of debenture trustee. Now he is like SBI. Who is like SBI? In his favor we create the security. That means for each debenture holder we will create security. We will create security in the name of one unit. That one unit name is called as a debenture trustee. Everyone understood the point or not? That now tell me, we will create security in the name of debenture holders or debenture trustee. This debenture trustee is the custodian, safeguarder of all the debenture holders. He will conduct regular meetings with the debenture holders. Whenever interest is not paid by company properly, he will inform the debenture holders. Whenever company is doing any wrong, they will inform the debenture holders. Who is the person doing all these things? Debenture trustee. Who will enter into contract with debenture trustee? Company. A deed will be written called as a debenture trust deed. Everyone, debenture trust deed. That's it. This is a point. Please see here once. Tell me, approvals required one by one. First, whose approval is required? Board of Directors. Next one, creation of what? Charge means what? Just now I said, no, sir, so much time. What is a charge? Creation of a security. Read, charge on the assets of the company. If our company assets are not sufficient, you can also go to the holding subsidiary and associate. Holding subsidiary and associate. So tell me, loan is 100 crore. Can I create a security of a asset worth 5 crore? Answer. Therefore, how to understand the asset value? Therefore, value of such asset shall cover both principal as well as interest. For a 1 rupee loan, you can't give 1000 rupee asset. For 1000 rupee loan, you can't put 1 rupee asset. Therefore, there should be a balance of the amount of loan and balance of the value of asset. Are you understanding or not? Next, who will be appointed? Debenture trustee, and execute the deed within how many days? 60 days after the date of allotment of debentures. Allotment of debentures. See here, very, very important question. What should be the life of a debenture? Tell me. Generally, life of a debenture shall not exceed. In special cases, it can exceed, but shall not exceed. When? What are the exceptions I have given here? First one, which company? Infrastructure company, infrastructure financing company, infrastructure debt fund NBFC, companies permitted by central government or RBI or a national housing bank. Just remember the names. First point, everyone tell me, this full answer in the page. We wanted to revise, tell me. Debenture includes what? Next one. I wanted to ask you one question. Approvals that are required. General debentures, what is approval? Secured debentures. Board of Directors at board meeting, if an amount is there, that amount exceeds, it also require shareholders by passing which resolution? Very good. Convertible debentures require at a board meeting, shareholders by passing special resolution in a general meeting. Very good. Next one. After that, charge creation optional, mandatory. Generally, if the debentures are secured, then charge creation becomes mandatory. Charge is created in favor of each debenture holder, one debenture trustee. Next one, we have to appoint a debenture trustee and execute a deed within how many days? 60 days from the date of allotment of what? Debentures. Next one, what is the general life of a debenture? Special case it can exceed, but not exceed. That can be done by which companies? Infrastructure company, infrastructure financing company, infrastructure debt fund company, or companies permitted by RBI, central government, or by the national housing company. These all can make a debenture issue of more than 10 years, but not exceeding 30 years. Up to here, everyone understood the concept clearly. Take a short break of 15 minutes and come soon. Sir, it's a 5 now, 5:15, 5:20. It's a 5:03 now. 5:20 we will again reassemble and we will complete another 2 chapters also after this as promised. Take a break and come soon. So let's continue. See here. So we started with the concept of debenture trustee and the related concepts. Normal debentures issue procedure we have completed. Now we are coming into the next area called as debenture trustee and the related concepts of the debenture trustee. Okay, see the screen once. See the screen, close the door. Shall we continue? See here. Debenture trustee, when appointment will become mandatory? Let us try to understand. See there. When appointment of debenture trustee is mandatory, it is mandatory where the company issues the debentures to whom? Public. Or not to the public, but to the existing members of the company, but the number is exceeding how many? Very, very important MCQ. Either this or this, if you satisfy, debenture trustee appointment becomes mandatory. Tell me, when debenture trustee appointment becomes mandatory? If the company issue the debentures to whom? Either to the public or to whom? Members. How many members? Exceeding 500. Members exceeding? In that case, whose appointment becomes mandatory? Debenture trustee appointment will become mandatory. Next one. After that, next one. What is the main purpose of a debenture trustee? First one, to protect the interests of DH. DH represents what? Debenture holders. Next one, to redress the grievances of debenture holder. Grievance means the problems. Redress means to resolve. To resolve the problems of whom? Start from the beginning. Point number one. When debenture trustee appointment becomes mandatory? If the company issue the debentures to the public or to the members exceeding 500 in number, then debenture trustee appointment become optional, mandatory. Very good. What is the primary duty of a debenture trustee? Protect the interests of the debenture holders and to redress the grievance of the debenture holders. Next one. Duty in case of insufficiency or default. Very, very important. Please see here clearly. See here. Situation. What is the situation? Let us try to understand. Point number one. Duty in case of insufficiency or in case of a default. Simply to tell, I will explain. Listen carefully. Please listen. Okay? Two situations are governed here. Insufficiency, default. Two cases. What do you mean by insufficiency? Whenever you issue the debentures, what will be kept as a security? What will be kept as a security? Those assets are losing the value slowly day by day. Simply to tell, company taken the loan of 1 crore. Taken the loan of? Kept the agricultural lands as a security. Agricultural lands as a security. Okay? Agricultural lands as a security. When the debentures are issued, the market value of that agricultural land is 1.5 crores. Debentures are taken worth 1 crore. Land worth 1.5 crore. Now tell me, what we said in the last part of the class, whenever you create a security of an asset, that security should cover both the principal as well as the interest portion. Do you remember? What and what should be covered? Principal as well as interest portion. So tell me, how much is the loan taken? 1 crore. How much is agricultural land worth? 1.5. Therefore, they also accepted, created. Slowly, agricultural land is losing its value. Losing its market value is losing. 1.5 became 1.3. 1.3 became 1.2. 1.2 became 90 lakhs. Now tell me, who is at risk? Company is at risk. Debenture holders are at risk. That's called as an insufficiency of assets to pay the liability. That's the first case. Second case. Today is the due date, but company is not paying the principal back. Means there is an insufficiency, a default committed. In these two cases, what a debenture trustee has to do is a question. Did you understand what I said? Yes, start again from the beginning. What are the two concepts we are going to cover here? Insufficiency and default. Honestly tell me, how many of you are listening this concept for the first time? Honestly you tell me, how many of you can tell, no problem. So point is, I know which concepts people are lacking clarity. Thank you, bro. So which concepts people are lacking clarity? Which concept student won't even touch? This area. Those only institute will be always allowed to ask in the exam. Which student never read? I want to ask that in exam. Even if you ask me, sir, if you prepare a question paper, what you will do? I will ask these questions only in exam. Because if a student can write this answer correctly, it is an indication for me that he read everything in the particular chapter. Do you understand? If debenture trustee appointment on what insufficiency if he read, he might have read everything in that particular chapter. Clear? Now tell me, what is the two situations that are governed here? Number one, insufficiency. Insufficiency of liability or asset. Or second one is default. Default committed by whom? Company. Company committed a default. What will happen? In case of insufficiency, repeat, in case of two steps will be there. What is the first one? Step number one. Who is he? DT means what? Direct taxes. Huh? What is DT? Debenture trustee. Make a petition to NCLT. Means who is there to protect the interests of the debenture holders? He is coming to know that there is a sufficiency of assets, insufficiency. Immediately will inform whom? NCLT. NCLT will now make a notice to the company, pass an order not to incur any further liability. Simply to tell, it will tell the company that don't incur any further liability. If you incur further liability, these assets will become much more insufficient. Clear? I repeat, how much is a loan? How much is our asset value? Slowly it became 1.3. 1.3. If you further take loans, further loan also you will keep this as a security. Further it will become insufficient. Therefore, if there is a insufficiency in the assets, first who will make an application? Make an application to whom? NCLT will say the company not to incur any further liability. This is if there is a insufficiency. Not insufficiency. See the what happened now? Default happened. What will happen? Let us see. Step number one. What will happen? Debenture holder or debenture trustee can make an application to whom? NCLT will make a petition. NCLT will make a notice to whom? Company to forthwith. Forthwith means immediately pay the principal and interest. Who will pass an order? NCLT. Pass an order to the company to pay principal and interest. After some time, immediately. Start from the beginning now. Tell me, whose concept we are discussing now? When debenture trustee appointment becomes mandatory? If the company is issuing debentures to the public or to the number of members exceeding how much? Then whose appointment becomes mandatory? Debenture? Very good. Now point completed. Next issue. After that, the next very important point is, whenever debenture trustee is appointed, when the petition to NCLT will be made? In two cases. Case number one, insufficiency of assets. Case number two, default. In case of insufficiency of assets, who will make application? To whom? NCLT pass an order on whom? To incur further liability, not to incur. Next one, there is a default. Who can make an application? Debenture holder or debenture trustee. Make an application to? NCLT will order the, to do what? To pay the principal and interest forthwith. Means what? Up to here everyone understood? Now next one. So main concepts only let us read. So this is the expected question for your exam this attempt. Debenture trustee also I am telling what is very important for exam. Read. What is the concept there? Disqualifications of debenture trustee and filling casual vacancy. Loudly. Filling. Filling. Sir, you know casual vacancy? How many of you know what is a casual vacancy? Casual vacancy. How many of you know what is a casual vacancy? You no problem. I will not ask any question. You just tell me how many of you know. Okay. Bro, you tell. What? What is a casual vacancy? One second. Let him answer. Tell, what is a casual vacancy? No, that's not the answer. I'm asking what is casual vacancy. You are telling under what cases casual vacancy will occur. Anyone else? One second. No chorus, one person. Anyone else wanted to answer what is a casual vacancy? Repeat again. When he exit the office. Okay. What is the difference between vacancy and casual vacancy? Yaar. Enga irukka? Namaste. Again. You, him, everyone is answering under what cases casual vacancy is occurring, you are telling. My question is not what creates casual vacancy. I am asking what do you mean by casual vacancy? You are all, yeah, that is correct answer, this is correct answer, this is also correct answer. I am not asking under what cases casual vacancy gets attracted in Companies Act. I am asking what do you mean by casual vacancy? Again auditor. So forget about auditor. You will become a great auditor. Agreed. But don't create casual vacancy. I am asking what do you mean by casual vacancy? Yaar. Henge irukku? Prior notice? Sorry, I will tell one thing. Listen carefully. What do you mean by death? I asked. Then a person said, a person fall from 5th floor, he will die. Right answer, huh? What do you mean by death? I asked. Then you said, if a person falls from 5th floor, what happens is the death. If a person is hit by a lorry, what happens is a death. If a person is drowned in the middle of a ocean, what happens is a death. My answer is right or wrong? Why? Why my answer is wrong? Tell at least why it is wrong, you tell. I am explaining what is death. I am explaining the reasons for death. Like that only you are answering. You are not understanding my question. I am asking what do you mean by casual vacancy? Sir, tell me. We will generally use the word na? Casual, casually. We will use or not? Casual means what? Generally, abnormally. Sir, tell me, when we say, why you call means casually, I call casually means generally, normally, abnormally. Everyone? Normally is there. Tell me, general, abnormal? Sir, listen carefully. I will give you an example. Listen carefully. There are two persons, A and B. So don't shout at example, first point. There are two persons. Why I am telling this story? Never in life this doubt should come. When you are having exams in 2.5 weeks, how can you get a doubt on what is casual vacancy? Are you understanding or not? So listen, what do you mean by the word casual vacancy? Let us understand the difference first. Then you can read this casual vacancy. If you understand, same you can apply also on the auditors. Auditor. So same you can also use for auditors if you can understand this example. So listen carefully. Two persons are there. These two persons used to call each other every single day. Okay. Let us say these two people are sales managers in a company. They have to contact with each other about the sale happened in two different regions. Okay. Office work is there. Listen carefully. A is there, B is there. They are working in some organization. Sale will be done. Both the people are sales managers. Am I clear? Company rule is every 30 minutes or 45 minutes or 1 hour, one sales manager should call another sales manager and update about the sales. Listening? Office starts at 10 o'clock in the morning. Office starts at 10 o'clock in the morning. From 10 till 6 o'clock office will be there. Every 1 hour, one person should call another person and update about the sale. That's a rule of the company. Did you understand my point? Now tell me. 10 o'clock, A called B. A called B. From the company phone, A called B. Now tell me, B will ask why you called. He will not ask. Why? It is implied that he will call only for what purpose? Have you ate the lunch or not? For breakfast, what you have? All this they don't ask. Are you understanding or not? Obviously, what he will ask? What about your sale? How many units you sold? Like that they will ask. Correct or not? Now tell me. 10 o'clock, A called B. 10:30, B called A. Now tell me, will A ask B, why you called? Will B ask A, why you called? They don't ask because obviously they will call for what purpose? Sales purpose, because generally they call only for that purpose during the office timing. Are you understanding or not? Now you tell me, 10 o'clock in the night, A called B. Now for updation of the sale, maybe for a different purpose. Maybe for a different purpose. Now what B can ask A? Please. Now B can ask A, why? What B can ask A? Why you called? That question will come. Then he said, I casually called. That's why casually is always an abnormality. It's not normal. Casual always represents an abnormality. That's why hospital emergency ward is called as a casualty. What is casual vacancy? What is casual vacancy? So now tell me, casual means emergency, normal? Generally Indians made English kichidi. Why you call me casually? We made up with our body language. Our body language made it general. Actually word is emergency only. Why you call means casually. Means body language is saying as if it is general. But the word casualty is emergency situations are called as a casual. So the word casual represents emergency vacancy is created. Do you know what is an emergency vacancy? As our auditor said. What you said the answer? Generally, answer my question. Auditor will be appointed for how many years? One, not the firm, individual auditor. Answer. 5 years completed. Term will be continued or vacated. You know that already or not? If we vacate before that, it's an emergency. If we vacate, that's why those only attract casual vacancy. If at all 5 years completed tenure of an auditor, auditor vacate the office and will take a office rest for another 5 years. Correct or not, everyone? At that time we call it as a vacancy, not a casual way. Anything happens suddenly, even before the expiry of the tenure of office, then only we will call it as a casual vacancy. Casual vacancy is called as an abnormal vacancy, also called as a vacancy created out of an emergency. Vacancy created out of an emergency is called as a casual vacancy. Read. All answers. One side. Yes, this is right. Read. Read now. Disqualifications of and filling of now listen carefully. If a debenture trustee, okay, if a debenture trustee does anything wrong, he will be disqualified. Disqualification will vacate his office, resulting in casual vacancy. I appointed debenture trustee for a period of 5 years. Appointed for a period of 5 years. After 5 years, if we go out, vacancy or casual vacancy? Answer. Before 5 years, if we go, casual vacancy gets attracted immediately. Everyone understood the logic or not? Read now. Tell me. Disqualification. Read. I am telling you this question will come in exam. Tadhastu. It has to come. Read. Disqualification. Start. Number 1. beneficial shareholder. Listen carefully. If you are having beneficial interest in the shares of a company, you cannot become the debenture trustee for the same company, because debenture trustee will try to complain against the company or support the company. All wrong answers. Again start. Debenture trustee wanted to support the company, he wanted to be against to company. Against to company, he never support the company, he support whom? Debenture holder. Why he'll support company? Always he try to find the faults in company. Listening? Array, if you are a shareholder, how can you complain? Auditor independence type. Auditor should be? Can I acquire shares in the company in which I am doing audit? Why? Disqualification. Babu. It is a threat to the independence or not? Auditor will have 5 threats of independence. Okay, self-interest threat, self-review threat, familiarity threat, advocacy threat, and intimidation threat. 5 threats to the auditor's independence. Are you understanding or not? Auditor, clearly they are saying that auditor must be honest, he should not certify what he does not believe to be true. Okay, so it is a financial examination of independent examination of financial information, whether profit oriented or not. Like that, why they said the logic is very simple. Audit is a independent examination. In that, there should not be any biased situation that should come, because confidentiality, integrity, all these are one of the features and characteristics of an auditor. So you should never make a biased report. Therefore, what happens? Law also said that, are you an auditor? Yes. Then don't acquire the shares in the company in which you are auditing there. Your relative should not be there. Like that they said, correct? Huh? Same logic for debenture trustee also. You are fighting against the company to protect the debenture holders. If you are the shareholder, how can you fight against the company? Therefore, you should not be beneficial shareholder. If you are, then you are disqualified. You should not be. 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 Start again. You should not be. Or you should not be promoter, director, KMP, officer, or employee. Not only of that company, like auditor, should not be in the company, holding company, subsidiary company, associate company. Tell me, what is the first one? Company. Company means what? That company. Next, holding, subsidiary, associates. You should not be the promoter, director, KMP, officer, employee. Done. Next one. What is the next one? Casual vacancy. Okay. Casual vacancy can be caused by, sorry, there's not registration, by mistake, resignation. What is it? Resignation. Casual vacancy caused by resignation can be filled with the consent of the majority debenture holder. Who resigned? Debenture holder resigned. Who resigned? Resigned and went away. Now place is vacant or not vacant? Vacant. Emergency or normal? Normal or abnormal? That casual vacancy will be created, will be filled by the majority debenture holders will take a decision. Okay, next. Caused by dash. This is a strong and dangerous case. Removal means that fellow might have done utter flop decisions, wrong decisions, did not protect the interest. When they are not paying the interest, he is sitting silent. All this nonsense happened. Therefore, filling of such casual vacancy does not require majority approval. Removal requires the consent of, first who should remove? Debenture holders will remove. But how many debenture holders has to remove? 3/4 debenture holders are 3/4 value holding debenture holders are. For example, all of you in the class are debenture holder. 200 people are there. How many are there? Who are all you? Who are you? Debenture holders. First bench is holding 80% and remaining are holding 20%. 1, 2, 3. These 3 debenture holders are holding how much? 80% of the total value in the debentures. Remaining all 197 people are holding. These 3 people decided to remove debenture trust. I am debenture trustee. These 3 people try to remove me. All of you are against to that. Now I will be removed or will not be removed? Will be removed. Why? Not number. Head count is not important. What is important? Value in debentures is important. How much value? Next one. Filled by the board. You removed, vacancy created. Who has to fill? Board of directors has to fill the vacancy. Up to here, understood the concept clearly or not? Everyone? These are all the important points that you need to understand. Last but not the least, the king of the ring in this chapter, debenture, redemption, reserve. The most difficult area to remember, but we make it as easy as possible. See the screen. Mark it important. MCQ can be asked, 3 marks, 4 marks questions can come. Any type of question he can ask in this area. So be extremely vigilant and careful. Since the chart has to be seen by all, I am making it full screen. See here. Even if I am not visible, no problem, but chart should be visible. Last benches, can you see the chart? See here. Sir, listen. This is already there in our Telegram group, so no need to take photos, etc. Already there. Share capital, I am preparing the charts material. 1 or 2 days I will share that full chapter on share capital and prospect, not prospectus, share capital. General meetings. Share capital and general meetings charts are getting prepared. Once completed, I will share those. Okay. See here. What is the concept we are seeing now? Debentures or debenture redemption reserve. So everyone please listen. So Zoom live students also please listen. Everyone please listen carefully. Important concept. What is the concept we are seeing on the screen? Debenture redemption reserve. How this concept is important? First point number 1. When to create DRR? Whom to create DRR? How much to create DRR? These are the 3 questions to be answered. Listening, huh? Let's see the screen. First one. What is the first one? See there. Creation of DRR and investment in DRF. Debenture redemption reserve. Debenture redemption fund. 2 points are there. First one. There are 2 concepts. Debenture redemption reserve. Debenture redemption fund. 2 concepts. See there. First one. Category number 1. If you are all India financial institution. Loudly. All India financial institution. Next one. Banking companies or public financial institution. In that case, DRR, whether it is a public issue or it is a private issue, DRR concept is not applicable. Reason. Banks, financial institutions are governed by RBI guidelines. You need not create any kind of reserves. Sir, why reserve will be created? Please tell me, I will learn. Why reserve will be created? Educate me. Why reserve will be created? Normally asking, why reserve is created? Suddenly amount may not be available. If you go on putting the amount slowly year after year, it will accumulate and you can pay it easily to the other person. Correct or not? Therefore, what will be created? Everyone. Same logic apply here. Banks, financial institutions, public financial institutions, all India financial institutions, etc. All those companies are already governed by whom? RBI guidelines. Normal headache will not be there. Statutory liquidity ratio. Statutory liquidity ratio. Cash reserve ratio. Nonsense ratio. So many ratios are there. Minimum cash balances they will already maintain. Who? Banks, financial institutions. Then why again they have to create DRR? Listening, that's why all India financial institution, banking companies, public financial institution, in all these 3 cases, DRR, DRF, public issue, private issue, anything, not applicable. First point, everyone understood the concept clearly? Come to the category 2 situation. Read. What is the category 2? NBFC and housing finance companies. HFC means what? Housing finance company. What are the 2 things covered? Please read. NBFC, housing finance company. In this case, let us try to understand what will happen. See here. Line this side. First one. D. First one, public issue. Second one, private issue. Applicable, not applicable? Again, same reason. NBFCs are governed by respective regulations and RBI regulations. Example, chit fund is a? You don't know that chit fund is a NBFC? Don't tell, now I know. Chit fund is a? NBFC. Chit fund is a? Chit fund is a pakka NBFC type. Okay? Chit funds are governed by Chit Fund Act, Registrar of Chits and RBI guidelines. Listening? Since there are multiple laws already governing them as to how to maintain, separately again debenture redemption is a public issue, private issue. Required or not required? Very good. But what is this? Everyone, what is DRF? Debenture Redemption Fund. Sir, what is Debenture Redemption Fund? That I will discuss later. Just remember, public issue, private issue. If it is a private issue, then applicable or not applicable? But here this is applicable. So now tell me, what is applicable till now? Till now we read so many things. In what case only it is applicable? In case of debentures issued by NBFC or national housing financing companies or corporations. DRF is required or not required? Required. In case of public issue of debentures. In case of DRR or DRF? Next category. See here. Next category. Start. Which company? Same concept again. First one. Next one. DRR. Public issue, private issue. Applicable, not applicable? Sir, why sir? And RBI something. Is it directly they are governed by RBI? Why sir? Listed companies are governed by SEBI. Governed by? Unless and until your liquidity is good, they don't allow you first. Listening? There is whom to govern you. Therefore, Companies Act has nothing to do with, because listed companies are already governed by whom? SEBI. Companies Act said no for debenture redemption reserve. So reserve creation is required or not required? Not required. Whether it is a public issue or whether it is a private issue. What is not required? DR. R. Required, not required? Very good. What is the next one? Same concept like NBFC. Private issue, not applicable. Public issue, applicable. What should be created? DRF. Very good. Next. After that. Category 4. Which kind? Unlisted company. What is this? And a public issue? They cannot make a private company unlisted. They can't go for public. Listening or not everyone? What I have written here? Means unlisted means who can come into that? Private companies can come? Or public companies la unlisted can come. Those kind can go for public or cannot go for public. So there is only one concept. What is that? Private placement. What is there? DRR. DRF. That's all. This is a concept. Yeah. Let us consolidate everything now. Start from the beginning. Point number 1. In what cases it is applicable? You tell me one by one. Debentures issued by NBFC and housing finance companies, creation of DRF is applicable in case of public issue of debentures. Very good. Next. Issue of debentures by listed companies. DRF is mandatory if it is going for public issue of debentures. Next. Unlisted companies going for private placement of debentures. Creation of DRR and DRF is mandatory. Answer over. It is a concept that he wanted to tell everyone. Understood the concept of DRR, DRF properly? But last but not the least, sir, how much DRR I should create and what is this concept of DRF? Sir, DRR means putting the amount aside. DRF means investing somewhere. DRR means aside. Next one is investing somewhere. Is called as what? DR. I think you need not invest every amount in that. Let us try to understand what it is. DRR shall be. Listen. DRR is required in which case? DRR is required in which case? Listed, unlisted? Unlisted. Going for what placement? How much they have to create? Read. DRR shall be 10% of value of outstanding debentures. You need not create everything. How much you need to create? 10% you need to create. DRR. Next. Continue. Investment shall be made at the rate of 15% as on the 30th April of the year in which the debentures are due for redemption. Investment shall be made in the following. Listen carefully. First one. DRR shall be how much percent of the value? 1,000 rupee debentures is there. How much we need to reserve? 100. Remaining 900 you pay on that day. But reserve how much? 100. Which is equal to how much percentage? 10. Second one. You listening everyone? Whenever you go in a traffic, 3 signals will be there. Number 1, red. Number 2, amber color, orange. Okay. Third, what is orange color representing? Wheat. Red, wait. Stop lo you won't wait. What you will do? So what is the intent of the amber color light? I mean yellow or orange, whatever you call. That means technically you can start but not go. Get set go type. That means get ready. DRF is really get ready concept. Means what? You have to repay the debentures in the March 2025. You have to repay the debentures in March 2025. Always remember one thing. Debentures you can't issue at whatever time you want. All debentures should mature on March 31st only. All debentures should mature on March 31st. You can't issue at whatever time you want. Regulations don't allow you. You issue at any time. But it should be redeemed on a March 31st of a particular year. Listening or not? So tell me. Which year our debentures are coming up for maturity? March 31st of which year? 2025. Over. Now he is saying that get set ready. Okay, na? How much amount? 100% amount you need not put ready today itself. What he is saying is total amount whatever you have to pay on 31st March of next year, in that how much percent? 15% of the amount you invest somewhere and get the ready. Are you understanding? By what time I need to invest that amount? 30th April of the year before the year in which you are making the payment. Tell me, which year we are in? Answer. Let us say today is 10th April. Today is what April? I have time till what date? 30th of April. Create a reserve of amount of how much percent? 15% fund. Transfer it to any of these 4. Transfer it to any of these 4. Either deposits with scheduled bank or bonds in Indian Trust Act or unencumbered deposit with CGSG or under the Indian Trust Act. Simply risk-free investments you have to make. What are these 4? In that amount what you have to do? You have to invest. How much amount? When to invest? Answer here. When to invest? 30th April of year before the maturity. When you are going for the maturity? 31st March of which year? 2025. You should create the fund as on which date? 30th April 2024. How much amount you need to transfer to the deposits? 15%. That's called as a DRF. Normally reserve will be created to the extent of 10%. Everyone understood the concept clearly? Yeah? Everyone? Everyone in the class? That is the concept he wanted to tell. Everyone understood the logic clearly? This is what the debenture redemption reserve concept wanted to convey. Now I will ask the question. Fatafat give the answer. It will be completed. Tell me. Point number 1. Which companies? I will ask a question answer. All India financial institutions, PFIs, etc. Tell me what is the situation. DRR required, not required? DRF required, not required? Very good. Next one. NBFC Housing Finance Company, DRR. DRF required only in case of. Next one. Listed company, DRR. DRF required only for public issue. Next one. Last one. Unlisted company, DRR. DRF private or public? Public? Public issue cannot be made. So question of public offer will not arise. Last one. How much DRR is to be created by those unlisted companies? 10% of the outstanding debentures. You have to create a reserve. DRF, whenever required, those companies has to put how much amount in the deposits? Every year, last year. Last year. Listening? Maturing date is next year, 31st March. Create the reserve, create the fund as on 30th April of the previous year. How much percent? Can I invest that in the crypto coins? Bitcoins? Reliance Industry shares? Futures and options? Then gone. Bowl. Therefore, what they said, for security purpose you are transferring means it should be in a risky area, a risk-free area. Therefore, government scheduled banks, government trusts, all these areas you need to make your investment. This is the end of the chapter. Debentures. Debentures is also completed. Everyone understood the concept clearly? The concept of debentures, everyone? What are the two topics we completed? First one, dividends. Next one, sir, if you have any kind of doubt, you can ask first. Once I clarify, you can go to the next one. Dividends we completed, debentures we completed. Are you clear up to here? Tell me, debentures, what are the concepts we read? First one is the features of debentures. Second one is the issue of debentures procedure we have seen. After that we seen one very important concept called as a debenture trustee. And after that we went into the concept of debenture redemption reserve and debenture redemption fund. Everyone understood the concept clearly? Next one. Come to the notes. Whatever the notes you are having, please come to the chapter called as charges. See the screen. See the screen once. Okay. See there. What is the concept we are going to deal with? Charges, sir. Registration of charges, sir. Yesterday I told you, creation of charge is not governed by Companies Act. Creation of charge is governed by another act is there. SURFACE. What is it? Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002, read with the Debts Recovery Tribunal Act 2016, CA final. So it is there, full fun. Okay, there you will read. Here not applicable for CA inter. That much torture they don't do in inter level. Final level of super it will be. Just 260 sections here. Nothing more. That comes for 10 marks. Full fun, I told you. At that time I will only again come. My face only you will see. At that time we discuss about how to create the charge. Here what we are reading, creation of charge. Registration of charge we are seeing here. There we will see the creation of charge. Okay, let's see. Sir, what are all the sections? Read the section numbers first. 77 is talking about what? Duty to register the charges. 78, application for registration of charge. 79, Section 77, apply in certain matters. 80, date of notice of charge. 81, register of charges to be kept by registrar. Company to report satisfaction of charge. Power of registrar to make entries of satisfaction and release in the absence of intimation from company. 84 is intimation of appointment of receiver or manager. 85, company's register of charges. Punishment for contravention, rectification by CG in the register of charges. So many concepts are there. Not that difficult, very easy to understand. But one section, very big section, but question will come not from entire section, they don't ask in exam. Important concepts are there, amendments are there in this area. Therefore, what I recommend you to do is, if there is any space available, any book, don't write in a separate book. For example, if you are taking my material, here only somewhere, wherever the place is available. See, in my book, 226 pages space is available there. Or if you are following any other book also, no problem. Wherever space is available, write notes there itself. The entire section, I will convert it into a small chart and I will try to explain like what we does with the transfer and transmission in the yesterday's class. Or else you won't remember, yeah, you are not understanding. Tell me, what is the time limit for registering the charge created on debentures? Adi. So first time some people are listening. What is the time limit for creation of charge created on debentures? 70 years. So 70 days ki no time limit is there in Companies Act. That's all. Extension? Are 300 days when there is a company, old Companies Amendment Act time it came. Not now. That's why. You can't remember debentures, what form you have to file. Okay, other than debentures, what form you have to file. Confusion will come. Listening? So the problem is, I will tell you. Listen once. Share capital, to some extent general meeting, to some extent general meetings, to some extent prospectus. At least students are having clarity. Means they will read because craze is there for those chapters. So everyone will tell share capital important, prospectus important. Everyone will tell this. Student by trend they will remember and they will read this. Problem will come with which chapter? Charges, deposits, debentures, dividends. These chapters when a problem will come because we neglect that completely. What institute will do? 5 marks questions they will ask from all the 4 chapters. That's all. Your 20 marks gone. Are you understanding? That's why the problem will come in the paper just because of being negligent in the examination preparation. That's all. Papers will not come difficult. The way they ask questions also, if you properly follow the class, you can answer. Problem is they will ask from the unexpected areas. Means what? You will prepare general meetings fully, share capital fully. Attempt, you know what they will do? Charges 7 marks, deposits 6 marks, dividends 5 marks, and debentures they will ask 8 marks question gone. All unexpected questions you will see in question paper. Those papers we call it tough. But actually those are not. Shall we continue now? Listen carefully. What is the concept we are going to begin with? Registration of charges. This is the name of the chapter. Okay. First one. See how many times this question was tested. 8 times this question came in examination. Okay. What is this question? Please note down. Keep the heading in the notes. Section 77. Section 77. Summary. Summary of section 77. Okay. Before going into the summary or writing anything, first let us understand the concept clearly. Okay, shall we continue? Okay. First, let us read some significant points here. First one. Tell me, what is the chapter we are starting with? What is the chapter we are starting with? Okay, charges. Read. First, what is the definition of a charge? Charge means an interest or lien created on the property or assets of a company or of any of its undertakings or both as a security. We can also call it as a mortgage. Simply, charge is a, simple words, charge is a security against what? Assets. For what taken? Loans taken. On what taken? Loans taken. Loans can be in the form of loan or loan can be in the form of debentures. Any form it can be. Simply to tell, it will be created on the debt. created on the, very good. Tell me, charge is a, bad. Charge is a security created on the, for what taken by the company? Loans or debt created by the company, we create a security. That concept is called as a lien or a charge. Okay, na? One point. Next. Problem is like this. Companies Act do not cover, I repeat, Companies Act do not cover charge creation. They cover registration of the created charge. They will talk about dash. They will talk about what? They don't talk about? They don't talk about creation of charge. Rather, they will talk about registration of the created charge. Already charge is created. The registration is discussed by the Adi. So tell me, what is mandatory under this section 77 or whatever the chapter may be? Creation of charge is mandatory. Yeah? Registration of created charge is mandatory. Yeah? So let us understand on what charge can be created. Read. Where? Stop there. Section starts with the words where a company creates the charge. And the creation of charge is already done under Companies Act. Not under Companies Act. Under different acts, what is already created? Charge is created on any of the assets of the company. It shall be the duty of the company to register such charge. Write down. First point. Point number 1. Section 77 talks about duty of the company. Section 70, I am telling the notes, write down. Section 77 talks about duty of the company to register the charge already created. To register the charge already created. Okay, na? Next one. Number 2. Point number 2. Tell me, charge is created on what? On liabilities, eh? On what? Instead of using asset, they use the word property. Instead of using the asset, they will use the word property. Property can be mobile or immobile. Mobile or immobile. Tangible or intangible? Tangible or intangible. In India or outside India? Maybe in India or outside India. The only thing is company should own that asset. That's all. Placement is irrelevant. Ownership is relevant. Listening everyone? Write down. Point number 1 or 2? 2. Charge is created on any property. Write down the summary notes properly. Exam ki you can't read 4 or 5 pages for one single section which is coming for 4 marks. What you have written? Charges? Any property which can be, below write down, bullet point type. Mobile or immobile. Bullet point 2. Tangible or intangible. Tangible or intangible. In India or outside India. In India or outside India. Okay. Next one. Point number 1 or 2 or 3? 3. Write down. Mark it most important for the chapter. It's a chapter, full chapter ki this point is important. I am telling clearly this full chapter. This is the most important point. Write down. Time limit for registration of charge. Time limits for registration of charge. Okay. First, I will give 2 minutes time for you to read, because sir, just like that robotically don't copy the notes. First you should read, you should remember. After that we will write the notes. Okay, na? I will give time. Read this first content. Notes visible everyone? Last benches notes visible? Now visible? Last bench students visible? Thank you. Read. Take 1 minute time, read it. Don't read out. You read, I will ask question. Okay. First point, have you read? First point means A, B, C, D. Have you read or not? Next, also read this. Okay. Have you read at least when I asked you to read? Not yet completed. Wait. I will ask another point also to read. Okay. You do one thing. Read these 2 points combination one more time. I will show you the direct answer now. What are the two situations? At least did you understand what are the two cases? What is the first one? Charge is created before the commencement of Companies Amendment Act 2019. Next one. Charge created after Companies Amendment Act 2019. Okay. If charge is created before Companies Amendment Act 2019, general charge should be created within how many days? 30 days of what date? Creation. If you could not make it, can you apply for an extension? Extension for how many months? Sorry, how many days? Everyone? No. It is only 270 days. Extension is not for 300. That's why I ask you to read. 300 from the date of creation of charge. And already what is completed by that time? 30 days already over. And the extension is given only for? Total period will be how many days, sir? This is before Companies Act or after Companies Amendment Act? Before Companies Amendment Act 2019. If charge is created after Companies Amendment Act 2019, tell me, what is the time limit for general charge registration? Are common for both the cases. Can I apply for a extension? There are two extension chances. There are how many? Two. First extension can be made for how many days, sir? Everyone. Hey. What you read here? Again wrong answer. Read again. Read again. Some are telling 60 days, some are telling 30 days. Why I gave time for you to read? Read again. Now tell me. After Companies Amendment Act, if you create, after Companies Amendment Act, if you create the charge, what is the general time limit given? Very good. If you could not do that, can you apply for extension? That's called as a condonation of delay. Means excuse. Condone represents excuse me. Pardon we tell na? That's in legal language they call it as a condonation. Condonation means please excuse me. Okay, for this time we ask the in general English excuse me. Excuse me in law language is called as a condonation. So can I ask for a condonation of delay? Yes, you can apply. How many days of extension will be given? I am asking. Some are saying 60, some are saying 30. Tell me. 30 only will be given. That's why he said after 30 days, but within 60 days. And what is the extension gap given? 30 days. Listening, huh? You did not register the charge even during that time. Can I again go for another extension? Yes. This time extension will be given for how many days? Further 60 days time will be given. Further? So, what is the extension time? Tell me. One by one tell me. First one? 30 days. Second one? 30 days. Third one? 60 days. Now I will ask a question. Why it is not directly 30 plus 60, 90? Why they broken into two parts? You can ask additional fees, na? Then why they have divided into two? The only reason is, answer is the fees. But first, generally you have to file the form within how many days? At that time you have to pay the fee. You have to pay the fee. You could not do that. You went for a condonation of delay. And you are filing in the within next 30 days. At that time you have to pay what? Fees and additional fee. When I was using the word additional, first something should be there to add to that. Additional fee means to what you are adding? To Sunyam you are adding. Something X is there, means to X you can add. Then I will call it additional. Nothing is there means it will become fees only. The general English terms meaning I don't want to, we are not in communication class. What fees? Additional means what? To something we are adding. That something is what? To that you are adding? Means how many are there? 2 fees already you are paying. Understood the point or not? That's called as what fee? That's called as what fee? Additional fee. Additional fee you have to charge and you will pay. Next, if you are going for, then additional fees will not be there. Ad valorem fees will come. What fees? Ad valorem fees. Sir, what is an ad valorem fees? Ad valorem means random, decided by the registrar. At that time he will tell pay 5 lakh means you should shut your mouth and pay that 5 lakh and file. Are you understanding or not? That's called as a ad valorem fees. At that time, depending on the case to case basis, he will change the value. Official way of asking money. Are you understanding the point or not? That's the concept called as what fees? Ad valorem fees. Which fees? Ad valorem fees. Did you understand my point or not? So try to understand clearly. So recently only, very recently, hardly how many days I will show you. See how the NCLT orders will be. I told you now, I used to represent before NCLT very frequently. See here once, I'm sharing one document. Sir, you know one company called as a gold medal switchboards. Switchboard, gold medal, GM gold medal. You know that or not? We are the auditors for that company. So that company is now going for a merger. You can see here. Section number 232 of Companies Act. See, these are the companies which are going for merger now. Goraji Marketing and Consultancy, we are the auditors for Vedmutha Electricals Private Limited. That Vedmutha Electricals is the name of the company, brand name is called as a gold medal. So Gold Medal Electricals Private Limited, these are the transferor and transferee companies. They are going for the merger now. See there, National Company Law Tribunal, which bench? Mumbai. Mumbai NCLT, we have to go. And they asked me to come as on earliest by September 15th. September 15th, the first session in NCLT is going on. There will be so many kinds of hearing will be there in NCLT. First hearing starts on or before 15th of September. This is all like this. The orders of NCLT will be. See here. Appearances, petitioners. Have you heard about this name RD? I told in Companies Act so many times in regular class. What is the concept? Regional Director. This is how it will be. Order. Like this they will give. Why I am telling is, point is they don't just like that what you are reading is not theoretical happening. Practically people are doing. I am doing like me, so many chartered accountants are doing. So the point is, whenever you are trying to pay the ad valorem fees means it's a random fee. Who will fix that? Registrar has to fix it. They will put whatever the penalty amount they want. At the time you have to pay. There is no option available for you. Clear or not? Now answer to my question, point number 1. Tell me, generally the filing period will be? Can we go for an extension? After Companies Amendment Act, first extension will be given within, will be given by 30 days. Means maximum period is up to 60. Can I go for second extension? Yes. What payment I have to make? Ad valorem fees I have to pay for that. Everyone understood the concept? Next one. Next one, certificate of registration. Okay, all these things. Let us continue writing the notes now. What is the thing you have written? Okay. Now, see here, time limit for registration of charge. Two branches, please write down. 2 branches, time limit for creation of charge. 2 branches, charge created before Companies Amendment Act 2019. Next one. Charge created after Companies Amendment Act 2019. Two branches. Charge created before Companies Amendment Act 2019. General time. Extension. General time. Who will file? Who will file? Has to file with ROC. Has to file with ROC. Please write down. Form CHG 1 or CHG 9. 1 is for other than debentures, 9 is for the debentures. Loan taken 1, deposits 1, debentures 9. Okay? This is called as application of registration of charge. AOROC means what? AOROC means what? Application of registration of charge. You will file with whom? ROC. This has to be filed within how many days? 30 days of DOC. What is DOC? Date of creation. Date of creation of what? Charge. I am writing all shortcuts. If you want, you can elaborate and you can write, or else you will forget what is AOROC, what is a DOCOC, DOCOC, like that you will read. So therefore problem may come. So therefore if you want, you can write. Okay. Next. Extension. Extension also, company will apply to whom? ROC. Please write down. Company will apply to ROC. So tell me, company will apply to ROC for what? Answer. Extension. Maximum time period will be given 1 time or 2 times. Again you forgot. Hey, this one I am asking here. How many times extension will be given? They will give one extension for a period of 270 days. Correct? On the payment of what fee? Additional fee. Again additional fee will be there. Charge is not registered within 300 days. At least you can register within next 6 months. Do you remember or not? Everything you are saying yes and giving wrong answers. I asked 1 time or 2 times, means 1 time you said. How many times it is be given? 2 times it will be given. Generally, it will be completed within how many days, sir? 30. Or else go for extension of? So totally complete within? Even if you could not do that from the 6 months on the registration. From the date of commencement of Companies Amendment Act, you can go for further extension for a period of how many months, sir? Okay. Sir, I will show you the form numbers also. Like this it will be. See here. What is this? For loans, deposits other than debentures, CHG 1. And CHG 9 is for what? Answer, yeah. Debenture. So whenever you want, you have to file in form number CHG 1 or CHG 9 as the case may be. Everyone understood the concept clearly, yeah? Okay. Now, see here. Company will apply for extension. Extension also you have to apply CHG 1. Application for creation of charge. How many types of time limits are there? 2 types. First extension, second extension. Tell me, first extension will be given? First extension will be given for a period of? Second extension will be given for a period of? From the date of creation of charge, commencement of Companies Amendment Act 2019. Okay, wow, everyone completed. Next, charge created when? Second situation, charge created when? After commencement of Companies Amendment Act 2019. Tell me, again 2 branches. What is the first one? General time extension. Again tell me, who will apply? Apply to whom? In form number? 1 or 9. Application of creation of charge. Please tell me, everyone, answer. What is the general time limit? 30 days of date of creation of charge. Extension. Again for the extension, who will apply? Company. Will apply whom? ROC. In form number CHG 1 or 9. What is this called as? Application of creation of charge. Registration of charge. And again, how many branches will be there? 2 branches. How many kinds of extension is there, everyone? 2 types. Tell me, first one, extension for a first, write down there. First extension for a period of 30 days. The total will be 60 days. Here total will be 300 days. After that, what will be given? Second extension will be given. Tell me, second extension will be given for a period of how many days, sir? 60 days. Main difference is this will have additional fee and this will have ad valorem fees. So entire text okay, see here. Sir, up to here, everyone understood all the concept clearly? Hello, everyone. Below, write down. How many points you have written? 1 or 2 or 3? 3. Fourth one. Point number 4. Duty of ROC. Duty of ROC. ROC will give to the company certificate of registration of creation of charge in form number CHG2. In form number CHG2. What is COROCOC? Certificate of registration of creation of charge. Who will issue that certificate? Answer. To whom he will issue? In what form he will issue that? CHG2. Examination, don't write like this. How you should write all this? But I'm not asking that. How to frame the sentence completely? The ROC shall issue the certificate of registration of creation of charge to the company in form CHG2. Like that you should frame the entire sentence. Are you understanding? Next. Read. Next one. Number 1 or 2 or 3 or 4 or 5? 5. Write down. Fifth one. Modification of charge. Modification of charge. Next concept is modification of charge. Okay, ba? Shall we continue? See here. Sir, what is modification of charge? Please. Listen, sir, please. What is this modification of charge? What is created as a charge? What is created as a charge? Write down here section 78. 78 and section number 79. 2 sections combination we are writing now. That's why I have written here clearly. 79. Okay. Modification of charge. What is a modification of charge? Let me first explain. After that you can read. Please listen here carefully. Sir, seriously I am telling you, once we complete this 3 sections combination. How many? 3. 78 only basic we are reading. 79 main section. 77, 79, 80. What are the 3? 77. 79, 80. If you complete these 3 sections, seriously I am telling, remaining all the sections will be complete in 15 minutes. The main section of this chapter, exam consistently which question will come? Section number 77, 79 and 80. First tell me, up to here 77 is completed. Did you understand the concept clearly? Yeah, the entire summary. Next, what is the next one we are reading? Modification. Mainly it is covered in section number 79. First answer. What is modification of charge? Listen carefully. What is created as a security? Will you follow me for next half an hour everyone? Tell me, what is created as a security? Asset is kept as a security. We call that security only as a charge. Asset is kept as a charge. Again, is a particular loan. Listening? Listen carefully. This asset is losing its value. Immediately I substituted with another asset in that place. Substituted another asset. Now tell me, charge is on the same assets. Assets are modified. That also you should inform to the ROC. That's what we are going to see now. Did you get the point or not? Write down. Modification of charge. First read the content, after that we will go. Read. As per section 79, provisions of section 77 shall apply. That means procedure is same. Read. Any property acquired by the company which is already subject matter of a charge. Simply to tell, company acquired a asset, or asset or a property. Any property is acquired by whom? Company, which is already subjected to what? Charge. Means company is buying an asset from another person. So generally we will buy second hand machinery. Which machinery? There is X Limited. X Limited has purchased one asset. Purchased one. That asset was under the security kept by that particular X Limited. Y Limited is purchasing this second hand machinery. That means on this machinery already what is there? Answer. Section will get attracted. Second one. Already charge is created on some assets. Now I am changing this. Means the terms and conditions of the charge is same or changing? Two cases. Read. Number one. Any property acquired by the company which is already subject to the charge. Number one. Number two. Modification in the terms and conditions. In these two cases, which section will get attracted? 77 or 79? 79. 79 will take the situations and conditions of section number 77. I will ask a question, answer. Whenever you modify the charge, which section will get attracted? 79. 79 takes the, therefore you tell, within what time I need to register the modification of charge? 30 days. Extension by another 30 days. After that again extension by 60 days. Don't talk about 2019 Companies Amendment. We are in 2024. Listening? Today, if a question has to ask in exam, they don't ask on old provision. They will ask on the new provision. So tell according to today's situation. Tell me. Today, a company is going for modification. Tell the procedure. General time period. Who should file? File with whom? What it should file? Application of registration of modification of charge, because already it is created long back. Now we are going for what? Modification. Understood? Form number? Same section is applicable. CHG 1 or CHG 9. Listening everyone? Extension? Again extension? With additional fees and ad valorem fees. That's the meaning of section 77 applicable to section 79. Listening? Who will give certificate of registration now? Now he will give certificate for registration of creation or modification. What form? That change will come CHD 3 they will give. Who will give? ROC. Now did you understand 77 completely? I am telling the section with rules. Section with rules. That's why form numbers are also coming here. Shall we continue writing the notes? Write down. 2-3 sections we can cover. Two branches. Okay? Modification of what? Charge. Tell me now. Intimation by company. Second one. Registration by ROC. Company will intimate whom? ROC. In form number CHG 1 or CHG 9. Application for registration of modification of charge. Tell me, general time period is how many days? 30 days of date of modification of charge. Extension will be how many days? 30 days, as the total becomes 60 days. Ad valorem fees, the how many days you can go for extension? 60 days you can go. So totally it becomes 120 days. So ROC shall issue to the company form CHG 3, certificate of registration of modification of charge to the company. If you are done with the concept, we'll go to the next sections. Okay? Now listen carefully. Have you written, everyone? Shall we continue? Now tell me. Please spare with me another 15 to 20 minutes. Lot of confidence you will get in the charges concept. Please listen carefully one after another. All the sections let us complete off. So listen. My question is, you created what? Registered with whom? ROC. Application you filed, everything is completed. How many sections we completed now? 2, not 3. 2 only we complete as of now. What is that? 77, 79. I will show you the list of sections. In that, tell me which sections we completed. What we completed? First one, duty to register. Next one, section 77 to apply in certain matters. Okay. Now listen carefully. 80 we are going to discuss now. Which one? 80. It's also a one-line section. I will first ask you a question. First answer this. Alarm to leave. Sorry, okay. Listen carefully. Please listen. You have a, listen first please. You have an asset. I am the company. I am buying your asset. I am buying your asset. That asset is already subjected to what? Who is buying? Company is buying. Listening? I didn't ask you. I didn't ask you whether there is a charge or not. You also didn't tell that there is a charge. I bought it. Okay? Na? Now mistake is with whom? Buyer or seller? Answer. The buyer a mistake. Do you know why? Now listen. The problem with this entire concept is, there is one concept in companies called as doctrine of constructive notice. Enna concept? Whenever some documents are public documents, it is a headache of the person dealing with them to read that public document and obtain the knowledge of that document. Did you read in the doctrine of constructive notice or not? As per doctrine of constructive notice? In memorandum chapter, tell me what is the doctrine of constructive notice? As per section number 399, memorandum and articles once registered will become the public document. Therefore, every person dealing with the company must have the knowledge of the memorandum and articles and understand the contents of the memorandum and articles in the right sense. It is a presumption in favor of the company and against to the outsiders. It is a presumption which works for the benefit of the company and against to the outsiders. It will protect the company against the persons dealing with the company. Do you remember the concept or not? Same concept. Who are you? Seller. Who am I? Company. Who are you? Seller. Who am I? Company. Being a buyer. Correct? I am buying from you. Two topics I can deliver here. Number one, you already purchased an asset. From you, I am purchasing that asset. That asset is already subjected to what? Charge you have already registered with ROC or not? And that the document is available in MCA website or not? Whose duty it is to check whether that asset has a charge or not? Answer. Buyer. Who is the buyer here? Now tell me, really I read or not, buyer will not ask, seller will not ask me. It is a presumption. It is a, and actually you read, we deem that you read. That concept. Read now. Read from the screen. Where any charge on any property of the company is registered under section 77. Some person, you registered, you are a seller. Then any person acquiring such property or interest in such property shall be deemed to have the notice of the charge of such registration, because charge register is a charge document is a. Sir, who said, sir, charge is a public document? Sir, for one say, which section we completed now? Which section we completed now? Now tell me, who said that? Don't tell my name. Law prakaram means as per law. Who said that charge documents are public document? Section 80. 80 said it is a deemed charge creation. 80 did not. Companies Act. Nice. Do you know why? 81. Read. What is this? No joke here. Please read fast. I also have to leave. From morning I am shouting. Read. Register of charges to be kept by the registrar. Register of charges to be kept by the registrar. You are all companies. 200 companies are there. Who I am? I am single person maintaining how many companies? All companies will file their charge documents. Sir, for example, A Limited, B Limited, C Limited, D Limited, like that, so many companies are there. Which company you are? A Limited. Answer, yeah. A Limited created a charge. CHG2, CHG1, CHG9 will be there. Where that company will keep their documents? In that company they will keep. A Limited will keep the charge documents of B Limited. Of which company they will maintain? A Limited. B Limited will keep the charge documents in their company related to which company? B Limited. They don't maintain A and C Limited, correct? But ROC should maintain the register relating to all the companies in the state. Correct? So many documents will be there. Therefore, charge documents will be kept on the MCA website. Since MCA website is a public accessible website, it is a public document. Understood the point or not? Read. The registrar shall keep the register of charges in such a form. Such a form means it will be kept in which form? Electronic form. Manner. Where? Okay. Next. Registrar shall be kept with respect to every company, because for me only my company, for you only your company. But registrar, all the companies in his regime he has to do, and shall contain the particulars of all charges. Any person, read, very important. Any person may, on payment of prescribed fee, inspect the register. Means it is a public document, a private document. If you don't read, mistake is with the buyer or seller. That's why doctrine of constructive notice will work. Which section we completed now? Section number? Answer. MCA website like company will maintain a registrar will maintain a company will maintain within the company. Within the company. I will ask one question with common sense you answer, if any. Company la charge registry is there. Who will be interested to read here? Who will be the users of charge documents in company? Who are concerned about that? 2 persons. 1 member. Because assets are belonging to him. Second creditor, loan belonging to him. Correct or not? Yes, company will maintain register in MCA website in the company. Answer. That's the next section. Completed. Company register of charges. Start. Every company shall keep register of charges in such form, leave it. Shall keep such particulars, leave it. The register shall be kept in the such place, don't tell, register officer. Such a form, such a particular, such a place, everything, such marks he will write. You got how many marks? Such marks. So therefore, register shall be kept in the registered office of the company. Instruments creating the charge shall also be kept in the registered office. Sir, what is register? What is instrument creating charges? Register, CHG1 register, CHG9 register. Listening? Stamp papers attached to that, agreements of loan. Listening? All these are called as instruments creating the charge. Those also will be kept in the registered office of the company. Two types of documents we will keep. Number one, register. Number two, instruments creating the charge. Both will be kept in the registered office of the company. Who can inspect? Start. Who can inspect? Member or creditor. With the fees or without fees? By any other person with the fees. That's all. Which section is also completed? Section number 85. First one, everyone, fatafat give the answer. Up to here, everyone understood the concept clearly or not? Yes, tell me. Company will maintain register in the company where? Registered office. Because branch offices are also there. Therefore, I am asking specifically where? Number one, pakka. Second one, point number two. Company will maintain register along with what documents also will be kept? Instrument creating the charges. Very good. Number three, who can make inspection? Member or creditor. With fee, without fee? Who should pay the fee? Fantastic. Next one. A registrar will keep the register in MCA website. Any person can make the inspection because it is which document? Next one. Whenever we are buying an asset which is already subjected to charge, what the law deem? The buyer has the notice of the charge creation. Really seller will ask her, it is deemed. The moment you are buying the property, we deem that you already know that there is a charge attached to this. Because of doctrine of constructive notice. Understood the concept clearly? Next issue. So see here, main sections, big sections are completed, small sections are still there. Please listen carefully. These are important. Two important sections are there. With that we will close. Important two sections. Please put this here. Don't be in a different world. Important. What is the concept? Registration of? I will ask a question, first answer. Who will register the charge? It did not register the charge. Who is in the problem now? Company will be in the problem. Charge holder is in the problem. Do you know what happens if charge is not created? Suddenly company went into liquidation. All creditors ran and go to the court. They will tell, court, please sell all the secured assets and give us money, it said. Court said that, okay, give the documents. It saw. Who is secured here? Court asked. I am secured, I said. Where is the charge concept here? Where is the registration of charge? Sir, we created, sir. No, not created. Where it is registered? Because registration gives the legality. Registration gives? Yeah. Shall I ask you one question now? Use common sense and tell if any. For example, she owned this building. She is selling to me. I bought. Money transferred. Documents given. I did not do registration. Now, owner is A na B na? Let us say she is A, I am B. Now tell me, owner is A na B na? In the eyes of government, legal owner is still whom? Answer. Now I will tell, sir, check, sir. I have given 1 crore check, sir. For what you gave, how would I know? Maybe there is a business deal between both of you. Maybe you took loan from her before. How can I tell that? This check number, you have given the payment. Loan. So what a timing. Where a level. What is the guarantee that I have given a check for the purchase of this property? What is the guarantee? I can't just to show the check number. Are you understanding the point or not? Check number means I can create checks like that, anything. Just it's a negotiable instrument. I can take a check and I can write and I can show that I have given. That's not the point here. In the records of the government, in the eyes of the government, who is the owner still? A is the owner. Why? What is not yet completed? Their problem with charges also. If you create charge but not registered, in the records of the government, that asset is free from charge. That asset is, until that is secured or unsecured? Answer. Now listen carefully. All of your what creditors? Secured or unsecured? Secured. Asset. E building is the asset. You gave me. I am company. You are all? Reply. You are all? This building was kept as a charge, security for loan given to me. I am company. I took loan from you. Listening? Now tell me, I didn't register the charge. You also forgot about it. 3 months after my company went into liquidation. Listening? At that time you went to the court and tell that sell my asset and get my money. Court said that give me the registration of charge document showing that this is secured against this loan. They said that sorry sir, we didn't register, we created. Company will tell that creation any fool can do. It requires only one stamp paper and one agreement. Where is registration? They said that sorry sir, we didn't register. Company has to register. Na? Company did not register. So that's a mistake of company. Company will do like that only. Why you are sleeping when that is happening? Now who is at the extreme risk? Company or charge holder? That's why if the company is not registering the charge, loudly, if the company is not, within how many days? 30 days of creation of charge, then charge holder by themselves can register the charge with the ROC unless company gives a reply. The reasons for delay. Listening or not everyone? Because who is at the extreme risk? That's why this section came. Simply this section says that who has a right to register the charge? In case of failure made by whom? In making the registration of creation or modification of charge. If you default, who has a right to do that? Charge holder can themselves do that work. Are you understanding the point or not? But not directly. See here the procedure. Shall we continue? Who are you? Company or charge holder? I registered or not registered? You are in a risk or not in risk? What you have to do now? Directly go and apply to the ROC. ROC will not register. ROC will send the notice to the company. Company, these people are saying that you took some loan, created a charge, but not registered. They are worried. They themselves applied. What is the reason? Company has to reply within 14 days. Company has to reply within 14 days. Saying some reason why there is a delay. Or tell that you will apply. If you don't give any reply within 14 days. If you means whom? Company. Don't give any reply. Within how many days? Then charge will be registered on the basis of the documents filed by the charge holder. That's the section number 78. Understood the concept or not? Read the concept first. Completed? Shall we go to the last one? See here. What section also we completed? Section number 78. Please see here the last section. Company to report the satisfaction of charge. Sir, what do you mean by satisfaction of a charge? What is mean by satisfaction of a charge? Name lone clear. Satisfaction of charge means payment of debt in full is called as a satisfaction of charge. Okay, simply to tell, release the asset from charge. Loudly. Release the asset from charge. It's called as what? Satisfaction of a charge. See there. First one. Where? Read. Where registered charge is paid or satisfied in full, the company shall give intimation to the registrar. Within how many days? 30 days. Next. Next. Where the registered charge is paid or satisfied but the company does not give the intimation to the ROC within 30 days, the company or charge holder may apply for conduct. So simply in one line, if you have to tell everything, tell me, satisfaction of charge happened. Again, who should inform? Should inform whom? About what? Huh? Charge. Within how many days? Within how many days? 30 days. Okay. Can we apply for extension if there is a delay? Yes. Extension will be made for a period of 270 days. Complete the total transaction within a period of 300 days. What we have to pay? Additional fee. What you have to pay? Additional fee. Listen carefully to the point. Okay? Listen. Who am I? In our exam, please participate. Who am I? I filed with whom? Within how many days? Or with extension within? 270 days extra. So total period is? I applied to whom? Saying that charge is created or modified or satisfied. Loan taken or loan paid. Now what ROC will do? He will register, give a certificate of creation of charge, satisfaction of charge. He will not do that, Adi. That's what I wanted to tell. If I am a false person, then you will be at risk. Companies Act never left anyone like that. Do you know what Companies Act said? See here. Who am I? Who am I? I applied for what? Applied to whom? ROC immediately send a notice to the charge holder. They will tell charge holder. One person is saying that, the company is saying that it has paid entire loan. That's why they are asking for satisfaction of charge. Really, did they pay you? They will send notices to all the charge holder. Sir, thousands of debenture holders will be there. Sir, how they can send? Andike debenture trustee is there. To debenture trustee, they will send a notice saying that trustee, this fellow is saying that they paid. Did they really pay? Debenture trustee or the real person has to reply within a period of 14 days. If they say, yes, they paid, register the satisfaction. Listening? If they don't give any reply, silence will be taken as a acceptance. Register the satisfaction. Listening? If they object to that particular notice, who objected? Then that ROC will inform the company saying that one of the charge holder is objecting that you made the payment. This is what this section wanted to tell. Read this. I'm sorry. First read this. Okay? Read this B point, C point and D. Okay? Hello, everyone understood the concept or not? Next. See here. That's all. That's the main concepts that we have to cover in this particular area. Sir, everyone understood all the concepts that we dealt with regard to the charges or not, everyone? These are all the important sections which we need to keep in mind while reading the chapter, registration of charges. So first tell me all the points, whatever we discussed, the substantial concept of the charges chapter. Everyone understood clearly? Yes, tomorrow's session, first 5 minutes, I will revise the charges concept one more time. After that, we will first consider in 40 minutes the concept called as a deposits. One small chapter is there. Today, if there is any deviation, the deviation is a 40-45 minutes. But we covered all the concepts in detail regarding dividends, regarding the debentures, regarding the charges. So tomorrow, first 45 minutes I will complete the chapter called as deposits. Once completed, we are going into two main chapters called as incorporation and accounts of company. What are the two? Incorporation and accounts of company. 1.5 hours for incorporation and 1 hour for the accounts of company. Sir, you choose one chapter, I will discuss accounts of company, prospectus. Did you understand? I'm leaving for your choice. Which chapter you want me to deal, I will deal with it. Accounts of company, prospectus. I will go with the ordinary resolution. Both don't raise hand. One only is possible for tomorrow. Okay? So tell me, accounts of company, how many? Prospectus. Now I understood. YouTube la what is there? They are not asking. What is not there? They are asking. Too much. Sir, okay, no problem for me. First we will cover what? Accounts of company and incorporation first. Am I clear? Sir, hey, 1 minute early. Bro, enna bro? You are packing bag. I am still here. Listen. Accounts of company will come for 6 marks to 8 marks in exam. Incorporation will come for 6 marks. So definitely any chapter you touch in Companies Act including choice will come for that 70 marks. Listening, 70 marks main concepts, all the concepts I will cover. You need not bother about that problem. Okay. Mainly what concepts which are not already there in the YouTube, first I will cover. I understood your strategy. Okay. First we will cover accounts of company and deposits, a small area. Next accounts of company. Next we will go for the incorporation of companies. Another 15 marks area we will cover in the tomorrow's session as well. Clear or not everyone in the class? Thank you very much. Meet you in the tomorrow's class again. Thank you.